Good afternoon to you and welcome to the National Assembly live proceedings on this second day of December, the year being 2021. We are so glad you're watching. A lot has been lined up before the floor of the House, before the House proceeds on recess later this evening. Two bills will be tabled before the floor of the House for the first time. The first bill that will be read for the first time is the Circle Society Amendment Bill, National Assembly Bill number 55 of 2021 by the Leader of Majority, and the bill by the Leader of Majority on SACCOs, 6 to amend the Circle Societies Act number 14 of 2008. This is by providing for the usage of ICT in collecting and receiving the statutory reports. This is aimed at reducing the regulatory reporting burden on SACCOs and ensuring of a faster, efficient and accurate reporting, as well as monitoring and analysis of SACCOs' financial status at any time, being the cornerstone of risk-based supervision. The bill also seeks to realign the definition and roles of ministers to Cabinet Secretary, and also the responsibilities and office of the control of budget as reflected in the Act to be in line with the Constitution. Another bill set before the floor of the House this afternoon happens to be the Political Parties Amendment Bill, Bill number 56 of 2021 by the Leader of Majority. This is pursuant to Article 110, subsection 3 of the 2010 Constitution. The principal object of the bill is to amend the Political Parties Act of 2011. This is for the connected purposes, and the bill has a total of 27 clauses. And just to mention, Clause 4 of the bill seeks to amend Section 5 of the Act to provide for an application. This is for the provisional registration of a political party and shall not be done after the reservation of a name, symbol, and slogan, as well as the lapsing of the reservation of the application is not done within 90 days of the reservation of the name, symbol, or slogan. Moving on, there will be a procedural motion on the reduction of the publication period for specified bills, that notwithstanding the provisions of Standing Orders number 100-20, the House resolves to reduce the publication period of the Circle Society Amendment Bill and the Political Parties Amendment Bill from 14 days to 6 days. The other motion set for deliberations before the House is the official documenting of the history of the National Assembly. It is a bill by the Leader of Majority, that aware that the House of any institution is key to evaluating its development. This House further noting that comparable jurisdictions have elaborate records of their history, which are periodically updated to capture new developments. The House seeks to ensure the preservation of the history of the institution for further and future generations. The Speaker of the National Assembly, Honorable Justin Muturi, is in the chamber, and I'll now be handing you over for the live broadcast. Enjoy your viewing. My name is Gladys Mungai.
Na tuombe. Ewe Mwenyezi Mungu, ambaye kwa hekima na wema wako umeteua nyadhifa za viongozi na mabunge kwa ustawi wa jamii na utawala wa haki wa wanadamu, twakusihi tutazame kwa neema nyingi sisi watumishi wako ambao umeridhika kutuita ili tutekeleze shughuli muhimu za jamhuri yetu. Twakuomba ututeremshie baraka zako sisi tuliokutanika hapa, na utujalie tuyatende na kuyafikiria mambo yote yatakayofikishwa mbele yetu kwa njia ya haki na uaminifu, ili utukufu na sifa zako ziendelezwe, na ili kustawisha amani, ufanisi na heri ya nchi yetu na wale ambao haja zao umezikabidhi mikononi mwetu. Amen. Ring the quorum bell.
The Speaker of the National Assembly, Honorable Justin Muturi, has ordered that the quorum bell be rung. This is to allow for the whip as well as the sergeant at arms to allow more members of the August House access the chamber to necessitate the House to get its requisite quorum to proceed with its business this afternoon. In the official documentation of the history as well as National Assembly motion, further cognizant that the legislature has been transforming, this is in the last century, both in mandate and composition, starting with the first unicameral legislature to a bicameral one. This is at independence to a unicameral legislature before again reverting to bicameral parliament after the promulgation of the 2010 Constitution, and recognizing that many works of arts, this includes statutes, frescoes, murals, and pictures connected with the history of Parliament of Kenya, including the contributions of great men and women, families, architects, as well as politicians throughout the 114 years of the history of this particular institution and its transformation and growth. This is throughout the period of the institution and its transformation, as well as growth period noted, that an appropriate stage, the House appoints a committee comprising of not more than 9 members to oversee the preservation of these histories. This is for prosperity with special focus on the National Assembly, and that the copyright of the history of Parliament of Kenya projects to be reserved for the benefit of Parliament and the people of Kenya. And finally, that the clerk of the National Assembly puts in place and executes appropriate mechanism to actualize the resolution. The House has attained its quorum, and I'll now be handing over for you to follow up on the live proceedings. Good afternoon.
Order number 1, administration of oath. Order number 2, communication from the chair.
Honour members, take your seats also. Honour members, you will recall that during the afternoon sitting of the House on Thursday, 25th of November, 2021, the first chairperson of the committees didn't report to the House that my office was in receipt of a letter from the chairperson, Departmental Committee on Justice and Legal Affairs, seeking leave of the Speaker to withdraw the Advocates' Amendment Bill, National Assembly Bill number 43 of 2021, pursuant to Standing Order 140. In her guidance to the House, the first chairperson of committees didn't remind the House that the same bill had been published and introduced in the House under the sponsorship of the Departmental Committee on Justice and Legal Affairs, following its admission of the prayer sought by Mr. George Jenga Mwaneki and 12 others through public petition number 20 of 2021, which sought, in brackets, amendment of the Advocates Act, Cap 16, to allow admission of law practitioners from the republics of Rwanda and Burundi to the role of advocates in Kenya, close the quotes. Honour members, as you may further recall, that the first chairperson did clarify to the House that the application of Standing Order 140 is subject to the discretion of the Speaker, who must weigh the merits or otherwise of a request for leave to withdraw a bill. Accordingly, she deferred commencement of second reading of the bill in question to await the Speaker's determination of the request by the chairperson of the Departmental Committee on Justice and Legal Affairs for leave to withdraw the bill. Honourable members, I have reviewed the letter of the chairperson of the Departmental Committee on Justice and Legal Affairs and established that the chairperson cited 2 grounds for withdrawal of the bill. These reasons are, 1, that the matter being addressed falls within the doctrine of reciprocity among the community of nations, in this case being the member states of the East African Community, as captured in paragraph 9 on page 19 of the committee's report, which emphasizes that, in quotes, without mutual and equivalent harmonization, there should be no reciprocity, close the quotes, with regard to the admission of persons from the other East African states to the role of advocates, and 2, that the Office of the Attorney General and the Department of Justice of the Republic of Kenya had, during its consideration of the petition, submitted that it was in the process of formulating 2 bills, namely the Kenya School of Law Amendment Bill and the Council for Legal Education Amendment Bill, which would, among others, address the concerns of the petitioners. Honourable members, before I guide the House with regard to the request at hand, I wish to report to the House that the petitioners have, by way of a letter dated 26th of November, 2021, appealed to my office objecting to the withdrawal of the bill by the chairperson of the Departmental Committee on Justice and Legal Affairs. For the benefit of the House, I have summarized the grounds on which the petitioners' appeal is premised as follows. 1, that the committee's decision to legislate in the manner contained in the bill signifies its acquiescence with their prayers and was arrived at after taking into account the views of the Attorney General, the judiciary, and the Council for Legal Education, among other key stakeholders in the legal profession. 2, that sections 12 and 13 of the Advocates Act had already been passed in the Statute Law Miscellaneous Amendment Act of 2012, but were, however, declared unconstitutional by the Court of Appeal in Civil Appeal number 96 of 2014, being a case with the parties being the Law Society of Kenya versus the Attorney General and 2 others, only for want of public participation. 3, that the matter at hand is exclusively within the authority of Parliament, being the arm of government with the exclusive power to legislate, and that even in the instances when the courts applied themselves to the matter and granted certain orders in the affirmative, they still refer the petitioners to engage Parliament to legislate appropriately. Consequently, honourable members, withdrawal of the bill from the House is prejudicial, as it would leave the petitioners with no other recourse. Honourable members, in considering the request by the chairperson of the Committee on Justice and Legal Affairs as against the plea by the petitioners, the right to petition Parliament on any matters within its authority anchored in Article 119 of the Constitution is instructive. As stated before, the Advocates Amendment Bill, National Assembly Bill number 43 of 2021, was introduced in this House following its exhaustive consideration of a public petition. The bill was not voluntarily introduced by the committee on its own motion. Part of the argument by the petitioners was the fact that they had exhausted all options available to them and were left with this House as the competent body of last resort. It was therefore their legitimate expectation that the House would address their prayers conclusively. Honourable members, with respect to public participation, I do note that the committee had invited the public to submit their views on the bill between 11th and 23rd of November 2021. It will be recalled that the courts have also affirmed mandatory nature of public participation and emphasized the qualitativeness of public participation and distinguishes it from a mere consultation or a public relations exercise without a meaningful purpose. As I've always stressed, public participation ought to be approached as a qualitative and not cosmetic exercise. Indeed, the High Court recently observed in Constitutional Petition number E001 of 2021, reported in the Kenya Law Reports, with respect to public participation that, and I quote, all parties interested in legislation should feel that they have been given a real opportunity to have their say. that they are taken seriously as citizens and their views matter and will receive due consideration at the moments when they could possibly influence decisions in a meaningful decision. The objective is both symbolical and practical. The persons concerned must be manifestly shown the respect due to their concerned citizens, and the legislators must have the benefit of all inputs that will enable them to produce the best possible laws. Close the quotes. Honourable members, the question that arises then is, who between the petitioners and the committee is competent to withdraw a matter for which the intervention of this House has been sought? You will agree with me that justice would demand that only a party seeking redress should be allowed to withdraw its request. In my view, allowing the committee to abruptly discontinue the process of actualizing the petitioner's prayers without any reference to them negates the spirit in Article 119 of the Constitution. Notably, honourable members, I do observe that the recommendation of the committee on page 20 of his report that Parliament amends the Advocates Act, Cap 16 of the laws of Kenya, and its conscious decision to introduce the bill in the House was made with the committee having taken into account the submissions received from stakeholders, including the Honourable the Attorney General. Honourable members, in seeking to withdraw the same bill, the committee alluded to the fact that the Attorney General and the Department of Justice of the Republic of Kenya were formulating two bills, namely the Kenya School of Law Amendment Bill and the Council for Legal Education Amendment Bill, which would encompass the proposals contained in the Advocates Amendment Bill 2021. Perhaps the committee would have noted the express provisions in Article 94, Clause 5 of the Constitution, which states as follows, and I quote, "No person, or body, other than Parliament, has the power to make provisions having the force of law in Kenya, except under authority conferred by this Constitution or by legislation." Close the quotes. Honourable members, the petitioners approach this House well aware that no other body has power to anchor into law the prayers sought in their petition. Clearly, the two draft bills referred to by the letter of the chair of the Committee of Justice and Legal Affairs have not been introduced in this House, either under Standing Order 114 by a member or under Standing Order 114A by the leader of the majority party. Consequently, the draft bills referred to are unknown to this House and cannot be used as a reason to deny the petitioners the audience of the House as sought. Indeed, the claim is outside the prayers of the petitioners. Honourable members, majority of the work of a House is discharged through its various committees, which consider matters committed to them and recommend various actions for resolution by the House. At this point, the committee is and remains an agent of the House and is not an aid by itself in matters legislation. Honourable members, the committee, in the spirit of Article 119 of the Constitution, is required to respond conclusively to a legislative request from aggrieved members of the public. It had, by publishing the bill, adhered to the first part of its legislative mandate in accordance with the recommendations of its own reports. The second part of its mandate would entail spearheading the processing of the bill in the House through its various stages, as if it originated the idea behind the bill. However, it now seems that the committee is either unable or unwilling to undertake this second part of its mandate. Honourable members, the chairperson of the Departmental Committee on Justice and Legal Affairs has, through his letter, given formal indication that he is not desirous of prosecuting the bill further. To my mind, exercising the discretion under Standing Order 140 to decline his request would place the petitioners in a rather precarious position. When the petitioners, for example, trust that the bill will be moved in a manner that properly communicates their true intention. Honourable members, in view of the foregoing, I would urge the chairperson of the Departmental Committee to reconsider his request to withdraw the bill. The chairperson, after taking into account the views of his committee, should communicate the committee's final decision on the matter to my office before commencement of the next session. Alternatively, the Speaker will allow any other member willing to sponsor the bill to have it republished in his or her name. Honourable members, with respect to public participation so far undertaken, I do note that the committee had invited the public to submit their views on the bill between 11th and 23rd of November 2021. Any memoranda received with regard to the bill shall remain valid for consideration in the preparation of a report to this House, either on the original bill sponsored by the chairperson, if he elects to proceed with the bill, or a bill sponsored by a member pursuant to this direction. Honourable members, in summary, I direct as follows. 1, that the chairperson or the committee, after taking into account the views of his committee, should communicate the committee's final decision on the matter to my office on or before 24th of January 2022. 2, that in order to adhere to the true intention of Article 119 of the Constitution, as read together with the mandate of this House to deliberate on and resolve any issue of concern to the people, in default of the chairperson sponsoring the bill, any other member may express interest to sponsor the bill on the petitioner's behalf. Where a member agrees to sponsor the bill, it shall be republished at the earliest opportunity and introduced in the House for consideration. And 3, that any memoranda received with regard to the Advocates' Amendment Bill, National Assembly Bill number 43 of 2021, shall remain valid for consideration in the preparation of a report to this House, either on the original bill sponsored by the chairperson of Justice and Legal Affairs, or a bill sponsored by any other member pursuant to this direction. The House is accordingly guided. I thank you. Members who are coming in, please make your way in. There are several other communications. I just resumed my seat to allow members to make their way in. Well, honourable members, I indicated that and some other communication to make further. And I only resumed my seat to allow members to make their way in, but I've seen others who are making their way out. Those who have finished with the session. Honourable members, this second communication relates to the gaming bill, National Assembly Bill number 35 of 2019. Yesterday, Wednesday, 1st December 2021, I received a request from the chairperson of the Departmental Committee on Sports, Culture and Tourism to consider scheduling of the gaming bill, National Assembly Bill number 35 of 2019, in today's order paper for consideration by the House in the Committee of the Whole House. My office did confer with the leader of the majority party with respect to having the bill included in the supplementary order paper for this afternoon sitting. Ordinarily, the function of scheduling business is one of the mandates of the House Business Committee as envisaged in Standing Order 171, subsection 4, paragraph E. However, in view of the imminent long recess, My intervention as your speaker in concurrence with the leader of the majority party would have sufficed in order to facilitate the business of the House today. Honourable members, you may recall that the Gaming Bill 2019 was published on the 27th of May 2019 and read the first time on 11th of June 2019, and thereafter committed to the Departmental Committee on Sports, Culture, and Tourism for consideration pursuant to Standing Order 127. Subsequently, the committee tabled its report in the House on the 14th of November 2020. In the same report, the committee proposed a raft of amendments to the bill. Honourable members, sometimes last year, the Ministry of Interior and Coordination of National Government further submitted to the Office of the Clerk further proposed amendments to the bill that included the functions of the proposed National Gaming Authority, the functions and powers of gaming inspectors, gaming advertisement, application for licenses and issuance, and offenses provisions. In addition, the ministry proposed amendments for the protection of children and young persons. Consequently, the committee considered the proposed amendments and tabled an addendum to its report in the House on 8th of October 2020. Honourable members, my office did approve a request for the committee to hold a sitting on Wednesday, yesterday, 1st of December 2021, at 10 a.m. to harmonize further proposed amendments to the gaming bill, following submission of additional amendments, both from the Ministry of Interior and Coordination of National Government and the Ministry of Sports, Culture, and Heritage. Consequent to this process, the committee has come up with additional proposed committee stage amendments. Indeed, honourable members, at 10:15 today, Thursday, 2nd of December 2021, the Office of the Clerk received a raft of amendments from the chairperson of the committee. Honourable members, Standing Order number 133, subsection 2 reads in part as follows, and I quote, "No amendment shall be moved to any part of a bill by any member other than the member in charge of the bill, unless written notification shall have been given to the clerk 24 hours before commencement of the sitting at which that part of the bill is to be considered." Close the quote. Honourable members, a close scrutiny of the proposed amendments by the committee disclosed that the committee is proposing to amend over 110 clauses of the 162 clauses of the bill. The committee is also proposing amendments to 5 of the 6 schedules to the bill. The committee is also proposing to include a further 13 new clauses to the bill. Honourable members, you will agree with me that the final bill will therefore be fundamentally different from the published one. Honourable members, given that the bill in question is a repeal and enactment bill, and that practice of the House requires that where the sponsor of a bill is proposing amendments whose effect is to replace almost the entire text of a bill, then the bill ought to be republished afresh so as to accord an opportunity to the members and the public to familiarize themselves with the content of the new bill. In this regard, honourable members, it is for this reason that this afternoon I have declined to the request to include the bill in the supplementary order paper for this sitting. Having said that, I direct that the bill be republished in the name of the committee, incorporating all their proposed and other additional amendments for expeditious consideration at the next opportunity, pursuant to provisions of standing orders of the House. And the House is thus accordingly guided. I thank you. Now, Member for Yatta, you appear like a supplier of water, a distributor of the same. Did the member for Kiharu? Member for Kiharu, today you have come to the house quite early. Is it because the house is scheduled to go to recess? Honour members, as you are aware, at the rise of this sitting today, the House is scheduled to proceed on its long recess from tomorrow, Friday, 3rd of December, 2021, to 24th of January, 2022, in accordance with its calendar for the 5th session. You may further recall that when approving the calendar on the 10th of February, 2021, the House did resolve that the committee sittings will start suspended from the 13th of December, 2021, to 24th of January 2022. In this regard, all committees will be required to suspend their sittings on the stated dates in order to allow members to attend to their constituency duties and for staff to take leave. Honourable members, it's important to note the following priority business currently pending before the House and which ought to be disposed of at the earliest opportunity. 1. Nomination of a person for appointment to the Equalization Fund Advisory Board, which is before the Departmental Committee on Finance and National Planning. 2. The vetting of a nominee for appointment as the chairperson of the Public Service Commission, which is before the Departmental Committee on Administration and National Security. 3. The vetting of nominees for appointment to the office of a member of the National Gender and Equality Commission, which is before the Departmental Committee on Labor and Social Welfare. And 4th, consideration of the 2022 budget policy statement for the financial year 2022-2023, which is now before the Budget and Appropriations Committee. Honourable members, it is instructive to note that the foregoing business has statutory timelines that will lapse during the recess period. In addition, you may recall that in his State of the Nation address to Parliament on Tuesday, 30th November 2021, His Excellency the President did appeal to Parliament to expedite and conclude certain pieces of legislation and statutory instruments. These include the Government Contracts Bill, the Kenya National Blood Transfusion Bill, the Irrigation Amendment Bill, the Kenya National Library Service Bill, the Huduma Bill, the Political Parties Amendment Bill, the Process of Crime and Anti-Money Laundering Amendment Bill, and 8, the Political Parties Membership Regulations 2021. The first 4 bills were passed by this House and are now pending in the Senate. Indeed, honourable members, the President did urge Parliament to consider adjusting its calendar to ensure that all the critical legislation and legal instruments, including those relating to elections, are concluded in good time. Fortunately, this House had in its wisdom adjusted its calendar so as to commence the 6th session on the 25th of January 2022 instead of the 2nd week of February as required under Standing Order 27 regarding regular sessions of the House. This adjustment affords the House 3 extra weeks, which comfortably accommodates the President's request. Honourable members, so as to ensure that the House concludes the priority business mentioned above, I will consult with the leaders of the majority party and minority party with respect to the dates for holding special sittings of the House should the need arise, and the dates will be communicated to all members. With regard to the processing of the budget policy statement for the financial year 2022 to 2023, and the honors is on the Budget and Appropriations Committee to guide the House accordingly. Honourable members, as you may be aware, by practice of this House, certain business, particularly questions and statements, ordinarily lapse at the end of every session. However, I am cognizant of the unprecedented circumstances under which the House operated this year due to COVID-19 disease meant that committees held fewer sittings. Indeed, I am informed that more than half of the questions asked and statements requested by various members are still pending before the relevant committees and have the fate of lapsing at the end of the session. In this regard, I have been petitioned by various members to authorize all pending questions and statements to be carried forward to the next session. Honourable members, in considering the foregoing requests, I am aware that unlike questions for which committees simply obtain a response from the relevant ministries or government agencies, some statements ordinarily require a committee to conduct an examination or inquiry into the issues for response. Indeed, I have established that a number of committees had actually commenced inquiries into issues raised in the respective requests for statement under their considerations. In view thereof, honourable members, and in order to guard committees from appearing to have commenced inquiries in vain, I will exceptionally permit statements pending before committees to be carried forward to the to questions. The existing practice applies. This implies that all pending questions will lapse at the end of the 5th session, which is later this evening. Finally, honourable members, it is my highest privilege and honor to thank the leadership of the House, members of this House, and staff for having braved the challenges posed by the COVID-19 pandemic to ensure that this House continued with its legislative business largely unimpeded. In conclusion, honourable members, I take this early opportunity to wish you all a safe and happy festive season, as well as a prosperous 2022. I thank you.
Order number 3, messages. Order number 4, petitions.
Honourable members, take your seats. Honourable members, starting under 225, subsection 2, paragraph B, requires Speaker to report to the House any petition other than those presented by a member. Further, Article 119 of the Constitution provides for the right of any person to petition Parliament to consider any matter within its authority, including petitioning the House to enact, amend, and/or repeal any legislation. In this regard, therefore, now members, I wish to report the House that my office has received a petition signed by several residents of Haraka Settlement Scheme in Yatta and Masinga constituencies. The petitioners, who comprise approximately 1,400 families, claim that they have been residing on 746 parcels of land within the settlement scheme, comprising of the following: 1, Dalani Phase 1 Settlement Scheme, Dalani Phase 2 Settlement Scheme, Mamba Settlement Scheme, Zukini Phase 1 Settlement Scheme, Zukini Phase 2 Settlement Scheme, Phase 3 Settlement Scheme, Zukini Phase 4 Settlement Scheme, Goliba Phase 2B Settlement Scheme, Goliba Phase 4D Settlement Scheme, Tithini Phase 1 Settlement Scheme in Masinga Sub-County, and Tithini Phase 2 Settlement Scheme in Masinga Sub-County. The petitioners aver that their families have lived on the parcels of land within the above-mentioned settlement schemes for over 45 years, but have never been issued with the title deeds as proof of security of tenure and as a guarantee for them to realize full economic potential of their land. They state that in 1988, the Ministry of Lands, in conjunction with the then Eastern Province Administration, formed a Ministerial Plots Committee, MPC, to look into the matter and recommend appropriate solution to the long-standing squatter issue. Honourable members, the petitioners claim that the Ministerial Plots Committee concluded its probe in 1994 in the settlement schemes within the land location, covering a total of 2,565 parcels of land, among them being the 746 plots that were identified as having squatter issues. In order to resolve the matter, the Ministerial Committee recommended subdivision and allocation of the plots to the verified allottees and squatters in some cases, and alternative plots for some squatters in other cases. In 2011-2012, ground verification of the 746 plots within Dalani phases 1 and 2, Mamba and Zuki phases 1, 2, 3, and 4 was undertaken. Allotment letters were issued to some allottees, although some remained as squatters, and their recent forceful eviction has caused hostilities between them and the allottees. Honourable members, the petitioners are therefore praying that the National Assembly, 1, investigates the circumstances behind the inordinate delay in facilitating the survey, subdivision, and allocation within Haraka Settlement Scheme in Yatta and Masinga constituencies to deserving squatters since 1988, when the then Ministerial Plot Committee recommended allotment of plots to verified squatters. 2, recommends immediate cessation of ongoing evictions from Haraka Settlement Scheme and allocation of part or whole of Haraka Settlement Scheme until genuine squatters are authenticated. 3, inquires into circumstances under which parts of the Haraka Settlement Scheme were allotted to unknown persons other than squatters who have lived on the land for 45 years and recommend revocation of any such irregular allotment. And 4, makes any other recommendations deemed necessary in addressing the circumstances of the petitioners. Having determined that the matters raised by the petitioners are well within the authority of this House, I order and direct that pursuant to Provisional Standing Order 227-1, this petition be committed to the Departmental Committee on Lands. The committee is required to consider the petition and report its findings to the House and to the petitioners in accordance with Standing Order 227-2. I thank you. The member for Ainamoi, is it?
Thank you, Mr. Speaker. This is public petition number 76 of 2021 regarding the use of heavy mechanization of tea plucking and harvesting and declaration of employees as redundant by multinational tea companies in Kericho and Bomet counties. I, the undersigned, on behalf of concerned tea plantation workers and residents of Ainamoi constituency and the entire Kericho and Bomet counties, draw the attention of the House to the following. Number 1, that tea is the top foreign exchange earner to Kenya and supports livelihoods of close to 5 million Kenyans directly and indirectly. Number 2, that the Kenya tea sector plays a crucial role in our national gross domestic product and is estimated to employ over 200,000 workers directly. Number 3, that the agricultural wages earned by laborers in the tea industry is a major source of livelihood for many households in Kericho and Bomet counties and tea growing area in the country. The earnings constitute a major source of income for these households, enabling them to educate their children, access healthcare, thus improving the general quality of their life. Number 4, that the introduction and continued use of heavy mechanization by multinational companies such as James Finlay, Unilever Tea Kenya, George Williamson's and Soti Company in the midst of ravaging COVID-19 pandemic caused layoff over 50,000 workers, especially manual tea pluckers. Number 5, that the tea plantation workers are paid absurdly low wages despite enduring appalling working conditions, forcing them to turn to moneylenders and Shylocks, which has condemned them to an endless cycle of indebtedness and made vulnerable to the detriment of their poor quality of life. Number 6, that the continued redundancy of employees resulting from the deployment of heavy mechanization of tea harvesting has caused a sudden slump in the local economy by an estimated 20%. Number 7, that it is believed that apart from possible health hazard, the heavy tea plucking machines compromise the quality of tea in the international market, which is denying the country the much required foreign exchange. Number 8, that if the issues raised by this petition are not urgently addressed, Many livelihoods that depend on the income of manual tea pluckers stand the risk of deterioration due to massive redundancy of their breadwinners, collapse of regional economies in the tea growing zones, and deterioration of Kenya's dominance in international tea market. Number 9, that none of these issues raised in this petition is pending in court of law, constitutional, or any other legal body. Therefore, you ample petitioners raise that National Assembly, through the Departmental Committee on Labor and Social Welfare, 1, intervenes in the matter with a view of recommending first introduction of heavy harvesting machines in all tea growing areas, particularly Bomet and Kericho counties, so as to safeguard against inhuman and massive job losses due to redundancy. Number 2, urgently review the existing legislation and policies on mechanization of heavy harvesting tea machines in order to provide a framework to regulate heavy mechanization of tea plucking so as to safeguard tea plantation workers' livelihoods. Number 3, recommends the mandatory setting aside of minimum percentage of tea plantations that multinational tea farms must harvest mechanically in order to forestall further job losses. Number 4, inquire possibilities of hazardous effects that mechanized tea plucking has on the quality of Kenya's plucked tea and safety of tea plantation workers who run the machines, with a view of ascertaining whether they are in line with ILO Convention 184 on the safety and health in agriculture. Number 5, recommends to the Ministry of Health and the National Bureau of Standards formulate, carry out periodically, review a coherent national policy on safety and health on the tea plantation. Number 6, inquires into serious breaches of law and human rights that multinational tea companies have been committing against tea plantations workers and recommend appropriate remedies to secure the right manual tea pluckers to fair labor practice as contemplated in Article 14 of the Constitution and in line with international and national labor laws. Finally, number 7, make other recommendation it deems appropriate in addressing the plight of petitioners. And your petitioner will ever pray. Thank you.
Honourable members, having observed what is happening, and that a while ago were quite many, but being cognizant of the fact that there are some who will allow comments now on the petitions, by the time we are through with the comments, there will be no quorum. I therefore rearrange the comments. Preserve your comments on the petition, on the two petitions. You reserve your comments. I first of all deal with rearrange business and proceed, do the business appearing as order number 10, 11, 12, and 13 on the supplementary order paper. It is procedural. It is procedural. We want to put the questions. So can we go there? 10.
Order number 10, motion. Report of the Committee of the Whole House on its consideration of the Asian Widows and Orphans Pensions into brackets repeal bill, National Assembly Bill number 29 of 2021. Question to be put and third reading.
Honourable members, order number 10 is for the question to be put on that reading. So I put the question, which is that this House adopts the report of the Committee of the Whole House on its consideration of the Asian Widows and Orphans Pensions in brackets, repeal bill, National Assembly Bill number 29 of 2021. Will as many as of that opinion say aye? Aye. As many of counter opinion say nay? No. The ayes have it. Move on. Move on for that reading.
Honorable Speaker, I beg to move that the Asian Widows and Orphans Pensions Repeal Bill, National Assembly Bill number 29 of 2021, be now read at that time. I also wish to request the Honorable Gladys Wanga to second.
Honorable Wanga. Very well. Honorable members, I propose the question, which is that the Asian Widows and Orphans Pensions brackets Repeal Bill, National Assembly Bill number 29 of 2021, be now read a third time. I put the question, having confirmed that we could read, which is that the Asian Widows and Orphans Pensions Repeal Bill, National Assembly Bill number 29 of 2021, be read a third time. Will as many as of that opinion say aye? Aye. Will as many as of the contrary opinion say nay? The ayes have it.
A bill for an act of parliament to repeal the Asian Widows and Orphans Pensions Act and for connected purposes.
Next.
Order number 11, motion, report of the Committee of the Whole House on its consideration of the Provident Fund Repeal Bill, National Assembly Bill number 30 of 2021, question to be put in third reading.
I put the question on our members, which is that this House do agree with the report of the Committee of the Whole House on its consideration of the Provident Fund Repeal Bill, National Assembly Bill number 30 of 2021. Will as many as of that opinion say aye? Aye. As many of counter opinion say nay? The ayes have it. Move on.
Honorable Speaker, I note there is a stranger occupying the leader of minority seat. But
He's a member for so he's not a stranger.
oh, we are used to him here. Okay, thank you. Honorable Speaker, I beg to move that the Provident Fund Repeal Bill, National Assembly Bill number 30 of 2021, be now read a third time. I also request the Honorable Sankok to second.
Honorable Sankok.
Thank you very much, Honorable Speaker, and I beg to second.
Now, honourable members, I propose a question. The members for, which one? It never happens that way. I propose a question, which is that the Provident Fund Repeal Bill, National Assembly Bill number 30 of 2021, be now read a third time. As decided by the House, I therefore put the question, which is that the Provident Fund Repeal Bill, National Assembly Bill number 30 of 2021, be now read a third time. Will as many as of that opinion say aye? Aye. As many as counter opinion say nay? The ayes have it.
A bill for an act of parliament to repeal the Provident Fund Act and for connected purposes.
Next.
Order number 12, motion, report of the Committee of the Whole House on its consideration of the Kenya Roads Amendment Bill, National Assembly Bill number 13 of 2021, question to be put in third reading.
I put the question. Please be in the House. Be in the House. I propose the question, which is that this House do agree with the report of the Committee of the Whole House on its consideration of the Kenya Roads Amendment Bill, National Assembly Bill number 13 of 2021. Will as many as that opinion say aye? Aye. As many as contrary opinion say nay? The ayes have it. Move on. Honorable Kosing.
Thank you, Speaker. Madam Speaker, I beg to move that the Kenya Roads Amendment Bill, National Assembly Bill number 13 of 2021, be now read a third time. And I also request Honorable Dawood to second.
Member for North Imenti.
I beg to support Mr. Speaker.
Support.
I second. Sorry, Mr. Speaker. Honorable Melly is disturbing me here. I beg to second, Mr. Speaker.
What is this migration in the house? Please, you will go, very soon you are going to recess, so you will have all the time in the bushes to consult. You know, these are the hallowed floor of the house. Now you look at that one now. Surely. That is the honorable order, isn't it? Yeah. Please just be in the house for a while. Just for a short while. I'm sure very soon you'll be out. Honourable members, I propose the question, which is that the Kenya Roads Amendment Bill, National Assembly Bill number 13 of 2021, be now read a third time. As designed by the House, I therefore put the question, which is that the Kenya Roads Amendment Bill, National Assembly Bill number 13 of 2021, be now read a third time. Will as many as of that opinion say aye? Aye. As many as of contrary opinion say nay? The ayes have it.
A bill for an act of parliament to amend the Kenya Roads Act and for connected purposes. Order number 13, motion, report of the Committee of the Whole House on its consideration of the county government's additional allocation bill, Senate Bill number 35 of 2021, question to be put and third reading.
I put the question, which is that this House do agree with the report of the Committee of the Whole House on its consideration of the county government's additional allocation bill, Senate Bill number 35 of 2021, be read. Of that bill number 35 of 2021, will as many as of that opinion say aye? Aye. Will as many as of contrary opinion say nay? The ayes have it. Mover. Honorable Shinali.
Honorable Speaker, I beg to move that the County Grants Bill, Senate Bill number 35 of 2021, be now read a third time. I also request Honorable Dr. Songok to second.
Honorable Songok.
Thank you very much, Honorable Speaker. And Honorable Speaker, there is Honorable Sitany, is Caleb, is giving our party a bad name. Honorable Speaker, I beg to second. And thank you very much, Honorable Speaker. And I have just seen your ruling, and it was the best. And you are there to be the future president. Thank you very much, Honorable Speaker.
Honourable members, I propose the question, which is that the county government's grants bill, Senate Bill number 35 of 2021, be now read a third time. As decided by the House, I therefore put the question, having confirmed that you still put it, that the county government's grants bill, Senate Bill number 35 of 2021, be now read a third time. Will as many as of that opinion say aye? Aye. Will as many as of contrary opinion say nay? The ayes have it.
A bill for an act of parliament to provide for the additional allocations to county governments for the 2021-2022 financial year, the responsibilities of national government and county governments pursuant to such allocation and for connected purposes.
Very honourable members, again, so as to clear these handles, let's go to order number 8. I'm still aware that you still reserve your right to comment on the 2 petitions. Don't forget. But let's clear these number 8 and number 9.
Order number 8, procedural motion, exemption of bills and petitions from lapsing.
Leader Majority.
Thank you, Honorable Speaker. Mr. Speaker, I beg to move that, cognizant that this House will be proceeding for a long recess from December the 3rd, 2021 to 24th of January, 2022, in accordance with its calendar for regular sessions for 2021, and pursuant to the provisions of Standing Order number 256, exemption of business from standing orders. This House resolves, 1, to exempt all bills which, having been read a first time during the 4th session, that's the year 2020, are pending at various stages of consideration in the House from the provisions of Standing Order number 141, 2, lapse and reintroduction of bills. And 2, that with respect to all public petitions pending before committees, the counting of the 60 days consideration period prescribed under Standing Order number 227-2, Committee of Petitions, shall cease upon commencement of the recess and resume when the House next sits in the 6th session. Honourable members, Honourable Speaker has just given a communication to the House guiding on how we process business and basically the bills that we can reasonably save. You may recall last year, at a time like this, we did save all the bills that had been introduced in 2019 and before and were in various stages because of COVID. So now we obviously cannot go back and save things into the past, and the cut-off period, as guided by the Speaker, has been done in 2020. So with those remarks and with the clear guidance that has been given earlier in the day, I beg to move and ask the Honorable Emmanuel Wangu to second.
Thank you, Honorable Speaker. Honorable Speaker, I rise to second. Thank you.
Honourable members, I propose the question, which is that cognizant of that this House will be proceeding for a long recess from 3rd of December 2021 to 24th of January 2022 in accordance with its calendar, regular sessions for 2021, and pursuant to the provision of Standing Order 256, which deals with the exemption of business from the standing orders, this House resolves, Roman 1, to exempt all bills which, having been read a first time during the 4th session, the year 2020, are pending at various stages of consideration in the House from the provisions of Standing Order 141, subsection 2, dealing with the lapse and reintroduction of bills, and 2, that with respect to all public petitions pending before committees, the counting of the 60 days consideration period prescribed under Standing Order 227, subsection 2, shall cease upon commencement of the recess and resume when the House next sits in the 6th session. Very well. Honourable members, just for your information, this decision you're about to take, if you vote in the affirmative, it will save a total of 25 bills, yours being one of them. So, honourable members, I put the question as demanded by the House, by the members, that the motion as read be carried. Will as many as that opinion say aye? Aye. Will as many as the contrary opinion say nay? The ayes have it. Order number 9.
Order number 9, procedural motion, reduction of publication period for specified bills.
Leader majority.
Honorable Speaker, I beg to move that, notwithstanding the provisions of Standing Order number 120, this House resolves to reduce the publication period of the Circle Societies Amendment Bill, National Assembly Bill number 55 of 2021, and the Political Parties Amendment Bill, National Assembly Bill number 56 of 2021, from 14 days to 6 days. Honorable Speaker, just this morning, this House approved the procedure to be followed for bills introduced between this evening and the time we come back. And the House approved that a bill can be introduced, can be referred to the committee after 3 days from the date of publication, where the Speaker deems it priority. Now, so the House having decided on that, indeed, the 6 days is already beyond the 3 days. So these bills could well have gone to the committee based on the motion that we did. But because these bills were already here before we have gone, it's only prudent that we process them specifically in the House by reducing the publication period so that they can be read a first time, referred to the committee, and within the course of next week, committees can work on them, and then we can determine how fast we can expedite them. And these bills are critical. Circle societies is one of the bills that was declared unconstitutional. And we are only reintroducing it so we can conform with the ruling of the Court of Appeal. The Political Parties Amendment Bill affects each of you here. So it's important that we process it in a positive way. So it's important that we process it so that you will be able to give your inputs to the committee during this recess period, so that by the time we come here to debate it, you will at least have interacted with it, because it affects all of you. And hence, I really wish that we facilitate the fast tracking of these two bills so that we can move forward. With those remarks, I beg to move and ask my predecessor, the Honorable Duale, to second.
Mr. Speaker, I am between a rock and a hard place. Because I don't know why, and you know I have been in this office, Mr. Speaker, so I still remember the tricks that the leader of majority, me and the current one, can play. I don't know why it's so urgent for the political parties one, particularly. I have read it last night, to be subjected. But because I'm a ranking member, I think let's give him the benefit of doubt that we allow the committee to deal with this matter. But the leader must assure us, the Speaker, that he will not, this bill will not be part of any other bill that will be subjected to a special sitting. We have no problem if this bill comes back in January 2024. And the Speaker, let's be very honest, maybe members have not read it. This bill is poison. But because we're not discussing the substance and the second reading, I want each and every member of a political party to look at this bill and read it. But now, because the leader is asking for the committee to start working, I think it's the Jailer Committee, to start working on this bill, I second and I ask the House that I agree with the leader.
I propose the question. It is that notwithstanding the provision of Standing Order 120, this House resolves to reduce the publication period of the Circle Societies Amendment Bill, National Assembly Bill number 55 of 2021, and the Political Parties Amendment Bill, National Assembly Bill number 56 of 2021, from 14 days to 6 days. there of the House, I put the question. I put the question that notwithstanding the provision standing under 120, this House resolves to reduce the publication period of the Circle Societies Amendment Bill, National Assembly Bill number 55 of 2021, and the Political Parties Amendment Bill, National Assembly Bill number 56 of 2021, from 14 days to 6 days. Will as many as that opinion say aye? Aye. As many or contrary opinion say nay? Nay. The ayes have it. No, you know, honorable members, when 2 or 3 members shout loud, very loud, it doesn't mean that.
Order number 14, the Circle Societies Amendment Bill, National Assembly Bill number 55 of 2021, first reading. A bill for an act of parliament to amend the Circle Societies Act 2008. Order number 15, the Political Parties Amendment Bill, National Assembly Bill number 56 of 2021, first reading. A bill for an act of parliament to amend the Political Parties Act and for connected purposes.
Very well, honourable members. Now, if you go to the supplementary order paper, we go back to order number 4, which is comments on petitions. And the comments are going to be limited, honourable members, so that everyone, as many of you can have something to say. So I say the Honourable Limo, member for Kipkelion East.
Yeah, thank you, Mr. Speaker. I want to comment on the first petition. The first petition, Mr. Speaker, on issues of squatters. Squatter issues in this country has been very, very serious, Mr. Speaker, and I want to encourage those officers who are responsible for resettling or handling squatters issues that they should only concentrate on ensuring that their issues are resolved before they are evicted or they are moved. Because one of the biggest mistakes we have been doing in this country is to evict people to camps. Then to verify them is difficult. So we want to encourage them to be very cautious when handling squatter issues. Mr. Speaker, on the second one, Mr. Speaker, the second one is on tea plucking machines in Kericho, Bomet, and indeed other tea growing areas, especially Nandi. There is a serious influx of big machines, Mr. Speaker, which, if we are not careful, we will be actually struggling in this country to build, to create jobs for people. Whereas technology is coming. But technology should be handled carefully, Mr. Speaker, because if we are not handling carefully, we will end up sucking our people, and all the people in the tea industry are going to suffer. Mr. Speaker, I want to encourage the committee which will be handling to handle this petition very, very carefully and ensure that these machines are slowed down immediately, Mr. Speaker, because it is going to kill Kericho and other areas, especially the businesses around, because they are depending on the tea industry indirectly, Mr. Speaker. Mr. Speaker, I want to say this is a serious matter and it should be handled very quickly, Mr. Speaker, to save Kericho, Bomet, and Nandi, and other tea growing areas, Mr. Speaker, from being wiped by the tea plucking machines. Thank you, Mr. Speaker.
Now, all members who have placed interventions, they want to comment on the petitions, I believe. Intervention. Member for Kamukunji.
Thank you, Mr. Speaker. I wanted to comment on the petitions as well as follow up a statement.
We are not yet there.
Okay.
That is order number 7. We are order number 4.
Thank you, Mr. Speaker. I wanted to speak on the issue of the squatters in particular. Given the fact that we are facing this problem in many parts of the country, I think it is very important for us to consider the problems of the squatters in a humane way and within the context of our constitution. I think to a certain extent in parts of Nairobi, I see that there has been evictions, the displacement of squatters under difficult circumstances in this particular moment when we have economic problems, the COVID-19 problems, as well as climatic conditions. So I think this should be handled very carefully and in a humane way and within the context of our Constitution. Otherwise, we will be violating the rights of those people. They are Kenyans. We have women and children, and we must consider them very carefully before any action is taken against them. I sometimes consider those people who are used to evacuate them or evict them as not proper human beings, because they don't look at the plight of those people. They simply bring in bulldozers, knock down their houses, and render them homeless. It is the responsibility of our local governments and our government to look after all its citizens, and squatters have rights and they need to be looked after or just like any other Kenyan, Mr. Speaker. Thanks.
Member for Mwea.
Thank you, Honorable Speaker. I would like to comment on both petitions. On the first, Honorable Speaker, this country has a number of settlement schemes that are yet to be concluded in terms of titling, Honorable Speaker, and this is causing anxiety among the people who are originally allocated those parcels of land, and some who are encroaching on the same, and some who are actually taking or buying land in some of those settlement schemes, and this is likely to cause a lot of conflict in the future, Honorable Speaker. I have in mind the Mwea settlement scheme, which to date is not resolved, Honorable Speaker, and I urge the committee, which has a number of petitions on the same, to move with speed to advise the ministry on how to go about that scheme and other schemes that we have in this country. On the other petition, Honorable Speaker, as the chair of Labour and Social Welfare Committee, I wouldn't want to comment much on it, but to assure the petitioner that the committee will put every effort to address the issues raised, a number of them, including health, including malpractices by the multinationals, and including also the application of mechanization or highly mechanized equipment in the tea industry. Honorable Speaker, we went through it in the rice industry. To date, we are settled, and I'm sure even the tea industry will also settle on the same. I promise, Honorable Speaker, that we'll move with speed so that the anxiety among workers in the tea industry in Kericho is addressed and settle them as quickly as possible. Thank you, Honorable Speaker.
Member for Endebess.
Thank you, Honorable Speaker, for allowing me to contribute to the petitions. On the petition by the residents of Yatta on the issue of squatters who are settled in that place, and up to date, they are complaining of even people who have been brought out to encroach into that land. I think this is something that is countrywide, and more so in Endebess and specifically in Jepchoina settlement scheme, where we have people who have settled there for the last 20 years, and the government coming and trying to displace some of them. I think this is something that we want caution on the government, and we want that the Ministry of Lands handles all these issues in a humane way, make sure that the innocent Kenyans and those who have already settled are protected. Every Kenyan has a right, and we should not be able to use political hoodwinks and political positions to try and give maybe reward to some of the people in the hope that maybe they'll give you votes. All those people who are in those lands must be protected. Honorable Speaker, on the issue of mechanization in Kericho, I think it is good that we should be able to allow technology, but we should also be able to protect the workers so that they are not able to be rendered redundant. With those few remarks, Honorable Speaker, I want to support.
Member for Mavoko.
Thank you, Mr. Speaker, for giving me this chance. I wish to comment on the two petitions. One, Mr. Speaker, in advanced countries like China, India, mechanization is controlled. Mr. Speaker, this is to give its citizens an opportunity to get a honey. So I hear members who have petitioned on this, Honorable Maritime, Kericho, Nandi, and the tea growing areas. If we mechanize, Mr. Speaker, we really make those residents of those areas vulnerable because they have no any other way to make a living. So, Mr. Speaker, it is upon us in this House, we can even propose an act of agricultural mechanization. At what extent are we supposed to mechanize? Because, Mr. Speaker, most of our people, rural folk, they rely on this for their livelihoods. Number two, Mr. Speaker, the issue of squatters. This is a menace, either caused by our so-called Bwenyenyes. Mr. Speaker, we have seen people living in plots for more than 30, 20 years, and then one morning, dozers just come in, and they bring down these houses. Mr. Speaker, it is unfortunate. I think we must have laws, particularly on how we are supposed to title these lands, be it public land, be it community land. Mr. Speaker, we must have legislation that protects these people. And as a government, we must be sensitive to people who have been living in such areas for so long. Case in mind is Mavoko, Mr. Speaker, and I know even Nairobi is experiencing the same, and every town in this country. I thank you, Mr. Speaker. Thank you.
Member for Mvita.
Mr. Speaker, I beg your indulgence, but I think my point of order I had
This comment
no, it is not in regards to this, Mr. Speaker.
Okay. Honorable Sankok.
Thank you very much, Honorable Speaker. And I rise to comment on both petitions. The first one is the one that you have read on behalf of the petitioners. Honorable Speaker, surely if people have lived in that land for more than 30 years, Honorable Speaker, and then they are being removed from that land, it is unfair, and the government should be able to protect those people. Honorable Speaker, on the issue of Kericho, T-Placas, Honorable Speaker, yes, we want mechanization, but also we as a country are signatories to the World Labor Laws, Honorable Speaker, and we know what the World Labor Laws say, so that ILO, so that we can be able to let the people be let earn a living, Honorable Speaker, so that we don't make people poor in their own country, Honorable Speaker, simply because we are chasing mechanization, Honorable Speaker. Those multinational organizations should consider the workers first. Honorable Speaker, I also wish all the members, because now we are going on recess, I wish them a happy recess, a happy Christmas holiday. And as you go and campaign, because I know you'll campaign, remember very well that you have interacted with our speaker, who is a presidential candidate, one-on-one, Honorable Speaker. You know his leadership skills, Honorable Speaker. So I implore all the members, as you campaign for yourself, campaign for our able, Honorable Speaker of this House, the right Honorable Justin Muturi, who have led us for the last 9 years and have led us without fear or favor, without bias, Honorable Speaker, and he has been the mobile encyclopedia when it comes to the laws. He's the best person to lead it. And Honorable Kabinka can second that one.
Member for North Menti.
Thank you, Mr. Speaker. Mr. Speaker, I want to comment on both petitions. First is the mechanization of tea farms. Mr. Speaker, we need to see how we can stop mechanization for every part of the industry, because yes, we need mechanization, but not in the tea farms. Second is regarding squatters, Mr. Speaker. Mr. Speaker, this squatter problem is all over the country, and I wish the land committee we could have sorted out, because, Mr. Speaker, I have got my colleague Gigi Murugaru, I don't know, he was just here. His people are squatting on my land for the last 40, 50 years, and they are not coming out, and we have got titles to that land. So I wish the Committee of Lands could have sorted that out once and for all, so my people can stay there, because they're unleashing bees and arrows on our people so that we cannot occupy our lands. And they are squatters, Mr. Speaker. And the Raka people need to come out of Kwangombe, because that is North Menti. Thank you, Mr. Speaker.
Member for Tinderet.
Honorable Speaker, thank you for giving me this time to comment. And Honorable Speaker, on the issue of mechanization, Honorable Speaker, is a very big issue. Mechanization is important even in the first world countries. But in our county, especially Nandi County, Tinderet sub-county, Williamson Tea has decided to lay down almost 2,000 workers. And this, Honorable Speaker, has caused unemployment, has caused suffering. People in that particular area, especially in the Williamson Tea Estate, cannot even pay fees. They cannot even have earnings. This is a company that has been having over 4,000 workers. And if you go there today, Honorable Speaker, there is nothing there. It's only machines. They have grown forests, and now people are really suffering. There will be a lot of theft around there. On the issue of squatters, Honorable Speaker, we have so many squatters across the country, and this is caused by poor land policies. Especially in my constituency, we have squatters in places like Chemelil, places like many parts of Tinderet. I want to urge the Lands Committee to ensure that every Kenyan is able to settle and feel free and have land across this country. I support, Honorable Speaker. Thank you.
Member Vosoi. Member Vosoi.
Sorry, Mr. Speaker. The member for Kibwezi was consulting on some issue. Mr. Speaker, I think on the issue of mechanization of tea, Mr. Speaker, it reminds me of the time when the computers were introduced and we had a lot of opposition to the introduction of computers. Mr. Speaker, as a tea grower, I think I have looked at the profits that we will make once we mechanize, and I think it will be good profits, Mr. Speaker. So I think we need to train, find a policy to train the current tea pluckers so that they may learn to do other things. And Mr. Speaker, before I sit, I've seen the Leader of Majority and the Honorable Sankok and my neighbor here, Abdul Somad, are concerned why I'm sitting here. Mr. Speaker, I'm very concerned because to sit at the table of the seat of the Leader of Minority, Mr. Speaker, the reason is a lot of Kenyans have said the opposition is dead. So I'm here to try and help them until they come and reoccupy their seats in 2022. Thank you, Mr. Speaker.
Member for Igembe Central.
Thank you, Mr. Speaker. Mr. Speaker, I rise to support the two petitions, Mr. Speaker. First and foremost, Mr. Speaker, mechanizing the harvesting of tea or plucking of tea, Mr. Speaker, will render a lot of citizens of this country, Mr. Speaker, jobless or with no form of ways of earning a living, Mr. Speaker. Mr. Speaker, tea being one of the main cash crops of this country employs so many citizens, and most of them are squatters, those who pluck the tea. They have very minimal earnings, and they comprise a very big number of citizens who are in these rural areas. And if we introduce machines into these farms, Mr. Speaker, we will render so many families destitute, and more so, we shall not be even able to, they won't be able to cater for their needs, school, medicine, and even housing, Mr. Speaker. And more so, Mr. Speaker, we have come to understand, I'm a tea farmer, Mr. Speaker, these machines, sometimes they don't have as good quality tea, Mr. Speaker. And once we introduce that one, we will also drop the quality of our tea. Squatters, Mr. Speaker, there are many, and even in my constituency, Mr. Speaker, we have got squatters who have invaded my place, especially from Daraka, and we really want them to ask them, please, let them stick to their land. Let them not to come to our land in Meru. Thank you, Mr. Speaker.
Member for Kiharu.
Thank you very much, Mr. Speaker. And I want to comment on the issue of mechanization. And Mr. Speaker, mechanization is actually not a bad thing because technology increases productivity even per capita. And the most mechanized economies, Mr. Speaker, are the ones that have got the highest revenues per person. The issue is usually about timing, Mr. Speaker, because in an economy like ours, where a majority are unemployed, Mr. Speaker, then machines cannot come and replace labor. And therefore, Mr. Speaker, that is the only reason I support the petition, but progressively, an economy thrives as we adopt and continue to embrace technology and mechanization. But Mr. Speaker, the whole issue is about the fight between capital and labor, and also between profits and wages. Because, Mr. Speaker, mechanization is a component of capital. And what that does is that it increases the margins, Mr. Speaker, or the profits. But also, Mr. Speaker, we have to be mindful that the progressive economy, Mr. Speaker, and the current economy across the world is an economy that moves towards mechanization, Mr. Speaker, where we see in economies like Germany, Mr. Speaker, and other developed economies. You see, for example, an auto company, Mr. Speaker, where they deploy robots to do what human beings do, Mr. Speaker. But also, actually that moves now to the issue of having a common wage for everyone, Mr. Speaker, for us seeing and looking forward to where economies will be predominantly mechanized and where labor will have very little to do in those economies. But because we are not there yet, Mr. Speaker, we need to embrace and spur economies and industries that are labor intensive to provide opportunities for the many people in the rural areas to be real agents of.
Member for Kabuchai.
Thank you, Mr. Speaker. Mr. Speaker, I also support this petition on mechanization, Mr. Speaker. That, Mr. Speaker, when we mechanize this tea plucking, Mr. Speaker, yes, it's good. Yes, Mr. Speaker, it saves on time. But, Mr. Speaker, this is only done in areas where we lack casual laborers. We have countries, Mr. Speaker, where you can look for manual labor and don't find. These are the only countries, Mr. Speaker, we can allow for these machines to be used and take the jobs of men. But, Mr. Speaker, in our country, like Kenya here, my people from Western, Mr. Speaker, they are the most relied people who black tea, Mr. Speaker, in Jebaun, Kapsuser, down, Mr. Speaker, in Seretet, even in Finlay, Mr. Speaker, in Kericho. Mr. Speaker, if we bring out this, we shall lay off so many people. And the economy, Mr. Speaker, is on the bottom. When we pay well those workers, we give a strong base, Mr. Speaker. And the bottom, Mr. Speaker, to rise up and have the bottom-up economy, Mr. Speaker. We pay well these people, Mr. Speaker. And then they will rise, Mr. Speaker, to have the best economy in the world by taking the base of this. Mr. Speaker, I don't want this to move further and even affect the sugarcane harvesting, Mr. Speaker, where if we use the mechanized harvesting, workers might not cut cane and we don't have much pay. Thank you, Mr. Speaker. I support the petition.
Member for Buret. Member for Buret.
Yes. Thank you, Mr. Speaker. I do rise to support this petition, Mr. Speaker, that the coming in of machines in the tea growing areas has impacted negatively on the economy in those areas, Mr. Speaker. First of all, majority of the population, Mr. Speaker, rely on working on the tea plantation. But as a result of mechanization, many livelihoods have been affected. All sectors, Mr. Speaker, have been affected, from the pluckers, the transporters who ferry workers to the tea plantation, Mama Mboga who provides food for the workers who are working at the plantation, even the suppliers of food for the workers who work at the plantation have all been affected, Mr. Speaker. It's a whole chain, Mr. Speaker, that has been affected. And the advent of these machines is impacting negatively. Notwithstanding, Mr. Speaker, that the population in those areas are coming to terms with the economy which has been affected by COVID. Now they have to deal with mechanization. Mr. Speaker, these companies, they have not sensitized the population. They should be transient. There is a way in which they should have introduced the mechanization. But just coming in and terminating employment is unwarranted, Mr. Speaker. Mr. Speaker, this economy, the economy of the areas, are built by the larger population. Coming of the machine will undo what has been done in many generations, Mr. Speaker. Currently, Mr. Speaker, with the bottom-up economy, Mr. Speaker, we need all the workers on the bottom be given the work, the wages to come from the bottom as you progress, and at the right time, when we are up there, we can go to the machines. But as of now, let's build the economy from the bottom, Mr. Speaker. Thank you.
Okay, the last one now on this member for Tharaka.
Thank you very much, Mr. Speaker. Mr. Speaker, I comment on the first petition and support the same and seek that it's moved expeditiously so that the issue of squatters can at least be addressed and possibly resolved. Mr. Speaker, I had just retreated to the back chamber to discuss very important legal matters that are coming before the House. When I heard the Honorable Member for Imenti North mention a place known as Kwangombe, stating that it is in North Imenti and it is occupied by squatters from my constituency, Tharaka. Mr. Speaker, allow me to say that that is extremely frivolous and vexatious, and that in fact, Honorable Dawood does not know where Kwangombe is. He has never set foot there. He has never asked for votes there. He doesn't even have one single development in that particular area. Record will bear me out that the market called Kwangombe is actually in Tharaka Nithi County. The school, primary school at Kwangombe is in Tharaka constituency, and the polling station, where I got voted, is actually in Tharaka. The only reason why Honorable Dawood brings this claim is purely because he may have run out of land in Meru and he is seeing untitled land in Tharaka, and he wishes to come down and get his people to actually occupy that land. It is therefore not true. Kwangombe and all these other places along the boundary are actually in Tharaka. As far as Honorable Kiringo is concerned, he is from Igembe Central, and Igembe Central does not border Tharaka at all. So if there are any people in Igembe Central who are from Tharaka, then they have actually bought that land on a willing buyer, willing seller, and therefore Honorable Kiringo cannot complain.
Well, the petitions stand committed to the respective committees. Honourable members, you know, if somebody says something that contradicts some facts, that is not, it is not another matter. That's merely a point of argument. Please, let the petitions be dealt with there. Let's move to next order.
Order number 5, papers.
Leader of majority.
Thank you, Honorable Speaker. I beg to lay the following papers on the table of the House today, Thursday, December the 2nd, 2021, afternoon sitting. The reports of the Auditor General and financial statements in respect of the following institutions for the year ended 30th of June, 2021, and certificates therein. A, East Africa Trade and Transport Facilitation Project, IDA credit number 4148 KE and credit number 4977 KE, MOT component. Number B, East Africa Trade and Transport Facilitation Project, MOT/KRC component, credit number 4148-KE and credit number 4977-KE. Number C, multiple educator cluster service project of UNICEF. Number D, the support of the healthcare financing strategy, reproductive health, output-based approach, project credit BMZ. Number Kenya 201065853, Ministry of Health. Number 2, the reports of the Auditor General and financial statements in respect to the following institutions for the year ended 30th of June 2020 and the certificates therein. A, Special Economic Zones Authority, the Nuclear Power and Energy Agency, the Kenya Vision 2030 Delivery Secretariat, Commission for University Education, Kenya Film Classification Board, the Kenya Towns Sustainable Water Supply and Sanitation Project, AFDB loan number 200002000501, Tana Water Works Development Agency, the University of Embu, the Jomo Kenyatta University of Agriculture and Technology. And number 3, the reports of the Auditor General and financial statement in respect to the following constituencies for the year ended 30th of June 2020 and the certificates therein. Number 1 is Bondo, Tigania West, Ugenya, Seme, Bureti, Bere South, and Isiolo South. Number 4, the reports of the Auditor General and financial statements in respect to the following constituencies for the year ended 30th of June 2019 and certificates therein, and these are Baringo Central, Chepalungu, Nakuru Town West, Baringo South, Njoro, Mogotio, and Ndia. And lastly, the reports of the Auditor General and financial statements on Kenya Film Classification Board for the year ended 30th of June 2019, and the certificate therein. Thank you, Honorable Speaker.
The Chairperson, Departmental Committee on Lands, Honorable Nyamai.
Thank you, Honorable Speaker. Honorable Speaker, as you directed, the two petitions that I'm going to table, the reports were handled concurrently. Honorable Speaker, I beg to lay the following papers on the table of the House today, Thursday, December 2nd, 2021. Reports of the Departmental Committee on Lands on 1, Public Petition number 45 of 2020 by residents of Garsen constituency in Tana River County regarding subdivision of agricultural development corporation land and stakeholders consultation on Galana Kulalu food security project, and public petition number 31 of 2021 by residents of Garsen constituency in Tana River County regarding degazettement of specified ADC land in Garsen constituency. Thank you, Honorable Speaker.
The Chairman, Departmental Committee on Lands. No, sorry, on Trade, all member, Special Funds Accounts Committee. Honorable Bukose.
Thank you, Honorable Speaker. Honorable Speaker, sir, I beg to lay the following paper on the table of the House today, Thursday, December 2nd, 2021. The 11th report of the Special Funds Accounts Committee on the audited financial statements for the National Government Constituencies Development Fund for 26 constituencies in the counties of Mombasa, Kilifi, Kwale, Taita Taveta, Lamu, and Tana River for financial years 2013-2014, 2014-2015, and 2015-2016. Thank you, Honorable Speaker.
Next order.
Order number 6, notices of motion. Order number 7, questions and statements.
Question by private notice, Honorable Simba Arati.
Thank you, Mr. Speaker. Notwithstanding of your earlier communication, Mr. Speaker, on the questions, I raised to ask question 12 of 2021 to the Cabinet Secretary of Health. What is the government's policy regarding detention of deceased bodies by hospitals over unpaid bills? 2, could the Cabinet Secretary compel the Kenyatta National Hospital, KNH, to release the bodies of the late William Gesige Oile of Nyeriba and Masaba, who was admitted on 20th September 2021, and unfortunately, Mr. Speaker, passed on 22nd October 2021, and the late William Omagwa Siambe, ID card 37-12-21, orphan from Kiabugesi sublocation, Kenyanya sublocation, Kisii County, who was admitted on 15th September 2021, and unfortunately, Mr. Speaker, passed on 6th October 2021. And the bodies have been lying since then in the KNH mortuary with a bill of amounting of 2 million.
The ministry appeared before the committee today, and they've responded, though the answer was not satisfactory, but we are still engaging, so hopeful by next week, Wednesday, as per the promise of the ministry, the farmers are going to have every reason to smile. So the fears of the members that perhaps maybe these questions will lapse when we go for the recess. Mr. Speaker, there is a possibility that the response will be positive. So keep our spirits going, Mr. Speaker.
Well,
Mr. Speaker.
But that's not to say that the standing orders will not apply. The spirits, obviously, we have every reason to add. We would want your spirits to be very high.
Thank you.
Proceed, Honorable Gutun.
Thank you. Thank you, Mr. Speaker. Mr. Speaker, I rise to ask question 484 of 2021 to the Cabinet Secretary for Interior and Coordination of National Government. Mr. Speaker, one, could the Cabinet Secretary explain the circumstances under which Mr. Barnabas Lagat of ID number 124-18176 was allegedly attacked and shot by a police officer attached to Kapchero Police Station at Kapsibilai Trading Center in Cherangani constituency on 27 September 2021 because he was not wearing a face mask? And then two, under what circumstances did the said officer stray beyond area of jurisdiction, considering that the Kapchero Police Station is in Elgeyo Marakwet County, while Kapsigilai Trading Center is in Trans Nzoia County, Mr. Speaker? Lastly, Mr. Speaker, are there any plans by the government to meet the medical bills incurred by Mr. Langat at the Moi Teaching and Referral Hospital and further compensate him for the shooting? Thank you, Mr. Speaker. And I've seen the chair here, and I'm sure he's going to assure me that by tomorrow we get the response. Thank you.
Well, the question will be replied before that committee, whose chair you have identified, Administration of National Security. The next question is by the member for North Imenti, Honorable Dawood.
Thank you, Mr. Speaker. Mr. Speaker.
Finance and National Planning. The next question is by the member for Mavoko.
Thank you, Mr. Speaker. I raise to ask a question directed to the Cabinet Secretary for Water Sanitation and Irrigation. Mr. Speaker, number one, could the Cabinet Secretary provide a detailed report on water projects implemented from 2017 to date, as well as ongoing and the status across the country, indicating the location of the said projects in terms of constituency and the county? Number two, Mr. Speaker, could the Cabinet Secretary further provide details of water projects implemented by the national government in Machakos County, particularly in Mavoko constituency, including the names of contractors, scope of works done, and amount paid to each contractor? Number three, could the Cabinet Secretary explain why the construction of Mangalalia Borehole and the Kavumboni Dam in Machakos County has stalled since 2019 to date, despite funds having been allocated? Number four, Mr. Speaker, may the Cabinet Secretary tell us why the PS, one Joseph Irungu, is campaigning with taxpayers' money? I thank you, Mr. Speaker.
The question will be replied to before the Committee on Environment and Natural Resources. Next is by the member for Kirinyaga Central, the Honorable John Wambugu.
Thank you, Mr. Speaker. I rise to ask question number 530 of 2021. The question is directed to the Cabinet Secretary for Education. One, could the Cabinet Secretary for Education explain the circumstances under which 41 students who sat for Kenya Certificate of Secondary Education, KCSE, in 2012 at Sacred Heart Kangaita Secondary School in Kirinyaga Central constituency were denied their certificate by the Kenya National Examination Council, NEC? Two, could the Cabinet Secretary also explain why NEC has failed to issue KCSE certificate to Gedai John Kariuki, index number 092034222035, and Kenywan D. Mureithi, index number 092034220005, who sat for KCSE in 2012 in the said school, despite the two having made numerous follow-ups and submitting all the requirements? Three, when will the affected student be issued with their KCSE certificates to enable them pursue their careers? Thank you, Mr. Speaker.
Question will be replied to before the Committee on Education and Research. What's your point of order, Honorable Fatuma Gedi? What's your point of order?
Mr. Speaker, listening to Mheshimiwa from Mavoko, he asked a question to the Cabinet Secretary of Water. Reading his question, Mr. Speaker, the last part that he mentioned, that the PS is campaigning with the money of the taxpayers, I think, Mr. Speaker, it needs to be removed from the record because it's not in the question that he asked, and the PS is not here to defend himself. The PS of Water, Mr. Speaker, is not in the House, and the question is not in the question, Mr. Speaker.
Now, let me tell you, the last page of the question reads as follows. Could the Cabinet Secretary explain why the construction of the Ngalalia borehole and Kabomboni Dam in Machakos County are stalled since 2019 to date, despite funds having been allocated? So anything said beyond that is superfluous, and it is ordered to be expunged from the records. What will be presented to the Cabinet Secretary is this one. Those others are meant for entertainment. So the Honorable Fatuma, again, don't worry. They say, remember it was said by the Americans that Parliament in plenary is Parliament in exhibition. This is part of the exhibition. So don't worry about the exhibition. What will be sent is what is written here. Honorable Kabinga Washira, what is the issue?
Mr. Speaker, thank you for your ruling on that. But Mr. Speaker, this cannot go just like that. The honorable member included something that was not in his question. And this has character assassinated somebody who is not in this House, Honorable Speaker. I think he needs to either apologize or withdraw officially what he has said. This is a very serious
somebody
allegation.
Has been assassinated?
Well, the character, his character.
Now I think let's forget about the assassination. They will survive. They may not have their heads chopped off. It's been expunged anyhow. It's expunged from the record. The last question is by the member for Langata, Honorable Nixon Korir.
Thank you, Mr. Speaker. I rise to ask question 531 of 2021 to the Cabinet Secretary for devolution. Question number 1. What plans are there to rehabilitate the dilapidated roads in Langata constituency, particularly the roads within estates under the National Metropolitan Service? Question number 2. Could the service provide a list of the roads that have been rehabilitated, improved, or constructed in Langata constituency since the establishment of the National Metropolitan Services? Thank you, Mr. Speaker.
To be replied before the Committee on Administration and National Security. Next segment is statement requests. And the first request is by the member for Laikipia North, the Honorable Sarah Korere. These are requests or responses. Who was to respond? Committee on Administration, are you ready? Do you have the response ready?
These are responses, Honorable Speaker.
They are ready, eh?
Yes.
The member is not present. Just table the report. Just table the report. Just table it. That's enough.
Thank you,
no,
Honorable.
Just table it.
I hereby table, Honorable Speaker, the response to the statement which was sought in regard to information on banditry attacks in Laikipia County. Thank you.
The next one is by the member for Lafi, the Honorable Mude, Ibrahim Mude. Okay, it's gone on recess already. You can just table the report.
Honorable Speaker, I therefore table this response to the statement which was sought regarding kidnapping and disappearance of persons in the country, which was sought by Honorable Ibrahim Mude, Member of Parliament for Lafe constituency. Thank you.
The next one is the response to a request for a statement by the Honorable Caleb Amisi Luyai. That one might on recess at the beginning of the week, I think. Just table.
Honorable Speaker, therefore allow me to table the response to the statement which was sought by the member for Saboti constituency, the Honorable Caleb Amisi Luyai, regarding delays in the issuance of national identity cards. Thank you, Honorable Speaker.
Honorable Abdul Samad.
Thank you very much, Mr. Speaker. I've raised this matter. I think.
Which matter?
The issues that I'm about to explain, Mr.
But
Speaker.
you can't say you have raised a matter which you have not said. So what, you say it first, then you say you have raised it.
Mr. Speaker, we had raised issues with the Finance Committee and the Labour Committee. Mr. Speaker, these matters were regarding issues to do with the reinstatement of 247 employees from Kenya Ports Authority, and the issue to do with the Finance Committee was why KRA is enforcing people whose PIN is not from Mombasa. They cannot be able to collect or use their cargo the way that they want, basically trying to imply that Mombasa is not part of Kenya. Mr. Speaker, I've raised this concern severally, both with the chairpersons on the floor of this House as well, considering, Mr. Speaker, that we are going for a long recess. And until today, I've waited until this very moment, the last moment feasible for me to be able to get a response, and I'm yet to get a response. And I think I leave it, the onus is on the chairpersons to be able to explain to themselves, and they're here, but they also feel very, very disturbed by what the ministry is doing and the kind of cat and mouse games that the executive is playing, Mr. Speaker. And I'd like you to be able to give a ruling on this matter, because every single day, Mr. Speaker, that passes, the livelihoods of the people of Mombasa are being jeopardized. Jobs are being lost. People are closing up factories. Warehouses are being shut down. CFSs are being shut down. People, livelihood, it's just becoming too unbearable. And if this House does not take that necessary action, Mr. Speaker, once again, we are looking at eventually having Mombasa to be a ghost town, whilst its representatives have raised these matters in the National Assembly.
Well, who is supposed to respond? Is it the Honorable?
It was both the Labour and Finance.
Honorable Wanga, do you have anything to say? This is good for end of term. I mean, it's good, isn't it?
Thank you, Honorable Speaker. Honorable Speaker, I empathize with the Honorable Abdul Samad, because one of the most important responsibilities that we have as members of Parliament is to stand up for our people, especially during times of difficulty. But Honorable Speaker, as a committee, we're also frustrated because we send all these questions to National Treasury, which you remember, Honorable Speaker, you even ordered that summons be issued for the CS for National Treasury. But he has been traveling out of the country. I think he has been representing His Excellency the President in some fora outside the country. So we haven't been able, for example, this feedback for Honorable Abdul Samad does not need the CS. We just needed to know exactly what is happening on this matter. Treasury has simply not sent back that feedback. So we are also equally frustrated because this matter was raised by Honorable Abdul Samad, even with me, at a private level. And I have been following up almost every single day with my secretariat to call the Treasury. The Treasury is called. Apparently, right now, the response is lying on somebody's desk who hasn't signed it. So, Honorable Speaker, at this juncture, we are not sure what more to do because even summons have been issued. So, Honorable Speaker, it's that's where we are as a committee at the moment on this matter. We have been told, the last we heard about it yesterday is that the report has been done. It is on somebody's desk who hasn't signed it in order to have it brought to the House. Thank you, Honorable Speaker. I don't know, I cannot give a commitment to to Honorable Abdulsamad, unfortunately, because that commitment might amount to naught. But I think hopefully, if the House closes today, we will obtain the response while committees are still sitting, and invite, for the time period that committees will still be sitting, and invite Honorable Abdulsamad together with Treasury within that period that committees will still be sitting, as will be guided by yourself, so that this response can be given before the House goes on full recess. Thank you, Honorable Speaker.
The Honorable Kabinga.
Thank you, Honorable Speaker. Indeed, as Honorable Wanga has stated, we have been trying to address our issue that is on the 247 employees who are laid down. And a week ago, Honorable Member from Vita raised the same issue, and we raised it again with Treasury. We don't understand why such a simple matter is taking that long, Honorable Speaker, and I want to really congratulate the Honorable Member from Vita, because he has been very, very, very consistent in following up this matter. We have had petitions and statements and questions where members sometimes forget them and we kind of sit on them. But on this one, he has been very, very, very consistent, Honorable Speaker, and I think it's a high time you probably give a ruling and also allow us within the period that we are in recess to have probably a joint sitting with the Finance Committee and the Minister, so that these two issues can be dispensed of at the same time, Honorable Speaker. We beg for your indulgence on this.
Unless you do it in the course of next week. Unless you do it in the course of next week. You know, Honorable Abdulsamad, you can't make this a debate. You know? No. It really is not going to be the debate. You must look for where you are not able to get response. If as Honorable Wanga saying, the CS is out of the country, there's a PS in that ministry. And you know, it speaks volumes that even notwithstanding the fact that we as Parliament notifying Treasury that next financial year usually is a general election year, and that we needed to get the budget policy statement in good time. They just brought it the other day, yesterday, I think, yesterday or day before. It just speaks volumes about the caliber of the fellows who are there. I think either they have gone to bed or they need some jolting. But we can only deal with them when we are sitting in plenary. So no, I mean, we cannot have a special sitting. No, please. This is not. Let's go to. We need to go to do business. No, the member for Kamukonji had an issue. He had seen me about an issue.
Thank you, Mr. Speaker. I also have an issue. I had requested a statement from the chair of the Departmental Committee on Administration and National Security on the frequent fires in my neighborhood of Kikomba Market. And we have now reached the end of this particular session. I had asked that statement on the 21st of October, and since then we have had 3 more fires and absolutely no response from the ministry. I must say that I'm concerned with this extraordinary lack of response, which gives me, does it mean that the ministry does not give a damn about the plight of the people of Kikomba, many of them who have lost their livelihoods, many of them who have been turned into destitutes? And there is no really visible action or firm action on the part of the government to kind of reinforce security and to protect the properties and the goods of those particular communities that are affected by these fires. So I just wanted to know your guidance and what we need to do about that, because this is absolutely not acceptable, and it's quite frustrating. And I would not get tired of raising their voices here and bringing their cases in this August House. And I'll be grateful, Mr. Speaker, if you would give us some guidance on that. The second one is that I had also raised a similar problem with
So I think I did my best, Honorable Speaker, and that is as much as I can respond. The bulk of the work was supposed to be done by the ministry as a CS, and mine is to transmit and deliver them to this House. Thank you, Honorable Speaker.
Well, you see, unless now if the House was sitting, then you can say that you get a response next week. But now there is no the House will not itself be sitting. So, Honorable Yusuf, you may have just to wait, or use other avenues that, as a long-serving member of Parliament, you know how best to deal with such situations. Honorable Yusuf. The other one, because the chair of Lands Committee is not here now even to respond. The chair left, so we cannot. That can be communicated through the Office of Leader of Majority to follow up. Indeed, even that one, I think the Leader of Majority will help you follow up.
Thank you, Mr. Speaker. I just shuddered to think about what could happen if there is another fire while we're still waiting for the response from the government department, responsible government department. Because
I think the response would be to go to the fire brigade, isn't it?
No, but there is a necessity to protect the properties and the goods of the people of Kikomba. They are citizens of Kenya, and they're taxpayers. And the government, at least, even if there isn't an immediate reply, is to show up security so that people can see that there is a concern from their elected government, that there is a concern about their plight. And also they have made a lot of losses. There's absolutely no attempt to compensate or support these struggling communities, given the fact that Kikomba is not just a market. This is a massive area that provides employment and livelihood to thousands of people.
Honorable Yusuf, yeah, I mean, now you're asking me what to do if there's fire. Now, I have never even trained in handling fire myself at all. Never even desired to, because I don't like fires. So I would be in similar difficulties as yourself. But I think let's follow up with the relevant people through the Office of Leader of Majority, because the House will be on recess. There was another one. Honorable Sankoka, you also have a statement. Which one?
Honorable Speaker, I had asked the Interior Minister to give me the LR number or the title deed number of the land he claimed that is owned by the Deputy President, 15,000 acres in Laikipia. And you gave directive that I should be answered on Thursday. The same Thursday, they came here, but they did not have an answer. Now 3 times, they have called me all the way from Narok, and they have refused to give me any answer. So, Honorable Speaker, I urge you, being the third in command, just declare His Excellency William Ruto that he is innocent of all the accusations that they have been being accused and labeled upon. Because if they cannot give, and they had actually, the CES on the Hansard claimed that there is that 15,000 acres. And also William Ruto through the media claimed that he does not have 15,000 acres of land in Laikipia. And if it is there, let them distribute to the landless of Laikipia. Now, when I ask that question so that we know where the truth lies, then the CS is playing monkey games. He have refused to come and answer. And even you gave directive. I think he does not know that you are the third in command. You can give even more severe directive that I should be answered. And now that we are going on recess, I cannot go. In fact, God will not forgive me if I go knowing very well that my question have not been answered. The people like Kipia are waiting to be given land, that the DP have already given them, that is 15,000 acres, 1,000 of those quarters are waiting. And again, no. Here he's not, they are not answering my question. So please let them answer my question, or you use your powers and declare that William Ruto is very innocent from not only this accusation that they have accused falsely, but also of other accusations that they have been labeling against him.
Did you say it was said on Hansard? Did you say it was said on Hansard?
Yeah, Hansard.
It was said on Hansard.
Yes, that is the minister, CS Matiang'i himself, came in front of a committee and claimed that the 15,000 acres is owned by Deputy President in Laikipia, when there was a lot of skirmishes in Laikipia. That is false accusation because he have not been able to table because I've asked the same question. And you know, we can excuse.
Maybe the Honorable Mwadi can respond to that one. If it was on Hansard, this
Honorable Speaker, when the Honorable David Sankok, MP, came to this chamber because he was seated here, and a response was supposed to have been given by the CS, but you had instructed that the CS does it. But who came? The person who came was the CS, and the CS said he was not under any instruction to answer that question, but that was going to be answered by the CS himself. Subsequently, Honorable Speaker, you've not been able to interact with the CS to be able to pursue that matter. But they said the answer was to be brought as per your direction by the CS himself. Thank you, Honorable Speaker.
Honorable Sankok, I think you will pursue it with Honorable Mwadi. If it's on Hansard, it can be. Yes, Honorable Mwadi, you want to say?
Honorable Speaker, I'm aware that we shall interact with the CS tomorrow, and I know we are going on recess today, and I can give him, if it's written, I promise and undertake to give him, to be going through it even as we are in recess. But I know they were very committed to bring that answer.
Very well. So you'll get, you say you are very sure you are going to interact with the CS. Is it as committee or as Honorable Mwadi?
Honorable Speaker.
You could be interacting somewhere else.
No. I want to make it very clear that occasionally when there are issues, including the balance of questions that we are not able to get, I directly have to get to him so that I'm able to articulate the issues that members bring. And as the chair of the committee, with the authority of the members, they allow me that if I get those, then I can transmit to the members.
Then include the one by the Honorable Yusuf?
Yes, all of them actually, the pending ones.
Yes, all those ones which have been raised, I think it's good that you get...
It's my desire, Honorable Speaker, that we have the output that befits the committee. It's only sometimes we get let down by the department.
Correct.
Thank you.
Honorable Ishungwa, you appear to be itching to say something.
Yes, Honorable Speaker, thank you for indulgence.
And today you unusually came after 4.
Yes, Honorable Speaker, unfortunately, or fortunately, I had a sitting with my border chairman and their secretaries in the constituency. That's why I'm late and I profusely apologize. But Honorable Speaker, thank you for indulgence. Sitting here and listening to all the issues that have been raised, Honorable Speaker, you must agree with me that there seems to be a problem. If you listen to the issue that Honorable Abdul Samad raised, and the chair of finance was at pains to enumerate the kind of struggle she has had to go through, it's indeed clear that there is a problem. And you know, Chair, Honorable Speaker, I sit in the Committee of Members' Welfare, a committee whose one of its cardinal responsibilities is to promote and entrench parliamentary democracy. And I see a danger, Honorable Speaker, in our parliamentary democracy being in grave danger from the executive, Honorable Speaker. If you listen to the issues that Honorable Abdul Samad raised, indeed, I remember speaking to that issue when he raised it on the floor, and it is a matter that affects the people that we represent in this House, Honorable Speaker. The chair, Finance, Honorable Wanga, you've clearly heard what she has said. the struggle she has had with the minister in charge of the National Treasury particularly. Honorable Speaker, we went to great lengths in this House in the course of this session to debate, taking a lot of taxpayers' time and money to debate the motion on fuel prices. And I'm aware the chair has tabled her report today only after interacting with the ministry yesterday. I am rather concerned, Honorable Speaker, that particularly the Ministry of Finance or the National Treasury is indeed taking this House for granted. And it's not just the question by Abdul Swamad, the issues that had been raised on by Honorable Duale, the issues that we have had to deal with, like the issue of petroleum prices, Honorable Speaker. You have just stated, Honorable Speaker, from where you sit, on the issue of the budget policy statement, a matter that is of serious concern to Kenyans, that if we are going into an election year, Honorable Speaker, and maybe at most you come back maybe a week or two before our scheduled mid-February resumption dates, we may not have time as a House to clearly interrogate the BPS as it ought to be. And I find it deliberate, and that's why I'm seeing a danger to our parliamentary democracy, Honorable Speaker. If we will be coming back in January to look at BPS, possibly look at a supplementary budget, Honorable Speaker. And I'm aware from other quarters, Honorable Speaker, that there are indications that they may even want to recall us from the recess to come and probably look at some of these issues like a supplementary budget. And it is within their right, Honorable Speaker. But we must be firm as a House that if that CS is to table a supplementary budget before this House should be firm not to consider such a supplementary budget until some of the issues that we have addressed in this House, like the issue Abdul Samad is raising that touches on the people that we represent, Honorable Speaker. People out here are suffering, being forced to get goods. You can imagine you operate from Mariakani or Changamwe, and you are forced to come for your goods from Nairobi and transport them back by road to Mombasa. And those are some of the issues the member for Mvita had raised. The issue on petroleum, Honorable Speaker, is a matter that this House took its time because it affected not just the livelihoods, but even the cost of living of the people that have sent us here. We are going into an election next year, Honorable Speaker. If the people see us not representing them and acting in their interest, Honorable Speaker, they will punish us next year. And before they punish us, then I want to implore on the House, Honorable Speaker, that indeed the House for granted. And I dare say, Honorable Speaker, I want to encourage the House, if there is a supplementary budget that is being brought in the course of the recess, Honorable Speaker, if the issues that have been raised by members here, the issue by Abdul Samad, the issue by Honorable Duale, the issue of the petroleum business that we are to do, and I'm happy that we have had procedural motions that allow us to consider some of these things and go to committee in the course of the recess, Honorable Speaker. But if there is priority business, I was reading the order paper in this morning, I was asking myself, if there's priority business that this House should have prioritized, was that bill on fuel prices by the committee led by Honorable Gladys Wanga. But if you have a cabinet secretary and a national treasury that is taking the House for granted, Honorable Speaker, we must have recourse. Otherwise, if the chair sits here and laments, the speaker is lamenting that the BPS was only brought the other day. I mean, what are the Kenyan people bound to do? We are only at the danger, Honorable Speaker, and that's the point I wanted to raise, just to raise our consciousness that we are at a danger of our parliamentary democracy being threatened by an overbearing executive that seems now to be very keen to capturing even the legislature, Honorable Speaker. And we must stand up as a House to protect our parliamentary democracy as the people's representatives. Thank you, Honorable Speaker.
Committees are at liberty to propose any of the sanctions that are available. So that, I've seen this time without number. Committees should not feel frustrated. You are at liberty to propose sanctions. The law is there. You have everything in your hands. So it's only you. If you don't want to apply those sanctions, then of course, I wish you well. So Did I see there's a request from the Honorable Shinali?
Leader of Majority Emeritus, I have been with you here since morning. Yeah, today, even when you are seconding Leader of Majority. Honorable Speaker, I wish to make a statement. Mr. Speaker, as you are aware, the 2022 budget policy statement submitted and tabled Wednesday, 1st December 2021. Mr. Speaker, this is a statutory document with strict timelines as provided under Section 25 of Public Finance Management Act and National Assembly Standing Order 232. Section 25 of the BFM Act 2012 provides that Cabinet Secretary, National Treasury to submit the PPS by the 15th of February each year. Thereafter, Parliament shall not later than 14 days after the PPS is submitted, table and discuss a report containing its recommendation and pass as a resolution to adopt it with or without amendments. Mr. Speaker, in view of the revised budget calendar to accommodate the general election scheduled for August 2022, the 2022 PPS was submitted to Parliament by 30th November 2021. The Cabinet Secretary, the National Treasury and Planning shall take into account resolution passed by Parliament in finalizing the budget for the financial year 2022-23 and the medium term. Mr. Speaker, noting the PPS forms the basis for preparation 2022-23 annual estimates, which are expected to be brought early February next year, it is imperative to process the 2022 PPS before end of this year. In regard, I would request your intelligence as well as that of the House so that I table a calendar of timelines in processing 2022 PPS and request the relevant departmental committees to adhere to the set timelines. In addition, Mr. Speaker, I will be liaising with the House leadership and your House to agree on it. I hope the House will consider our request and approve. I'm the Vice Chair.
Which is that you are saying you'll be tabling a calendar?
Yes, it's one I want to table, Mr. Speaker.
Calendar?
Timelines. Yeah.
You can go through that.
But we don't know, Yeah, read out what is proposed, because you see, the House is, as per the resolution of 10th February this year, scheduled to go on recess this evening.
Yes, Mr. Speaker, I just tabled for you to go through whether it's agreeable, Mr. Speaker.
We could have read out so that we hear what it is.
Mr. Speaker, I wish to read. Let me read them out, Mr. Speaker. Mr. Speaker, submission of the 2022 budget policy statement, PPS, to Parliament, that is on 1st December 2021, which was done. Mr. Speaker, public participation of the 2022 PPS pursuant to Article 118(1)(b) and 201(a) of the Constitution, that is on 6th to 10th December 2021. 3, Mr. Speaker, briefing and consideration of the PPS by relevant committees, that is 8th December 2021. Presentation of unpacking of the PPS to Budget and Appropriation Committee, that is 14th December 2021. receiving submission from departmental committees of the National Assembly 16th to 17th of December 2021. Meeting with the Parliamentary Service Commission, the Auditor General, and the National Treasury to discuss the proposed ceilings, 18th December 2021. And budget and appropriation considering the draft report on the 2022 PPS, 20th December 2021. Special sitting day to approve the Budget and Appropriation Committee report, 21st or 22nd December 2021.
I'll tell you this for free, that the calendar of this House can only be altered by the House resolution. The Treasury of the Republic of Kenya has no authority to come and propose those kind of things. No, I mean, it's not possible. It's not possible. It is not. People cannot sit on their job and then want to hold Parliament at ransom. It is wrong. They were warned long ago that the House was due to go to recess on 2nd of December. And then the BPS is tabled here on 1st of December, and then somebody starts proposing that 8th, I don't know, 6th, I don't know. I mean, there's no question. I mean, there's not.
No, but Mr. Speaker, I think we members, even chairs and members, we must protect the independence and the integrity of this House. Mr. Speaker, this afternoon, among the many communications that you issued, was that committee sittings will end on the 13th of December.
Yeah.
And they will resume sometime in January. Mr. Speaker, this is why sometimes we are accused of executive capture of the legislature. I mean, a member of parliament, a vice chair of a committee of budget, cannot come, Mr. Speaker, and Honorable Shinyali is a second timer. He participated in the approval of calendars. I mean, today, after the Speaker has read a communication, without a motion, he wants to have this House to deliberate on behalf of one Ukuru Yatani until 25th of December. The Speaker, that is an abuse of parliamentary privileges. In fact, this member should be cited for contempt. But the Speaker, I think he's a good man. He's a good friend of mine. Maybe the budget office, and I have a feeling the budget office maybe prepared this. And if they're listening to me, if I'm listening, they're listening to me. Honorable Mrs. Makau and the team she works with are the best, one of the best departments. I don't want them to mislead members. You know, Mr. Speaker, Honorable Shinali walked in, he saw you a number of times, he had a paper. I was wondering, this is a very good, decent man. Why is he being harassed? Little did I know that he had a document, but I think, Mr. Speaker, if he was here, I think earlier, he was not here earlier when you were reading many communications. The House is going on recess this evening, for record. The Speaker has made a communication. The last committee sitting is on 13th. And it's not only for members. Even our staff must go on holiday. So Yatani can look for another parliament, whether it is the Parliament of Somalia or the Parliament of Djibouti, and he can go and discuss those things. We will only deal with this matter when we come back on 24th.
Yeah, I mean, we Honorable Shinali, we will treat that one. We treat that one as if it never happened. Just because it is not possible. We've already, and we passed the calendar on 10th of February. So Honorable Shinali, whoever gave you the paper is the one who is trying to mislead you. They just accosted you on the gangways and gave you a paper from budget office. I'll tell you this for free. if the House is so minded, it can make any resolution, including resolving to sit. But that is only the House, but not somebody coming to propose some calendar here, because the reason why Parliament has been in constant touch with the National Treasury about this issue of the BPS, it was because we did not want them to interfere with the calendar of the House, which we gave them. And now, sorry, it is never done that way, even. It is never done that way. So just take it back to them. They say RTS, return to sender. We treat it as if it never happened. Leader of Majority.
Thank you, Honorable Speaker. It's closing day, so there are light moments like this are expected. Honorable Speaker, pursuant to the provisions of Standing Order number 44-2A, I rise to give the following statement on behalf of the House Business Committee, which met on Tuesday, the 30th of November, to prioritize the business for consideration. Honorable Speaker, I wish to take this opportunity to thank you, honorable members of this House, as well as your staff, for the sacrifice, active participation, and overall contribution to the improvement of our lawmaking at every stage of the process, representation of our people, and critically exercising our crucial oversight role. I also commend the committee chairpersons for their diligence in leading the committees in concluding a lot of pending business before them. And in retrospect, I believe it has been a wonderful session in which we have achieved change. And we all know that we actually surpassed a threshold we have tried. Now, what more can we aspire to? And I think we deserve to pat ourselves on the back and be proud of the legislative year that has been. Honorable Speaker, as we recollect and appreciate what has been achieved, I wish to point out that the mission of the 12th Parliament is not over yet. We still have a significant number of good legislative proposals, bills, and other statutory instruments that most certainly need our keen attention, including the 25 bills that we have just saved to process between end of January and April. Unfortunately, time and tide waits for no man, and therefore, to complete our mission, every committee. Honorable Speaker, I'm reliably informed there are no questions scheduled to be responded to by Cabinet Secretaries. Obviously, as communicated by yourself, the committees will not be meeting. And in fact, this gives committees the ample time to take this time to expedite their pending business before they also break for the long recess. Honorable Speaker, as we proceed for the long recess later today, it is important to note that in case of any urgent business that requires the attention of this House, members may be recalled for a special sitting pursuant to the provisions of Standing Order number 29. And this special business may well include the passage of the constitutional names that members have been processing, plus anything else that between the Speaker's office and the Leader of Minority we will consider important enough to recall you so that we can process during the break. On behalf of the House Business Committee, and indeed the people of Kibiperi who give me the time to sit here with you every day, I wish you all a Merry Christmas and a happy festive season as you interact with your families, constituents, and other Kenyans. And I look forward to seeing you all as we come back in good health so that we can together face the electorate and hopefully have a bigger turnaround threshold than the traditional one. I now wish to lay this statement on the table of the House.
Order number 16, Committee of the Whole House.
Okay. Order members. Order members, we are now getting to the Committee of the Whole on the Industrial Research and Development Institute Bill, National Assembly Bill number 44 of 2021.
Clause 3.
Clause 3, honorable members, I propose a question that clause 3 be part of the bill. We have an amendment by the honorable chairperson. Who is the honorable chairperson? Who is the chair? Oh, you are the vice chair for the chair. Please, proceed.
Honorable Chairperson, I beg to move that clause 3 of the bill be amended as it appears in today's order paper. The justification is that the clause 3, sorry. The justification for this amendment is that it seeks to establish and outline the purpose of the bill, which is the establishment of the KLD and giving it a mandate.
Honorable members, I propose a question that clause 3 be amended as proposed by the chair. I now put the question that clause 3 be amended as proposed by the chair. Will as many as are of that opinion say aye? Will as many as are of the contrary opinion say nay? The ayes have it. I now put the question that clause 3 as amended be part of the bill. Will as many as are of that opinion say aye? Will as many as are of the contrary opinion say nay? The ayes have it.
Clause 4.
I propose a question that clause 4 be part of the bill. We don't have an amendment to it. I therefore put the question that clause 4 be part of the bill. Will as many as are of that opinion say aye? Will as many as are of the contrary opinion say nay? The ayes have it.
Clause 5.
I propose a question that clause 5 be part of the bill. We have an amendment by the honorable chairperson. Please proceed.
Thank you, Honorable Chairperson. I beg to move that clause 5 of the bill be amended as it appears in today's order paper. The reason is we want to include building materials as part of the research that the Institute will be undertaking. I thank you, Mr.
Honorable members, I propose a question that clause 5 be amended as proposed by the honorable chair. I put the question that clause 5 be amended as proposed by the Honorable Chair? Will as many as are of that opinion say aye? All the members, even the Chair. All the members. All the members, at the very least, the Honorable Chair should be able to vote on her amendment. Did they? I'll carry that again. Honorable members, I now put the question that clause 5 be amended as proposed by the Honorable Chair. Will as many as are of that opinion say aye? Aye. Will as many as are of the contrary opinion say nay? The ayes have it. I now put the question that clause 5, as amended, be part of the bill. Will as many as are of that opinion say aye? Aye. Will as many as are of the contrary opinion say nay? The ayes have it.
Clauses 6 and 7.
I propose a question that clauses 6 and 7 be part of the bill. We have no amendment to those clauses. I therefore put the question that clauses 6 and 7 be part of the bill. Will as many as are of that opinion say aye? Aye. Will as many as are of the contrary opinion say nay? The ayes have it.
Clause 8.
I propose a question that clause 8 be part of the bill. We have an amendment. Honorable Chair.
Thank you, Mr. Chairperson. I beg to move that clause 8 of the bill be amended as it appears in today's order paper. The import of this is to increase government representation in the board, particularly the Office of the Attorney General, so that they can be preferring and offering legal advice. Thank you.
Very well. Honorable members, I propose the question that clause 8 be amended as proposed by the Honorable Chair. I now put the question that clause 8 be amended as proposed by the Honorable Chair. Will as many as are of that opinion say aye? Aye. Will as many as are of the contrary opinion say nay? The ayes have it. I now put the question that clause 8 as amended be part of the bill. Will as many as are of that opinion say aye? Will as many? The ayes have it.
Clause 9.
I propose the question that clause 9 be part of the bill. We have no amendment to it. I therefore put the question that clause 9 be part of the bill. Will as many as are of that opinion say aye? Aye. Will as many as are of the contrary opinion say nay? The ayes have it.
Clause 10.
I propose the question that clause 10 be part of the bill. Honorable Chair, clause 10, you have an amendment.
Yes, thank you, Mr. Chairman. I have a proposed amendment, and I beg to move that clause 10 of the bill be amended as it appears in today's order paper. And the reason is that we want to align the functions of the board with the Mwongozo. Thank you. Mwongozo code, which obviously guides the operations of boards in state corporations. Thank you, Mr. Chairman.
Honorable members, I propose the question that clause 10 be amended as proposed by the Honorable Chair. Yes, Honorable TJ Kajwang.
Mr. Chair, I must confess that I wasn't putting my head to this, but when I heard certain things being mentioned and I happen to be an authority in them, and you know, the gracious lady who is moving these amendments is a person who I hold in very high esteem. But, Mr. Chair, the word Mwongozo has never been defined in law. It has never been defined in law. And so when there are references to it, and to give it some type of activity is in contrast to written law. So would the chair explain how the term Mwongozo would be in tandem with the rest of the books of law?
Honorable Chair, do you want to take a stab? By majority, you speak to it. But Honorable TJ Kajwang says he's an expert in this. Is it on Mwongozo or on law generally?
On delegated legislation and regulatory making.
Very good.
Yeah.
I'm reliably informed you have written a lot. You have written. Anyway, Honorable Majority Leader, then Honorable Chair.
Yeah, Honorable Chair. I'm not sure whether Honorable Kajwang, I think he was a member in the 11th Parliament as well. The Mwongozo Code was a code. It's because it was tabled and accepted as a document of the House. And hence, that's why we keep referring to it. But I see what you're saying, and at some point in future, we will probably need to codify it within law to give it a difference. But was tabled in this House and became a part of the documentation of this House.
Yes, I'll come to you, Honorable TJ Kajwang, but let's have Honorable Sankok.
Chair, I may not be an expert like TJ Kajwang, whom we popularly refer as CJ Bonoko, although he sworn in the Right Honorable Raila Odinga, who is now performing all the duties of that office. So, Honorable Speaker, Chair, Honorable Chair, the Mwongozo Code of Conduct, I have been a chair of a state corporation, and we have been using it because it is part of law.
Honorable Sankok. What is Honorable Sankok? What is out of order, Honorable Wanga? Give her the mic.
Honorable Chair.
Yeah, just wait. You need to be on record. Yes.
Honorable Chair, is the member in uniform in order to refer to Honorable the People's CJ TJ Kajwang as Bonoko. Bonoko, Honorable Chair, actually means a madman. Is the member in order to refer to a fellow member of this House as a madman? Honorable Chair, for us to listen to the member, he has to withdraw that very, very obnoxious statement against the People's CJ. Chair, I find him out of order.
You can't find him out of order, but I may. But Honorable TJ Kajwang seems not to have an issue with that. But
I'm his advocate.
You are his advocate.
Yes.
Honorable Sankok, let's not get there. Let's not get there. Let's be on focus.
President was being sworn in. Where was he?
Was
he in that congregation? So he should not take lightly some of these things that we have worked for this country with pain and blood.
Honorable TJ Kajwang, the issue of swearing in makes it even on another tangent. Honorable Sankok, please let us focus.
Yes, in fact, I just said that he swore in the Right Honorable Raila Odinga.
Honorable Sankok, focus on the bill. Let's deal with the bill. The others, we can deal with it elsewhere.
But all of them were like Nyasukuta. Is it Nyasukuta or Nyasuna? Okay, Honorable Speaker, the issue of the state cooperation, that is the Mwongozo Code of Conduct. When the council or the board hire the CEO according to 10G, then, because a long time ago we used to hire CEOs from the ministry or is the CS, but when we bring it so that the board, according to Mwongozo Code of Conduct, is the one hiring, then the CEO will be more answerable to the board. But when the chair of the board or the directors of the board are answerable to the CS, and also the CEO is answerable to the CS, there is a lot of clash because it's like two centers of power. So I support this amendment.
Anyway, let's hear Honorable TJ Kajwang, then we make progress on this.
Mr. Chair, I asked this to the chair, and the leader of majority rose to explain, but I don't know whether he got the substance. I think he did. That look, Mwongozo Code was brought to this House as a policy paper. And as a policy paper, which therefore was the basis upon which legislation was made. But the word Mwongozo itself must be defined by statute law. So that when you are referring to it in this legislation that we are talking about, you know exactly with certainty what you are talking about. And so it is just a simple thing. It does not even require debate. I do not know why a clear issue such as this should lead us to a debate. The chair should just come to section 2 of his bill, of her bill, and attempt to define, after we have run through the clauses, we will come back to definition section, which is section 2. And in that section, she should define with clarity what Mwongozo literally means. Then anybody reading that legislation will know what this thing is all about. It really, it is all of us who are legislation practitioners will understand that is a common sense in my view. Thank
Okay,
you.
very well, Honorable Chair, I'm sure has taken note, but also you define what is in the bill in the first place. So she has to check whether there is actually a reference to Mwongozo, or she was just speaking and introduced the word Mwongozo in her speaking. But if it is in the bill, maybe you may want to consider that. But anyway, that is up to you with the advice from TJ Kajwang. Honorable members, let's make progress on that. I think I had proposed. I now put the question that clause 10 be amended as proposed by the Honorable Chair. Will as many as are of that opinion say aye? Aye. Will as many as are of the contrary opinion say nay? The ayes have it. I now put the question that clause 10 as amended be part of the bill. Will as many as are of that opinion say aye? Will as many as are of the contrary opinion say nay? The ayes have it.
Clause 11.
I propose the question that clause 11 be part of the bill. We have no amendment to that. I therefore put the question that clause 11 be part of the bill. Will as many as are of that opinion say aye? Order. 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 At the very least, I said the Honorable Chair should be able to vote. At the very least. I'll carry that again, Honorable members. I now put the question that clause 11 be part of the bill. Will as many as are of that opinion say aye? Aye. Will as many as are of the contrary opinion say nay? The ayes have it.
Clause 12.
Okay.
I propose the question that clause 12 be part of the bill. We have an amendment. Honorable Chair.
Thank you, Mr. Chairman. I just also because of clause 10, when I alluded to Mwongozo, it's just like we do benchmarking in other countries. It was just to explain. It was not part of the bill.
Okay.
It was just an explanation.
Yes.
Now moving to clause 12, I beg to move that clause 12 of the bill be amended as it appears in the order paper. And that justification is that a lot of the times we appoint a full board and then we retire them all together. Then we lose the memory of the boards. So we are saying we stagger appointments, we stagger retirements, so that the board memory there is continuous board memory. Thank you. Institutional memory, but also the board memory, because it's good practice. It's good practice.
Anyway, Honorable Chair, don't cross-engage the members before I propose a question.
Thank you, Chairman.
Honorable members, I propose a question that clause 12 be amended as proposed by the Honorable Chair. I put the question that clause 12 be amended as proposed by the Honorable Chair. Will as many as are of that opinion say aye? Aye. Will as many as are of the contrary opinion say nay? The ayes have it. I now put the question that clause 12 as amended be part of the bill. Will as many as are of that opinion say aye? The speaker must hear. The speaker must hear. You see, my eyes got straight to the chair again. The speaker must hear. So I'll put that again. I now put the question that clause 12 as amended be part of the bill. Will as many as are of that opinion say aye?
Aye.
Will as many as are of the contrary opinion say nay? The ayes have it.
Clause 13.
I propose the question that clause 13 be part of the bill. Honorable Chair, you still have an amendment?
Mr. Chairperson, I beg to move that clause 13 of the bill be amended as it appears in today's order paper. Again, the justification is that this is it's a punitive clause where members who are found to have committed offenses are taken action. And we are saying there is need for a fair and independent investigation before any action is taken upon them. So it's actually a good practice when you're introducing a punitive clause in law. Thank you.
Let me propose, Honorable Miri Odhiambo first. I propose a question that clause 13 be amended as proposed by the Honorable Chair. Honorable Miri.
Thank you, Chair. Chair can see the intention of the member, but I'm just fearful that the way it's worded, it is subject to abuse. That where any member is suspected to have committed, should it be suspected or is accused? Because accused is of a slightly higher threshold than is suspected. And at what point do you say a person is suspected? When a person dreams, when a person imagines? Because suspecting is a very fluid term. The Chair, perhaps you would want to consider putting a stronger word like is accused, because accused is a legal term. Suspected is a very fluid term. So perhaps the chair of the committee, because you are the one who can amend at this juncture, and it is your amendment, if you could consider using the word not suspected, where a member is accused of a crime. Because you are setting aside, you are not actually removing. Removal is upon conviction. But suspicion, what is suspicion actually in law? There is no suspicion in law.
Yes, Honorable Chair, I'll give you a chance. And Chair, you still can consult with your team here as we hear from Honorable Member for Seme.
I do not support this basically for the same reason. Accused is too general. It should either be under investigation or on trial for, because those are specific, you know what to do when. But in this case, who is accusing? If a member of one member of the board says he's accused, somebody goes to the press and says, we suspect, is that enough reason? So I think we need better terminology, or just drop it all together.
Honorable Sankok, Honorable Chair, just I'll give you.
In fact, it seems Honorable Dr. Nyikala have stolen from my mouth, because Honorable Millie had come up with something very important, that being suspected is too general. But she have come up with accused. But again, you can be accused by your detractors. And a mere accusation cannot make you to be sent to step aside. So I think what we need is a legal term that is already on trial, so that on conviction, then you will be summarily dismissed. But when they are on trial, they can be step aside, so that they cannot interfere with the investigation. But once the investigation have commenced, but not the issue of accused, not the issue of being suspected, not the issue of being looked upon, because will they be using spiritual eyes to know who is suspected and who is not suspected? All of us are suspects.
Okay. Okay. What is out of order? Then we have the chair. I'm sure the chair has a way out, but Honorable Miri.
For her, Chair.
Yes, Honorable Miri.
Sorry, Chair. I know that the Chair is going to comment. And Chair, you know, because we are trying to do a lot before we go on recess, so you'll excuse us for not being overly vigilant. But Chair, you notice that even when you say vacate office, what is to vacate office legally? Because you are actually saying that a person can actually be removed from office on suspicion. That is actually not proper at all. So even, I do not even mention the one of vacating office, so it should be, I would urge the Chair strongly to either drop this amendment or reward it, or then if that's not possible, we just oppose it so that it drops.
Honorable Chair, you still, Honorable Chair, depending on what you say, but I just wanted to give you guidance. There is nothing that stops you from further amending
I agree,
and
Mr. Chairman.
replacing.
And I want to move a further amendment on that clause, and I say this bill belongs to this House, so the comments are well taken. And so I move a further amendment so that the word suspected, we actually take it, we replace it with accused, because actually suspected is extremely broad. And so that then becomes much more focused. And then on the other vacate office, I agree, we should use the word step aside to allow for investigation. Or step aside may be a better word, or suspend to allow for investigation. So we are going to amend that as well.
Very good. But now that you are on record, I'm sure the cleanup will happen. Honorable members, in the circumstances and in light of what the chair has said, I will now put the question that clause 13 be amended as proposed by the honorable chair. With as many as are of that opinion say aye. With as many as are of the contrary opinion say nay. There is have it. I now put the question that clause 13 as amended be part of the bill. With as many as are of that opinion say aye. With as many as are of the contrary opinion say nay. There is have it.
Clauses 14, 15, 16, 17, 18, and 19.
Honorable members, I propose a question that clause 14, 15, 16, 17, 18, and 19 be part of the bill. We have no amendment to those clauses. I therefore put a question that clause 14, 15, 16, 17, 18, and 19 be part of the bill. Will as many as are of that opinion say aye? Will as many as are of the contrary opinion say nay? The ayes have it.
Clause 20.
I propose a question that clause 20 be part of the bill. We have an amendment. Honorable Chair.
Mr. Chairperson, I beg to move that clause 20 of the bill be amended as it appears in today's order paper. And you know, this is to allow that the DG, the gazettement of the DG, once it's recommended by the board to the respective cabinet secretary, then the gazette may be done by the respective cabinet secretary, not the board. The reason also is for separations. Because once the board has recruited and has interviewed, and I'm talking this from practice, you know, I've come from that area, then it is allowed that then the 3 names that are recommended to the cabinet secretary then now appoints and gazettes.
Very well, honorable members, I propose a question that clause 20 be amended as proposed by the honorable chair. I now, what? Yes, honorable Sankok. I'll give Sankok and then we make progress.
Yes, no, we had said that for separation of power, they should be the CEO should be appointed by the board. Now again, we are giving 3 names to the cabinet secretary to select one so that he can appoint one or she can appoint one. It is again renegating from what we had earlier said and from Mwongozo. So it is either the board gazette and give a letter, or then let the minister recruit. So I oppose this amendment. I oppose them, and it's wrong.
Honorable Miri.
Thank you, Chair. Chair, actually, what I notice is what the chair is actually moving, not moving, but what the chair said is very good, but it is not what is in the proposed amendment. Because the proposed amendment does not even provide any role for the board at all. Because then, according to the proposed amendment, it shall be, there shall be a Director General of the Institute who shall be competitively recruited and appointed by the Cabinet Secretary. So actually what you are saying, which you say conforms to Mwongozo standards, is not what you are doing. You are giving the sole responsibility to the Cabinet Secretary, and that's why I was actually asking why, so that if there's a reason why, for instance, you want the power to inhere in the Cabinet Secretary alone, that's okay, but at least we need to have some good reason for that.
Yes, Member for Seme.
I oppose this amendment. You know, we cannot institute boards, put them in place, then masculate them. It is actually not necessary, because you have a board, and now basically the cabinet secretary is the one that is appointing the CEO of the board. Now who then is the Director General answerable to? If there is a question, who does? So I think we should drop this.
Other members, Honorable Chair, it's good for you to read the clause actually. And the members, the bill, the clause read, there shall be a Director General of the Institute who shall be competitively recruited and appointed by the board. So the amendment is replacing the board with the Cabinet Secretary. So Honorable Chair, you have another chance. What do you have to say?
No, not dropping. I think we can just cancel the appointment and say the gazettement, because I know that separation works it's very important. No, but the in practice, but we can drop it. We can drop it, it will not alter the...
Okay. So, honorable members, that amendment is dropped. I therefore put the question that clause 20 be part of the bill. Will as many as are of that opinion say aye? Aye. Will as many as are of the contrary opinion say nay? Ayes have it.
Clause 21.
I propose a question that clause 21 be part of the bill. We have an amendment. Honorable Chair, clause 21.
Thank you, Mr. Chairman. I beg to move that clause 21 of the bill be amended as it appears in today's order paper. And again, is to give experience to the person appointed to the office of the DG. Given that this is a research institute, it requires somebody of greater experience. That's the import of that proposed amendment. Thank you, Mr. Chairman.
Honorable members, I propose a question that clause 21 be amended as proposed by the Honorable Chair. I now put a question that clause 21 be amended as proposed by the Honorable Chair. Will as many as are of that opinion say aye? Will as many as are of the contrary opinion say nay? The ayes have it. I now put the question that clause 21 as amended be part of the bill. Will as many as are of that opinion say aye? Will as many as are of the contrary opinion say nay? The ayes have it.
Clause 22.
I propose the question that clause 22 be part of the bill. Honorable Chair, you have an amendment?
Yes, Mr. Chairman, I propose and I beg to move that clause 22 of the bill be amended as it appears in today's order paper. Again, is additional functions of the Director General to ensure proper dispensation of services of the Institute and the prescriptive functions that have been provided in the bill removed so that it can be contained in the Director General's letters of employment. The final amendment is seeking to correct the typo appearing in paragraph G.
Honorable members, I propose a question that clause 22 be amended as proposed by the Honorable Chair. I put the question that clause 22 be amended as proposed by the Honorable Chair. Will as many as are of that opinion say aye? Will as many as are of the contrary opinion say nay? The ayes have it. I now put the question that clause 22 as amended be part of the bill. Will as many as are of that opinion say aye?
Aye.
Will as many as are of the contrary opinion say nay? The ayes have it.
Clause 23.
I propose the question that clause 23 be part of the bill. Honorable Chair, you have an amendment?
Thank you, Mr. Chairman. I beg to move that clause 23 of the bill be amended as it appears in today's order paper. Again, the justification, we have been having CEOs appointed for 3 years. Before they even do a strategic plan, they are making their way out. So we decided it's better for an institute of research to propose the 5 years as opposed to 3. Thank you.
Honorable members, I propose a question that clause 23 be amended as proposed by the Honorable Chair. Yes, Honorable Odhiambo.
Chair, I can see the chair very worried. She thinks I'm going to oppose. I think this is a very good amendment because when the practice has actually been doing this 3 years, and by the time you reach a CEO, getting another job is very difficult. So it's actually almost putting people at a dead end career-wise. So if you do 5 + 5, 10 years, at least somebody will already have organized their lives. So I support.
Honorable members, I put the question that clause 23 be amended as proposed by the Honorable Chair. Will as many as are of that opinion say aye? Will as many as are of the contrary opinion say nay? The ayes have it. I now put the question that clause 23 as amended be part of the bill. Will as many as are of that opinion say aye? Will as many as are of the contrary opinion say nay? The ayes have it.
Clause 24.
I propose the question that clause 24 be part of the bill. We have no amendment to that. I therefore put the question that clause 24 be part of the bill. Will as many as are of that opinion say aye? Will as many as are of the contrary opinion say nay? The ayes have it.
Clause 25.
I propose the question that clause 25 be part of the bill. Honorable Chair, you have an amendment.
Thank you, Mr. Chairman. I beg to move that clause 25 of the bill be amended as it appears in today's order paper. And again, is to give the independence of the board in appointment and giving them the exclusive powers to appoint the corporation secretary, who will be their legal advisor.
No, you're dealing with clause 25.
Oh, sorry.
It's about remuneration, salaries and remuneration commission and the board.
Oh. Sorry. I think I've mixed up my notes. Oh, yeah. The clause is seeking to actually to remove the board may on advice of the remuneration. We want to give the board independence, so we are removing such terms and simply substituting thereof with the words as the board may determine. So we are giving the board again the independence to make those decisions on the salaries.
But it's on SRC.
Yeah.
SRC.
Are you done with the moving? I need to propose it. Yeah?
The leader of majority is advising we can remove it, and I have no objection to that. Because it contradicts the law of the SRC.
You don't need to be advised by leader. You are convinced.
I am convinced.
Very good.
Yeah, I'm dropping it.
Honorable members, the amendment is dropped. I therefore put the question that clause 25 be part of the bill. Will as many as are of that opinion say aye? Will as many as are of the contrary opinion say nay? The ayes have it.
Clause 26.
I propose a question that clause 26 be part of the bill. Honorable Chair, clause 26.
Honorable Chairperson, I beg to move that clause 26 of the bill be amended as it appears in today's order paper. Again, this is to create clarity on the qualifications of the office of the Corporation Secretary, which is law, which is a legal requirement.
Honorable members, I propose a question that clause 26 be amended as proposed by the Honorable Chair. Yes, Honorable Sankok.
This is according to Mwongozo, and this one is very normal, that in a state corporation, the corporation secretary should be a legal mind, should be a lawyer, because they act as a corporation secretary and as well as a legal advisor to the corporate, because the board will be making policies and law, and it is just imperative that the secretary have a background in law. So we support that one, and I think you can put the question. We support it.
No, you can't put before Honorable Ngeno has spoken. Honorable Ngeno, you want to speak on this? Yes, proceed. Give a...
I'm lost.
Yeah, you are on.
Thank you, Speaker. I support only that maybe, Speaker, you know, when you talk about relevant, Mr. Speaker, Chairman, should have been at least specific. Oh, and putting the law.
It's an amendment now.
Good.
It's an amendment now.
Guided, well-guided, Speaker.
Okay, very well. Honorable members, I put the question that clause 26 be amended as proposed by the Honorable Chair. Will as many as are of that opinion say aye? Will as many as are of the contrary opinion say nay? The ayes have it. I now put the question that clause 26, as amended, be part of the bill. Will as many as are of that opinion say aye? Will as many as are of the contrary opinion say nay? The ayes have it.
Clause 27.
I propose the question that clause 27 be part of the bill. Order, Honorable Duarte. You must give space to the chair to move the amendment.
Yeah.
Or you are advising her
Thanks.
and supporting her. That's good. Honorable Chair, now you have the space.
Honorable Chairperson, I beg to move clause 27 of the bill to be amended as it appears in today's order paper. And this has been a very, and the only issue, and that's what my colleague was saying, is the issue of reporting of the Corporation Secretary directly to the board, but functionally to the Director General. Yeah, that's what we are saying that the Corporation Secretary will be reporting, Mr. Chairman, to the board. Reporting to the board because it's an advisor of the board, but functionally because on the day-to-day running of the organization, the chief executive is the Director General.
Yes, what is out of order, Honorable Odhiambo?
Chair, I think the chair is a little confused, and she's confusing the House. She's talking about functionalities and about the law. But what she's actually amending makes it not just functional, but legal. Because you are saying the Corporation Secretary shall be responsible to the DG. That therefore makes it legal. That the Corporation Secretary, it will not just be functional, it will be legal. And the Corporation Secretary shall not then be answerable to anybody other than the DG. So if that is your intention, that they be answerable to the DG, then that's okay for order. But if your intention is for them to be functionally responsible to the DG, but legally to the board, then it is the board you should put here and also then maybe say functionally responsible. But what you are saying is actually different from what you are proposing. You are proposing a legal responsibility directly to the DG. So be clear about what you want. Personally, I'll support you with either because you are experienced in this sector and you know what works, So tell us what you want, but what you are saying is not what is in the amendment.
Honorable Miri, maybe she's not confused, but not as clear as she ought to be. Honorable Chair, do you want to be as clear to Honorable Miri Odhiambo to the House?
Yes, Mr.
On your
Mr.
intent of
Chairman,
amendment of clause 27?
Yeah, the intention of this proposed amendment is to bring clarity, because the Office of the Corporation Secretary is supposed to be answerable to the board in terms of advising on legal issues. And the Corporation Secretary should be an independent advisor to the board. But functionally...
No, you have to move. I will propose, I will give members a chance to...
Okay, I thought you had asked me to clarify why I'm proposing
Yes,
the amendment.
proceed as you move, because I will open it up for the members to engage. You know, Honorable Chair, Honorable Chair, don't listen a lot to directly to Honorable Miri, so that then you're able to move, finish, and then I will propose a question and members will... Honorable Chair, you have the floor.
Myself, the board, the members can vote either way, but for me, what I think is the correct thing is what is being proposed here, that the Corporation Secretary is answerable to the board, because he's an advisor.
Honorable Chair, Honorable Chair. I told you don't look at don't listen to Honorable Miri Odhiambo.
Okay.
Just move.
Okay.
So, you know, you are halfway listening to Honorable Miri. Please.
Stop shouting.
Don't even listen to Honorable Sankok.
Miss,
Honorable Chair, you don't be distracted by any member.
This
Just
work
move.
is for this country, so I think we need to do it together. Yeah, and Mr. Chairman, we can go and look at it. If we need to bring it back to the House, we'll do it. I can drop it for now.
So, is it dropped?
Yes.
Okay. Honorable members, that is dropped. I now put the question that clause 27 be part of the bill. Will as many as are of that opinion say aye? Aye. Will as many as are of the contrary opinion say nay? Nay. The ayes have it.
Clauses 28 and 29.
Honorable members, I propose a question that clause 28 and 29 be part of the bill. We have no amendments to that. I therefore put the question that clause 28 and 29 be part of the bill. Will as many as are of that opinion say aye? Will as many as are of the contrary opinion say nay? The ayes have it.
Clause 30.
I propose a question that clause 30 be part of the bill. Honorable Chair, you have an amendment to clause 30.
Mr. Chairman, I beg to move that clause 30 of the bill be amended as it appears in today's order paper. And this is on release of information by the Institute. And we are saying that this amendment is therefore necessary for clarity to allow release of information in line with the requirement of the law in terms of the Communication and the Information Act, given that some of it will be proprietary information. I beg to move.
Honorable members, I propose a question that clause 30 be amended as proposed by the Honorable Chair. I now put a question that clause 30 be amended as proposed by the Honorable Chair. Will as many as are of that opinion say aye? Will as many as are of the contrary opinion say nay? The ayes have it. I now put the question that clause 30 as amended be part of the bill. Will as many as are of that opinion say aye? Will as many as are of the contrary opinion say nay? The ayes have it.
Clause 31.
I propose the question that clause 31 be part of the bill. Honorable Chair, you have an amendment?
Yes, Miss. Is it 31 or 30?
That one. We have just done 30.
Yeah,
we are now at that one.
Honorable Chairperson, I beg to move that clause 31 be made part of the bill, be amended to be part of, as appears in the order paper. And the object is to give timeline to the Cabinet Secretary to...
No, Honorable Chair, it is clause 31.
Sorry.
It's about Parliament and National Assembly.
I think there was a typo error. They put it as 30. I'm not used to so much noise, Mr. Chairman.
Honorable members, let's give Honorable Chair the space to move.
Yes,
Honorable Miri, you are not helping her. Give her the space.
And the law is to help this country and not an individual or a committee. So, Mr. Chairman, I think what we are in clause 31 is we are clarifying to give the National Assembly the powers that is vested on it to allocate and appropriate funds, and not Parliament, because Parliament includes Senate. That's the clarity we are seeking to beg.
Okay, that's straightforward. Honorable members, I propose a question that clause 31 be amended as proposed by the Honorable Chair. I now put the question that clause 31 be amended as proposed by the Honorable Chair. Will as many as are of that opinion say aye?
Aye.
Will as many as are of the contrary opinion say nay? The ayes have it. I now put the question that clause 31 as amended be part of the bill. Will as many as are of that opinion say aye? Aye. Will as many as are of the contrary opinion say nay? The ayes have it.
Clauses 32, 33, 34, 35, 36, and 37.
Honorable members, I propose a question that clauses 32, 33, 34, 35, 36, and 37 be part of the bill. We have no amendment to that. I therefore put the question that clauses 32, 33, 34, 35, 36, and 37 be part of the bill. Will as many as are of that opinion say aye? Aye. Will as many as are of the contrary opinion say nay? The ayes have it.
Clause 38.
I propose the question that clause 38 be part of the bill. Honorable Chair.
Thank you, Mr. Chairman. I beg to move that clause 38 of the bill be amended as it appears in today's order paper. And the justification is to give the Cabinet Secretary the right to make rules that will operationalize this act, and we are giving him a 6-month timeline. Thank you, Mr. Chairman.
Honorable members, I propose the question that clause 38 be amended as proposed by the Honorable Chair. I now put the question that clause 38 be amended as proposed by the Honorable Chair. Will as many as are of that opinion say aye? Aye. Will as many as are of the contrary opinion say nay? The ayes have it. I now put the question that clause 38 as amended be part of the bill. Will as many as are of that opinion say aye? Aye. Will as many as are of the contrary opinion say nay? The ayes have it.
Clause 39.
Honorable members, I propose the question that clause 39 be part of the bill. You are proposing a deletion, Honorable Chair.
Yes, I beg to move that clause 39 of the bill be amended as it appears in today's order paper. And we are amending that the clause that 39 be deleted because it's being captured in the interpretation of terms, which is captured in clause 2. Clause 2.
Honorable members, I now put the question that clause. Honorable members, I propose a question that clause 39 be deleted as proposed by the Honorable Chair. Honorable Miri.
Chair, even as members are in a hurry, I just wanted clarity from the chair because this is a transitional provision. And sometimes when we are in a hurry, we make such grave mistakes that make us look like we are not serious as a house. Can we just have clarity because you are seeking actually to remove a transitional clause? What then happens?
Yes, Honorable Duare.
Just clarity. I just need clarity.
Honorable Duare.
I'm sure that is provided for maybe in the act, so the vice chair can tell us. I'm sure the committee cannot delete that, so there must be a provision somewhere else within the main act. No, it is there. Wait. This is a transitional clause. I don't think a committee of this House can.
Mr. Chairman, this is a new bill. It's not that we are amending.
No, there's a parent act.
Sorry.
Yes, Honorable Chair, proceed, please.
Yeah, I was trying to explain that this is really a new bill, and so the issues that Honorable Millie is referring to is like the appointed day, which operationalizes the act, and the former institute. And you see, there was no act on the creation of this institute before. So this is an initial law. So that is why then that becomes unnecessary.
So the amendment is superfluous.
Yeah.
Okay, honorable members, I now put the question that clause 39 be deleted as proposed by the Honorable Chair. Will as many as are of that opinion say aye? Aye. Will as many as are of the contrary opinion say nay? The ayes have it.
Clause 40.
Honorable members, I propose a question that clause 40 be a part of the bill. Honorable Chair.
Yeah.
Do you have an amendment to that clause, Honorable Chair?
Not on 40, on 41.
Okay, I think my notes are not as clear, but actually there is no amendment to that. Honorable members, I now put the question that clause 40 be part of the bill. Will as many as of that opinion say aye? Will as many as of the contrary opinion say nay? The ayes have it.
Clause 41.
I propose a question that clause 41 be part of the bill. That one you have an amendment.
Honorable Chairperson, I beg. I
Honorable
seek your protection.
Honorable Miri, let the mover.
Yeah.
And you can tell your effect to the chair.
Yeah.
So let the chair finish.
Thank you, Mr. Chairman. Honorable Chairperson, I beg to move that clause 41 of the bill be amended as it appears in today's order paper. Again, the justification is very clear, is that the Constitution now provides for when the law becomes operational upon assent by the President.
Honorable members, I propose a question that clause 41 be amended as proposed by the Honorable Chair. Honorable Miri.
Thank you, Chair. Chair, I know members appear to be very eager to deal with the proceeds of crime and anti-money laundering amendment bill. I think they want to make sure that they stop money laundering. That's why they are very keen and they want us to move. But yeah, we make very grave mistakes when we move on a bill with that kind of speed. Chair, if you actually look at the amendment that the chair of the committee is proposing in 41, which is on the appointed day, that is okay. But when I connect it with what I was saying before, which is in relation to the deletion of 39, which deleted appointed day in A and deleted B, former institute. Yet the chair has not proposed any amendment in 42, which talks about any person who was a member of the former institute. I'm sure when the chair sits down later, she will understand what I'm talking about. So you are making reference in 42 that you are not amending. You are only amending a portion of 39. Yeah, we've deleted 39, and 39 is in two parts, A and B. And we are doing a further amendment now in this current amendment by speaking to the deletion we did in 39A. But the one in 39B should also have ensured that we deleted 42, which is not done, because we are now making reference to a former institute, but we've deleted the definition of that. So I'm urging members, let us not be in such a hurry, and then we make mistakes that look like, will make us look not serious in this house. I can see the majority leader knocking his head, but if you actually read 42, it says any person who was a member of the former institute, but we've deleted the definition of former institute.
Yes, majority leader.
Indeed, Honorable Millie is right to highlight some of these things. But what we actually did in 39 is, if you look at the bill, clause 39 had two clauses defining former institute and also defining appointed day. Now, what has happened, the former institute is now defined within clause 2. And the amendment that will be coming to clause 2 now defines within clause 2, where the other definitions are, what the former institute means. Then, obviously, appointed day is now being changed to upon commencement of the act. Okay? So the issue is the two issues that were in 39. One is transferred to clause 2, where definitions are. Then the other one, Then the other one, within 41, is being changed to what it is. So I think we are all together now. Thank you. Yeah.
Let's not block member for seven briefly, so that we make progress.
Chair, mine is not about the 42, but it is the explanation here. Whereas I support that everywhere you will remove the appointed day and say upon commencement, and perhaps correctly said that now it is defined in the Constitution when it's ascended to by the President. I just want that clarification because we know many laws that have been actually ascended to by the President and are actually not implemented. Like the Health Act 2017. So can I just be educated on that so that I know that we are actually okay? Because we can have a law and then eventually it stays in the shelves and never gets implemented.
The appointed date and the commencement date, Honorable Majority Leader, then we make progress on this.
Now, just for clarity, I think the responsibility of this House is to enact the bill, and then it's transmitted to the executive or to the head of state to assent to the law. Once the law has been assented, it's now the responsibility of the executive to implement. It has left this House. If it's not implemented, we have within our oversight role, as for example, the Trade Committee could then summon the minister to ask why certain clauses have not been implemented. So, but in terms of our role as a House, is we legislate, it then goes to His Excellency the President, he assents to it, and it has left Parliament. Then our oversight role then comes in. So upon commencement of the act is when it's accepted, imetuondokea.
Anyway, honorable members, I now put the question that clause 41 be amended as proposed by the honorable chair. Will as many as of that opinion say aye? Will as many as of the contrary opinion say nay? The ayes have it. I now put the question that clause 41 as amended be part of the bill. Will as many as of that opinion say aye? Will as many as of the contrary opinion say nay? The ayes have it.
Clauses 42 and 43.
I propose the question that clauses 42 and 43 be part of the bill. No amendment. I therefore put the question that clauses 42 and 43 be part of the bill. Will as many as of that opinion say aye? Will as many as of the contrary opinion say nay? The ayes have it.
New clause 4A.
Honorable members, we have new clause 4A. Honorable Chair, if you may move for the second reading of new clause 4A.
Mr. Chairperson, I beg to move that the new clause 4A be read a second time. The reason for this, Mr. Chairperson, is to give the objects, to have a clause that gives the objects or the mandate of the institute. And I just want to clarify, this is a new law establishing the institute. That's why we removed some of the clauses like were in 39 that were creating confusion. Yeah. Thank you.
Honorable members, I propose a question that new clause 4A be now read a second time. I put the question that new clause 4A be now read a second time. Will as many as of that opinion say aye? Aye. Will as many as of the contrary opinion say nay? The ayes have it. I propose the question that new clause 4A be part of the bill. I put the question that new clause 4A be part of the bill. Will as many as of that opinion say aye? Aye. Will as many as of the contrary opinion say nay? The ayes have it.
Schedule.
Honorable members, we have no amendment to that. I therefore put the question. I propose the question that the schedule be the schedule of the bill. There are no amendment to it. I therefore put the question that the schedule be the schedule of the bill. Will as many as of that opinion say aye? Aye. Will as many as of the contrary opinion say nay? The ayes have it.
Clause 2.
I propose the question that clause 2 be part of the bill. Honorable Chair, you have an amendment.
Thank you, Mr. Chairperson. I beg to move that clause 2 of the bill be amended as it appears in today's order paper.
Yes. Well, it is a point of order. Really, it's not a. What is out of order? Who has raised? Is it Honorable Wanga?
Chair, you do notice that in clause 2 we are raising very, very many amendments in terms of definitions.
What is is a point of order, right?
Yes, yes.
Yes, please proceed, Honorable.
Yes, that's what I'm actually proceeding with. Yep. And Chair, if you actually at the committee of the whole house and we decide to do corporate amendments, Chair, that is actually not in order because they are very singular amendments. I would propose, Chair, that procedurally that we go by singular definitions so that we have defined former institute. If we have an issue we raise, incubation, indigenous knowledge, innovation, because I may not have an issue with the former institute, but perhaps I have with incubation. So how we have actually moved before is by definition, Chair. So I seek your guidance, but I think that would be the proper order to go, Chair. I am supporting you to stop being a heckler.
Honorable members, it is Honorable Miri Odhiambo, that you are right to ask for that. All it does is to ensure that the chair actually moves one definition after the other. There are quite a number of them, but that's why we're here, isn't it? Yes, the clerk will read them, and then she will put the import, and then we will put the question. It just takes a bit of time, but look. There are several definitions. You know, like there is a former institute, there is incubation, there is indigenous knowledge. They are in the order paper. They are in the order paper. What is it, Honorable Sankok? Let's hear from Honorable Sankok.
That is why we are normally given the order paper in advance, so that we will be able to go through, see where we have a problem, and then you can raise it, but the question is put together, unless then Honorable Millie have a problem with this. And we had this order paper since yesterday, so I think we have already gone through, and some of us are faster than others. We have already read it, and we cannot continue going one by one, because it is, as it is organized in the order paper, it is not one by one, it is close to, and all the amendment follows. And then we do it together. And Honorable Millie, you are the professional heckler, not me. Everybody knows.
Order, Honorable Sankok. Order, Honorable Sankok. We have to keep the lane. Let's hear Honorable Duare will hear Honorable.
Chair, I think what Honorable Millie is saying.
What is it, Honorable? Just Honorable Duare. What is it, Honorable Anga?
You know, Honorable Chair, there are things Honorable Sankok keeps saying on record, and they are unacceptable. And even when I raised this earlier, you did not ask him to withdraw. For example, he refers to Honorable Millie as a professional heckler. And no, she was not on record. She was not on record. So Honorable Sankok stands and says things in jest and refers to people as clowns, as bonocos, as hecklers, and he's on record. And this is a house of record. Our children our grandchildren, people will be in this house, and they will go to those records and see those things. It is unacceptable. It cannot be let to pass. Honorable Sankok must grow up and take responsibility for the things he says on the floor of this house.
Order, honorable members, you know, let's you know, we are dealing with a bill here. Honorable Miri may have said something that is not on record. Honorable Sankok responds on record. Please, members, let us keep the rein. Honorable Sankok, you remember this was raised again earlier. Let us keep the rein. Honorable Sankok.
Apologize.
So then,
I withdraw and apologize to Honorable Millie Odhiambo. What is that?
Let us proceed.
Yes, I'm very sorry. I withdraw.
Let us proceed.
And this.
Members, we had Honorable Duare. I'll give direction on how we deal with clause 2 in a minute. Honorable Duare.
Chair, outside what is going on, the shenanigans. I think I agree with the Honorable Millie, but I think to save on time, there are about 5 definitions. Former institute, innovations. No, let me finish.
Let Honorable Duare.
Invention, intellectual property, secretary, and I think technology. I think the vice chair can move all of them together, and then when you give members to contribute, Honorable Millie can say the one particular one where she wants further explanation, so that we deal with it as one. And I think this has been happening, Chair, before, to save on time. Because it's only Honorable Millie, then you give her a chance, the one that she really wants to be expounded.
Well,
yes.
let's. I'll give one up member for 7. I'll give direction after that, so that
Chair.
we make progress really.
Chair,
on
I
this
want support
procedural issue.
Chair, I want to support Honorable Millie's position. The whole of this bill is actually based on clause 2. When you talk of patent, when you talk of intellectual property rights, when you talk of innovations, we are going to interact with the whole world. And if we don't get that right, I remember I was in a meeting in Geneva one time where a definition actually took 24 hours. So these definitions have such serious meaning that I think we should go one by one and agree on them.
Other members, Honorable Mwadi, then really this is a small procedural issue that I will give direction.
Yeah, it's small, but I think, thank you, the Honorable Chair. I think you were saying it's a small issue, as small as it is. But we've been here with
It is a small in the sense that I will give direction,
Yeah,
but it's fundamental in the sense that it has been raised by the members.
We've been here doing this before. It's not the first time. And what we have done before is consider clause by clause. There are even other provisions in some clauses here which were so many more than this, but it was read as a clause. Let those people who have issues where they want explanation come out and ask for it. Otherwise, we'll be treating this as a very special case, which we have not been doing before. Honorable Chair.
Well, honorable members, in certain situations that I have actually been the chair, in certain situations we have had specific definitions. In many other instances, we have put it together as it is today. What I propose, and it is a good suggestion by Honorable Miri Odhiambo, even moving forward, it may be helpful to sort of put them item by item, moving forward, not on this, so that then members have an opportunity to speak to each amendment. But for now, because it is actually not 3 definitions, there are actually more, because even on innovation, and even on the next page on number 121, there are quite a number of other definitions. So what I suggest, what I direct is that the Honorable Chair move it as in totality. I'll give Honorable Miri a specific opportunity to speak to whichever, and probably even convince the chair to in her direction. But Honorable Miri, that suggestion is actually taken. Honorable Chair.
Thank you, Mr. Chairman. I beg to move that clause 2 of the bill be amended as it appears in today's order paper. And as of course we are justifying by saying that these are technical terms and some of them are used in context, so they need to be properly explained so that they, for clarity when they are used in law, so as they interact with the users in the industry. But I also wanted to say that innovation has been defined twice, and I was proposing that the innovation that is appearing directly above intellectual property and invention and intellectual property, the one that is just appearing immediately above the intellectual property definition, be deleted. Thank you, Mr. Chairman.
Honorable members, I propose a question that clause 2 be amended as proposed by the Honorable Chair. Honorable Miri, you have a singular opportunity to speak to this.
Yes, thank you, Chair. Chair, just for records, I want to indicate, because I'm always in this stage, and many times, including in my own bill, we have gone definition by definition. And the reason is just by even what the chair herself has done. She's dropped one. Secondly, there are some definitions here I don't agree with, but I agree with all. So then it means that if you put it as a global, I may be forced to vote no when I actually support all of it. So I think this is actually, we are suffering the effect of money laundering, Chair. But given be that as it may, let me just go to the issues that are of concern to me. Number 1, Chair, because I have concerns over various issues. Number 1, in the issue of former institute, the chair had indicated to us that legally the Kenya Industrial Research Development Institute did not exist.
It existed, but not by law.
No, Honorable Miri, please proceed. Do not be distracted. Now, the distraction earlier came from the other direction. Seems to have...
Chair, they are balancing, so I'm allowing them to balance. So, Chair, the former institute, because it didn't actually exist by law. So when we're actually making reference to what didn't exist by law, it's a bit strange, legally speaking. Secondly, Chair, when you talk about indigenous knowledge usually in here, in our, not forefathers, but our fathers in communities. So a definition of indigenous knowledge should actually have incorporated that. For example, if you are talking about indigenous knowledge on, for instance, beneficial properties of certain plants which you get in research, it is not actually, when you talk about wisdom does not capture actually the concept. Another issue, Chair, when you talk about invention, innovation, intellectual property, and patent, and even technology, Chair, those are terminologies that are already defined under the Industrial Property Act. So normally the way you define is by making reference to the Act, so that you don't create differing definitions by a new law. So if Industrial Property Act already defines all these definitions, Chair, what we are likely to do is to come with conflicting definitions that are going to create problems when we are implementing the law. Because when you make this and somebody, because there are some times when the laws are actually operating concurrently, which they are likely to, because the components of these acts are likely to come into contact with the Industrial Property Act. So, Chair, when you have differing definitions without making reference to an existing law with similar terminology, Chair, it creates a problem. And Chair, because of that, I will leave it at that, but I think in future you understand what I'm saying. I may not have an issue with, for instance, the definition of secretary. I may not have an issue with the deleting cabinet secretary. But then I would have wished that if we went by one, I would have requested the chair to then make reference as defined under the Industrial Property Act, instead of coming like we are coming with the new definitions, Chair. So because of that, it makes it difficult for me to even vote. Thank you.
Honorable members.
And I would want to encourage my good friend, Honorable Sankok. I think he took a lot of chocolate today. So he has a sugar rush.
Let's not get there, because now you are on record, he is not on record, and you will get through the same situation. Honorable members, I now put the question that clause. Honorable member for Seme, you have a minute. You have a minute.
For example, on indigenous knowledge, what the definitions we have here assumes what we know on the environment. It does not take into consideration what we do. For example, in the Kisi, there are people who actually do brain surgery, and that is indigenous knowledge. Now, if you look here, it would then even include practice. So I would then say, and practice. Now, when you then come to secretary, cabinet secretary, you are saying industry and leaving out research. Now, in fact, it would be important because sometimes you may have ministers. One minister may be responsible for industry, another minister may be responsible for research.
Very well.
Now, where will then this thing lie? So,
very well.
What about research?
Please.
Okay, so in my view, I don't see why we are leaving out research and just taking industry.
Very well. Honorable members, I will put the question on this. I now put the question that clause 2 be amended as proposed by the Honorable Chair. Will as many as of that opinion say aye? Will as many as of the contrary opinion say nay? The ayes have it. I now put the question that clause 2, as amended, be part of the bill. Will as many as are of that opinion say aye? Will as many as are of the contrary opinion say nay? The ayes have it. Mike.
Title.
Honorable members, I propose the question that the title be the title of the bill. We have no amendment to that. I therefore put the question that the title be the title of the bill. Will as many as are of that opinion say aye? Will as many as are of the contrary opinion say nay? The ayes have it.
Clause 1.
Honorable members, I propose the question that clause 1 be part of the bill. We have no amendment to it. I therefore put the question that clause 1 be part of the bill. Will as many as are of that opinion say aye? Will as many as are of the contrary opinion say nay? The ayes have it. Honorable members, the mover.
Honorable Chairperson, I beg to move that the committee do report to the House its consideration of the Kenya Industrial Research and Development Institute Bill, National Assembly Bill number 44 of 2020, and its approval thereof with amendments.
Honorable members, I put the question which is that the committee do report to the House its consideration of the Kenya Industrial Research and Development Institute Bill, National Assembly Bill number 44 of 2020, and its approval thereof with amendments. Will as many as are of that opinion say aye? Will as many as are of the contrary opinion say nay? The ayes have it.
Honorable members, Mr. Speaker.
The chairperson.
Honorable Speaker, I beg to report that the Committee of the Whole House has considered the Kenya Industrial Research and Development Institute Bill, National Assembly Bill number 44 of 2020, and approved the same with amendments.
The mover.
Honorable Speaker, I beg to move that the House do agree with the committee in the said report. I also would request the Honorable Duarte to second the motion for agreement with the report of the Committee of the Whole House.
Honorable Duarte.
There is a member of the committee, so I'll then invite the Honorable Vice Chair of the committee to second the motion of agreement with the report of the committee.
The Honorable Vice Chair.
Thank you, Honorable Speaker. I beg to second.
Honorable members, order. Order, members. I propose the question, which is that the House do agree with the committee in the said report. The Honorable Sangok, I will not grant your wish at this time. I will direct that action will be undertaken when this particular business will be set down on the order paper again. I therefore direct that we move on to the next business.
Order number 17, the Proceeds of Crime and Anti-Money Laundering Amendment Bill, National Assembly Bill number 39 of 2021, second reading.
The Honorable George Murugara, what is out of order?
Thank you, Mr. Speaker. Mr. Speaker, allow me, before the second reading of this particular bill, allow me to raise several pertinent issues which, in my view, go to the substratum of the bill itself. Mr. Speaker, sir, the chair, the speaker, has ruled on several occasions that this House cannot debate and deal with a bill that is unconstitutional. All laws that we pass, in the estimation of this court, of this House, have to be within the parameters of the Constitution. We risk at all times.
So the Honorable Mulugara, before you proceed,
yes,
I understand you to be rising on a point of order to raise a constitutional issue, yes, in regard to the business that we want to consider.
Yes.
All right, proceed.
Yes.
That you may do at any time.
Yes. The risk involved is that if we proceed to debate on a bill that is unconstitutional, we risk having laws that are made by this House struck out, declared null and void by the courts. We cannot lead ourselves into this. Mr. Speaker, may I rise under standing order number 1 so that I ask from the Speaker's chair a direction and a ruling as regards this bill. I have gone through the bill, and I am of the opinion that there are sections proposed to be introduced in the amendments that are unconstitutional. I therefore seek a ruling regarding those sections. Allow me kindly to point out the sections which I seek to impugn in the bill. These are clauses in the bill which seek to amend certain sections. The bill we are discussing and the bill that we seek to have some sections impugned are the Proceeds of Crime and Anti-Money Laundering Amendment Bill, National Assembly Bill number 39 of this year. And the provisions, the clauses that have unconstitutional provisions are sections 2 and sections 9 of the bill. Section 2 proposes to amend Section 2 of the Principal Act, while Section 9 proposes to amend Section 48 of the Principal Act. The purpose of the amendment is to introduce advocates, notaries, and other independent legal professionals who are sole practitioners, partners, or employees within professional firms to become designated non-financial businesses or professions that are obligated to report money laundering and related activities, including what will be termed as proceeds of crime instance. By dint of these two provisions, therefore, advocates join accountants only, because under those two sections, the advocates are coming after accountants to be reporting persons relating to crimes under the Principal Act. In my own estimation, there is unconstitutionality in these particular provisions. Number one, the proposed amendments have not borne into mind the fact that advocates and their practice are regulated by the Advocates Act. And what is being proposed here may not be in consonance with what is provided in the Advocates Act. Be that as it may, and relating to the two factors that are most important in legal practice, may I go to what is unconstitutional. And I refer to Chapter 4 of the Constitution, which is on the Bill of Rights. Article 27 protects advocates and accountants from discrimination. So, when we have advocates being introduced here as professions that must report this particular instance, it does appear that we are leaving out the other professions, or the other professions that are regulated by statute. By so doing, we are actually lowering the standing of the advocates. A tidier way of doing this should have been to introduce all professions that are regulated by statute, so that they also become reporting persons. Number two, the only one that is there is accountants, if you've read the bill. Accountants only. Number two, to single out advocates and accountants, the status of this is reduced when viewed against the other professions. Number two, by singling out these two professions, the state is actually discriminating directly against them on the basis of their profession solely, contrary to Article 27(4) of the Constitution. Mr. Speaker, sir, I know the Speaker of this House is a guru in constitutional matters. He is actually backed by a panel, the Speaker's panel, which is composed of lawyers who are also of the highest standing. Therefore, allow me to invite you, the Speaker, and the substantive Speaker, to also consider the following. What is the effect of the proposed amendments to the cardinal legal principle of advocate-client confidentiality vis-a-vis what we are proposing? Number two, what is the effect of the fiduciary relationship between an advocate and a client as the foundation and pillar of the legal profession practice worldwide, and Kenya in particular? The reason I say so is this. Mr. Speaker, sir, this bill is being introduced by the Finance Committee. But the Justice and Legal Affairs Committee was actually invited to Mombasa, where the Treasury made some representations on this bill. And when we pointed out the unconstitutionality of this bill, the answer we got from Treasury was that there was pressure from certain quarters that we must pass this bill by a given period of time. And the question we ask is this: which pressure is that, and who is exacting it, on what basis, and most importantly, to an independent country? Because previously, we have made fundamental mistakes in our laws by listening to people who are putting pressure on us. Such people are now telling us to pass a law that is unconstitutional. And to that, I urge this House to reject absolutely, so that we now get a ruling that we are seeking a ruling from the Speaker, which in particular tells us whether this bill is within the Constitution or out of the Constitution. Because it is fundamental that before we proceed, we are accordingly guided. Thank you, Mr. Speaker.
The Honorable Murugara has raised very fundamental matters, but I'll allow a few others to weigh in. And I will definitely start with the Honorable Otiende Amolo, followed by...
Thank you, Mr. Speaker. Mr. Speaker, I see Honorable Kaluma eyeing me badly, but I will have him know that my right to raise a point of order was actually reserved by the Speaker on 29th of September when this matter first came for the first reading. And I did indicate to the substantive Speaker that I had certain constitutional concerns, and the Speaker directed that before commencement at the second reading, then we would raise them. And therefore, I joined the Honorable Murugara in raising constitutional issues. I will not repeat the parts that Honorable Murugara has covered. And Honorable Murugara has covered clause 9B and clause 2B. And he has cited the issue of discrimination and the legal principle of advocate-client confidentiality. Mr. Speaker, I will only point out further clauses that also fall within that category. But to cap clause 2B, this bill, amendment bill, proposes to include advocates as reporting agents. And the first question to be asked is, why only advocates in addition to accountants? There are many professions that receive money, and there are many professions that deal with money. If it was a question of dealing with professions, then it would have been dealt with
the way already now the Act deals with it. If you look at the Act, the Substantive Act, Section 2G, it allows the minister discretion to add such other business or professions in which there's a risk of money laundering, in which a risk of money laundering exists, as the minister may, on the advice of the center, declare. It is broader, and it invites the possibility that there must be a demonstration. But if then you want to focus on advocates, then you must demonstrate. Why is only advocates being included? That is discrimination. Mr. Speaker, it is not only discriminative of advocates. Even when it comes to its own definition, it has further discrimination within advocates in two ways. One, it only talks of advocates, notaries, and what it calls independent legal practitioners. It introduces a term not known to our law. That term is not in the Advocates Act, is not in the Law Society of Kenya Act. Whatever it is, we don't know what it is, and it is not defined in the amendment. Independent legal practitioners, we don't know who they are. But also, in its conclusions, in definition section 2, it talks of advocates, notaries, and other independent legal practitioners within professional firms. So again, it only restricts the advocates who are within professional firms. So it's discriminatory of advocates generally, and then even within that category, it only refers to those within professional firms. Mr. Speaker, it is interesting to note that in the definition of the reporting agents, the advocates are now supposed to join others like operators of casinos, estate agents, dealers in precious stones, and such other businesses which ordinarily do not come with grace.
The Honorable Otiende, which clause are you referring to? Can you read it, all of it?
I am reading the definition in clause 2B in conjunction with Schedule 1 of the Substantive Act. If you read Schedule 1 of the Substantive Act, it already enumerates the reporting agents. Those reporting agents, you will see, Mr. Speaker, include operators of casinos. It includes, dealers in precious stones, estate agents, and such other professions. Now, the advocates are now supposed to join that hallowed list. And it is quite telling, Mr. Speaker, for a profession that is usually described as noble to be put in that category. Mr. Speaker, the fundamental point is, other than being unconstitutional, is it necessary? If the intention is to give an authority to include any other profession, once it can be demonstrated and justified, then it already exists in the Substantive Act, in Section 2, as I referred to, G, which gives the minister on the advice of the center. But in including the lawyers, then now it does not depend on advice. It does not depend on anything. They are just included. Mr. Speaker, Section 9B is a section the Honorable Murugara did not mention, and I want it included in that consideration. The issues are as similar as the issues in Section 2. Then clause 10, C, 3A. Again, when it comes to qualifications for appointment, that is also to be considered. But of greater concern is clause 130A. That is the limitation clause. That is the clause that now limits the right to privacy in Article 31, and I'll come back to that. But as clause 130A talks of the limitation, clause 131 and 2 then gives that limitation and gives a discretion to be searched, for seizure of property, to reveal financial information of family, not even of the advocate, of family. And it also allows interference with communication without due process. There is nothing in this amendment that talks of any due process. And so you now want to subject advocates to the possibility of seizure, search, disclosure of financial information of family, and even communication without due process. That is unconstitutional, Mr. Speaker. Mr. Speaker, clause 16.1 then brings in the Law Society of Kenya as one of the other bodies, what is called supervisory bodies, without examining the capacity of the Law Society of Kenya to be a supervisory body in financial transactions. The Law Society so far regulates who can practice law, not how. Who can practice law, not how. And in doing so, it then now requires the Law Society to do two further things. One, under Section 44 of the Act as it is now, then it places an obligation to start monitoring lawyers in terms of how they do their work. And in terms of Section 45 of the existing Act, it then places an obligation on the individual advocates to verify customer information. And such customer information is indicated as identity, including birth certificate, including driver's license. Those are the kind of things that now this proposal wants advocates to do. Mr. Speaker, it is not only discriminatory, it is burdensome, and it infringes on the age-old custom of client-advocate confidentiality. Turning to Article 31, Mr. Speaker. Article 31 of the Constitution is very specific, and it protects privacy. Under Article 131C, information on private affairs. Under D, privacy of communication. In this bill, the bill specifically seeks to bring information on family under Clause 130, communications under Clause 132. And Mr. Speaker, it is to be noted that Article 24, Subarticle 5, tellingly allows limitation of the right to privacy for members serving in the KDF and the National Police Service. Why does the Article 24.5, take the trouble to say that for the right to privacy, for those in the armed forces and the disciplined forces, it can be limited? It is because the right to privacy is fundamental. It may not be non-derogable as those in Article 25, but it is fundamental. You cannot just derogate it. Mr. Speaker, if you look carefully, and I now come to Article 24, if you want to limit the right to privacy under Article 24, you must do at least three things. First, you must limit it by law, as they are seeking to do. Secondly, that limitation has to be reasonable. And it has to be reasonable in a democratic, it must be reasonable and justifiable in an open and democratic society. I have read the entire bill, the purposes, the report. It does not seek to demonstrate the justification in an open and democratic society. Mr. Speaker, it might look easy, and one might say it concerns lawyers. Let it be remembered that the confidentiality of the client-advocate confidentiality is not for the benefit of the advocate. It is for the benefit of the client. So when you look into it, it is not the lawyers it's affecting, it is everyone else. Might it be remembered, Mr. Speaker, that as we seek to curtail and diminish the standing of the legal profession in this country, we are members of the East African community and members of COMESA. The constitutive instruments allow cross-border practice. We are coming to a situation where we are diminishing client confidence in advocates in this country, with the result that they will just use other practitioners in other sister countries. Mr. Speaker, I want to suggest that even as we lose on this issue, it should be remembered that already we have very stringent regulations, both under this act and other acts, where any professional, not just advocates, who deal with any bank are required to disclose information when you receive money, when you send money, and that is sufficient. There can be no justification for now isolating and bringing the lawyers to this. Mr. Speaker, I want to submit that this proposal, however well-intentioned they are ill-advised, They are ill-conceived. The text is such that it cannot pass constitutional muster. Indeed, Mr. Speaker, rather than have long debates on this matter, Mr. Speaker, I urge you and the substantive Speaker to find that these proposals are completely unconstitutional and to be dropped at this stage. Thank you, Mr. Speaker.
The Honorable Dr. Otiende, then you are saying that in whose hands are we safe? The Honorable Duale.
Honorable Speaker, I raise under Standing Order 83 to join my colleagues to raise a point of order on a very fundamental constitutional question touching on the Proceeds of Crime and Money Laundering, Anti-Money Laundering Amendment Bill, National Assembly Bill number 39 of 2021. Honorable Speaker, as you are aware, and my colleagues have said, I won't repeat, this bill seeks to, among other things, number one, expand the definition of reporting institutions, and it says this will include advocates, notaries, and other independent legal professionals, and their employees as persons of interest, to report and cooperate with investigative and enforcement agencies where transactions they are handling are suspected to be related to proceeds of crime and money laundering. Number two, Mr. Speaker, this bill seeks to, among other things, applies the provisions of the Act to advocates, notaries, and other independent legal professions and their employees when preparing or carrying out transactions for their clients, including securities, management of banks, savings, security accounts, organization of contribution for the creation or operation or management of companies, and creation and operation and management of buying and selling of business entities or legal arrangements. And number three, this bill seeks to include the Law Society of Kenya and the SACCO Societies Regulatory Authority in the first schedule to the Act as a supervisory bodies responsible for advocates and SACCO Societies Act for the purpose of the application and enforcement of the Act. And Chair, you need to protect me from the Leader of Majority. I have been with him since the 10th Parliament. When I'm on my feet, you wait for your time. We've invested, you know, you are trying to talk to me. And please, not when you are sitting here. So please, what you do, wait for your time. He was just talking to me when he was leaving.
The Honorable Dwale, it is true. I heard him murmur something. But,
yeah, he's murmuring.
But just concentrate on what you are saying. I think it's very important.
You know, we have spent time and energy to rise on a point of order. Yes. So you wait for your time, use your time efficiently, leave us. And we have got the freedom of speech and thought as a member of Parliament for Garissa. An Honorable Speaker, I participated with Honorable Millie Odhiambo and Honorable Leader of Majority in the 10th Parliament in the formulation of the Terrorism Act, Anti-Terrorism Act, in the formulation of the Money Laundering and Proceeds of Crime Act, in the establishment of the Financial Reporting Center. And all these pieces of legislation were geared to deal with the money laundering, proceeds of crime, and anti-terrorism financing. Honorable Speaker, allow me first to observe that this is not the first time, and I want to go on record, that the amendments to the Proceedings of Crime and Anti-Money Laundering Act contained in this bill find their way here. In 2019, Mr. Speaker, and in the Finance Bill of 2019, these amendments were withdrawn and expunged from the bill for serious constitutional issues. Fast forward, in 2020, the same amendments, Mr. Speaker, were expunged from the bill. And indeed, Mr. Speaker, indeed, the Honorable Substantive Speaker, and allow me to refresh the minds of my colleagues in this House, that in his communication dated 15th of July 2020, Mr. Speaker, you did communicate that the withdrawal of the proposed amendments to the Proceeds of Crime and Anti-Money Laundering Act from the Statute Law Miscellaneous Amendment Bill of 2020. Honorable Speaker, the question I want to ask this evening is what has changed? I am not a constitutional lawyer, but it is obvious to everyone that which fails, or any bill that fails the constitutional test, cannot be cured, even if one keep on reintroducing that bill, the same amendments, and sneaking them through various different bills, whether it is the statute law, whether it is the finance bill. And Mr. Speaker, why do I say so? And even before I even say what I want to say, Mr. Speaker, by reintroducing these amendments many times, in my opinion, it's like putting poison in different cups and hoping to tell us it is not poison. Mr. Speaker, why do I say so? And allow me just to follow my colleagues and highlight the following provisions of the Constitution, which, in my opinion, offense or are offended by these amendments. And I'll start with Article 31 of the Constitution, that provides that every person has a right to privacy, which includes the right not to have information relating to their private affairs unnecessarily required or revealed to any person. Mr. Speaker, this bill makes advocates reporting institution means that it obligates every lawyer and every advocate to report any transaction they deem suspicious. And we are not being told what is the definition of the term suspicious when they engage with their clients and the citizens of this country. This clearly, Mr. Speaker, violates Article 31 of the Constitution. I submit. 2, Article 48 of the Constitution provides that the state shall ensure access to justice for all persons. Mr. Speaker, these amendments in the reading of the Constitution clearly violates Article 48 because they are making advocates to report every transactions which they feel deem or they deem suspicious. And one wonders what is the definition of suspicion or suspicious, which can be anything. Many people shall be shy away from dealing with advocates as their communication and transactions shall not be privileged and confidential. And Mr. Speaker, I want this House and my colleagues to listen to me. This matter is not about advocates. This matter is about your own privacy. And the eternal chapter in the Constitution is Chapter 4, the Bill of Rights, that protects the basic fundamental freedoms of the citizens of this country. Mr. Speaker, what are we saying? Next, this House is going to legislate that a medical doctor can violate your privacy and give your medical history to whoever he wants. This is the route we are taking, Mr. Speaker. Third, Mr. Speaker, in the reading of the Constitution, Article 49, Subarticle 1C provides that an arrested person has a right to communicate with an advocate. The obligation on advocates to report transactions they deem suspect also violates the right of arrested persons to freely communicate with advocates. Advocates will no longer communicate with their clients. Even those who commit serious crimes like terrorism, even those who commit murder, have under the Constitution, under the Bill of Rights, the right to communicate with the advocates. It's a guarantee. Article 50 of the Constitution, and also Article 50, sub-article 2K. Finally, Mr. Speaker, Article 50, sub-article 4 of the Constitution on the right to fair hearing also provides that evidence obtained in a manner that violates any right or freedom in the Bill of Rights shall be excluded. The obligation to report suspicious transaction by advocates to the extent that it violates Article 31, Article 48, Article 49, and Article 50, the bill also fails in the view of Article 54, as such evidence could not be admissible. Honorable Speaker, the Bill of Rights forms the basic structure of our Constitution. And this House, this evening, Mr. Speaker, should not participate in considering a bill that has the effect of negating in a blatant manner very fundamental human rights protected in the Constitution, Mr. Speaker. World over, Mr. Speaker, it is a commonplace and a general principle that an advocate-client relationship are privileged and any ensuing communication is confidential. Mr. Speaker, to end, Mr. Speaker, I really want to urge this House that today you might think it is the advocates. Tomorrow, Mr. Speaker, and those who are listening to me, one of the basic fundamental principle that those who fought for the 2010 Constitution was because they wanted Kenyans to enjoy their privacy and their freedom, and that is why the Bill of Rights, Chapter 4, is so critical, is so fundamental. It is the pillar that holds our Constitution. It is an eternal chapter. Mr. Speaker, this matter came, this is the third time. We are being told it's being pushed. Mr. Speaker, I read through. It doesn't happen, what we are doing this afternoon, or we are planning to do, it doesn't happen in democracies similar to ours. In the US, in Canada, the Supreme Courts of very many countries annulled these provisions. Mr. Speaker, nobody, and I want to say it, no country, however powerful it is, whether it is the US or UK or even the IMF, call them, they cannot dictate to us everything we do in this country must be within our own Constitution. We cannot do it outside. And Mr. Speaker, the fundamental question I want to ask is, as the former leader of majority, this matter was brought up in the Finance Bill of 2019. It was brought up last year in the Statute Mysterious Amendment Bill. The Speaker of the House made communications. Mr. Speaker, I don't know why this poison is not leaving the corridor of Parliament. Who is interested in that? Mr. Speaker, today, the Central Bank of Kenya, the Financial Reporting Center, the Asset Recovery, and all the private financial institutions can, in a minute, at the touch of a button, whether it is a lawyer's client's account, they can detect, they can monitor, they can flag any proceeds of crime, whether it is from narcotics, whether it is from terrorism financing, whether it is money laundering, whether it is stealing. I mean, the other day I saw a young lady who ran to Germany, who her account was hit with 120 million plus. You know, it is very easy. That's why even you can't withdraw $1 million, you can't deposit $1 million. Mr. Speaker, this House will be remembered like before. And you, Mr. Speaker, you'll be remembered. We should not allow this House to negate the rights and the freedom that were given to us by many people who sacrificed their life in the attainment of the new Constitution. Honorable Speaker, I seek your guidance on the constitutionality of the Proceeds of Crime and Anti-Money Laundering Bill. And as Speaker, I ask you to rise to the occasion, just like our substantive Speaker, and either say we cannot discuss this bill until you make a proper ruling and communication, or because you are listening to us. I mean, we are not saying the street propaganda. You know, the leader of majority, you cannot rush me. You cannot tell me to wind up. You are talking to the wrong guy, my friend. I can continue talking. The only person who can stop me is the Speaker and that clock. So I am not. In fact, I am not under you. So please, you are the one who said the House will sit until 9. Why are you in a hurry? No, you relax. Relax, my friend. Relax. We represent people. So, Mr. Speaker, I really want you to make a ruling, to make a communication, just like the substantive Speaker, so that those of us who want to write our memos, your ruling will be part of what we are going to say that this House did it. I urge you to rule that this matter and these amendments touch on the Bill of Rights and must be dropped so that the bill can proceed. Thank you, Mr. Speaker. We are friends.
Very serious submissions by the Honorable Duale. The Honorable Kaluma, and as you speak, I would like you to tell me where they teach in law school this subject known as suspicion. Suspicious character, suspicious behavior, as you speak. Proceed, the Honorable Kaluma.
I thank you, Honorable Speaker. Honorable Speaker, a culture is developing in this House which needs to be forestalled. A culture where members, instead of allowing members of Parliament to debate a bill on the merits, flags a thing of unconstitutionality, and then they cannot substantiate it, but instead they end up debating the matter on the merits. I think we must go to developing a tradition where when you say a provision of the bill or a bill is unconstitutional, you can, without groping around, tell us which provision of the Constitution it violates, and you read it and you leave it at that. You cannot second guess by interpretation on constitutionality. It should be something so clear. And Honorable Speaker, this is what is happening here. Honorable Speaker, having said that, let me say that I've read very many constitutional documents across the world. In fact, in my postgraduate studies, I studied public law, the main core of which was comparative constitutional law. Now, Speaker, we are the only country with the whole article of the Constitution talking about values, national values and principles of governance. And well, Speaker, as I go to responding to this issue, let me remind the House of the provisions of Article 10, Sub-Article 2C. It says, the national values and principles of governance.
The Honorable Kaluma.
Yes.
Have you looked at the one for Uganda?
I have not.
Proceed.
I don't need to. We look at those more progressive ones. Honorable Speaker, the Honorable Speaker is very impartial. Honorable Speaker, if you look at Article 10(2)(c), it says the national values and principles of governance include good governance, integrity, transparency, and accountability. National values and principles of governance. Honorable Speaker, what we are dealing with is a law relating to how we deal with proceeds of crimes and money laundering. You are being told, Honorable Speaker, that lawyers are being discriminated against because they are not being enlisted with other professions other than accounts. But Honorable Speaker, look at page 1221 of the bill, which is repeating the section 48 being amended under the clauses they are talking about. You know, accountants are already provided for. Accountants are already provided for. Honorable Speaker, if you look at the current section 48, subsection B, there is a whole array of service providers included there, which is very wide. It's not just lawyers and accountants. Look, A trust or a company service provider not otherwise covered elsewhere in this act, which as a business provides any of the following services to third parties. And you can see all of them. You are being told, accountants, lawyers, remember all these service providers are of necessity professionals. Like we provide legal services. Anybody, so long as you provide these services here, by the way, registering partnership, maybe even a lawyer. Yeah, whatever you call it. So the first point I'm making, Honorable Speaker, is that these presenters before me are misleading the House. There are a whole array of services, which for the sake of time, I will not read, but can be read, and they are all there. And by the way, if you interpret those services, they are very wide and cut. With the matter of fishing, you deal with fishermen and fishmongers and fish eaters like me. If we are dealing with proceeds of crime and how they are handled, you are dealing with money laundering, you will target those provisions and service lines which may interact with such money. Honorable Speaker, I may not declare to you, but in my old life, I was lucky to be a partner of a man called P.L.O. Lumumba, Professor P.L.O. Lumumba. Honorable Speaker, that is the time robbers were being caught around here. There is one evening we were approached by a very senior CID officer to keep for them money in our client's account. We thought it was coming in check, waiting for it in the evening. Honorable Speaker, only for money to come in a canter, and we were told it is 3 billion then. 3 billion. And we said, what are you talking about? We told them to, and we made our reportings as necessary about him. I will not talk much. But what I'm saying, Honorable Speaker, is that when people have proceeds of crime, like you remember police officers who would reach robbery scene, you hear nothing is being recovered. They run with those monies to accountants and lawyers. Honorable Speaker, we may talk about the right to privacy. I told you our Constitution is very rich. And the array of fundamental rights we have are compared to only a few countries in the world. In fact, human rights is a national value and principle of governance at Article 10. But Honorable Speaker, look at what the Constitution also does. Can you look at Article 24 of the Constitution? It provides for limitation of rights and fundamental freedoms. And very stringent conditions are there. I will go into it, Honorable Speaker, but you remember just a short while ago, we dealt with the Narcotic Drugs and Psychotropic Substances Amendment Bill. And we made provisions there allowing interception of communication, which on the face of it would be a violation of the right to privacy. What had we to do? Look at the provisions we put there. We ensured that those limitations to the right of privacy had to be in full accord with the prescriptions under Article 24 of the Constitution. So that I want to request my learned colleagues here. We may be saying lawyers are being attacked. How should you help the House? Look at those provisions bringing lawyers as reporting agents and ensure, because it is a limitation of rights, it accords with the strictures of Article 24. And that is how you do it. And Honorable Speaker, if you look at Article 25, so I'm answering this, then I'll go to the meat of the matter. Article 25. Only 4 sets of rights are incapable of limitation. Only 4 sets of rights. And they say, despite any other provision in this Constitution, the following rights and fundamental freedoms shall not be limited. Only 4. And I can tell you, they do not include privacy or these ones you are talking about. In fact, the privacy, if you look at Article 24, sub-Article 5, privacy is the first one they are telling you will be necessarily limited for police officers, KDF, and others, among others. Now, these rights are freedom from torture and cruel, inhuman, or degrading treatment or punishment. That one is inviolable. You cannot limit it. Freedom from slavery or servitude. You know what amendment it is in the United States, and you know what our ancestors who were taken there went through. Being thrown sometimes in the Atlantic Ocean, having those things in the mouth you cannot eat for eternity. It is your strength, you'll be a slave. We say that cannot be restricted or limited. The right to fair trial. Where is Honorable Duale? The right to fair trial. Incapable of limitation. And he's shouting right to fair trial, but it does not connect it to a single provision of this bill, which is either unconstitutional or cannot be amended to be unconstitutional. The last, Honorable Speaker, is the right to an order of habeas corpus. When you disappear with Miguna, even if you don't like him, Kaluma will go to court and will ask you to produce Miguna's body, whether he's alive or not. And I want to say this as the person who argued the bail application of Miguna before Judge Wakiaga, and I paid the bail money with my own money. My own money. He calls me a juvenile despot, but he has not refunded my money. But that is a right that is inviolable. Honorable Speaker, we have to make choices. I believe we must reach a level as Parliament where a matter can be debated on the merits and a decision made. I'm confirming to you, Honorable Speaker, that instead of addressing us on privacy, discrimination, which do not arise by my explanations, Honorable Speaker, you're now told there is something called advocate-client confidentiality. Under which provision of the Constitution is it provided for? So when you are raising a constitutional issue, tight. And I studied professional ethics and trial advocacy at Kenya School of Law. Honorable Speaker, you talked of suspicion. I want to come to it. This bill does not just say suspicion. This bill obligates the lawyers to report, Honorable Speaker.
The Honorable Kaluma, for just my own education.
Yes.
When you talk about fair trial, which is inviolable.
Yes.
Under Chapter 4.
Yes.
Doesn't the right to an advocate, isn't it integral in a fair trial?
It is there.
It is.
And
it is integral.
Yeah, let me respond
to
you. Let me respond to you, Honorable Speaker. In the provisions for limitation of rights, look at Article 24, sub-Article 3 as the answer there. It says, the state or a person seeking to justify a particular limitation shall demonstrate to the court, to a tribunal, or other authority that the requirements of this article have been complied with. The point I'm making is that if you fear there may be a violation of the right to fair trial, make an amendment to the specific clause, which is not being specifically mentioned here, and we'll delete it at the committee stage. But don't torpedo debate by the people. Honorable Speaker, let me say something. When we had the NYS issues in the country, how many lawyers were mentioned? And how did they avoid the trap? Advocate-client confidentiality. Just recently, Governor Sonko, the title is Teles, I'll give it to him, leaked, those things he's calling Sonko leaks. Go to YouTube, part 5. In a single day, an advocate's account is getting remissions in terms of hundreds of millions. Would that raise suspicion? Should that advocate, just in keeping with an open society, tell us this is the source of the money and this is what it is to be used for? What is the problem with that? Honorable Speaker, we can count and count and count. The fact of the matter is that the advocate confidentiality we are talking about in the olden days is not the circumstance under which we are operating today. And it is a big issue. Honorable Speaker, you intercepted with the clarification question when I was going to the first question you raised with me. That provision, Honorable Speaker, does not say on suspicion. There is a word there before it called reasonable, on reasonable suspicion. And Honorable Speaker, you had the benefit of studying in better schools than me. You studied in the school of our second president, Kabarak High. I was in some village somewhere struggling. Tell these people, being senior to me, that there is a way in law we define reasonable. Reasonable. And it is something Honorable Duale cannot understand. So before you say reasonable, and you remember in first year we would study it for a whole semester. What is a reasonable man's test? The man on the Clamfer bus, the man on a matatu going somewhere. Those tests have to be met. But remember also, Honorable Speaker, that has to be read together with the provisions of Article 47 on the right to fair administrative action. Go and look at the ideals there also. So that whether it is a court, whether it is a parliament as we are sitting now, we are waiting for Honorable Kimunya to persuade us whether the limitation of the right to privacy is something that complies with Article 24. We don't need to intercept them. This confidentiality thing was a rule in England. And I can tell you, I will be speaking later on this matter on the merits. Even in the United Kingdom, they have done this thing, subject to compliances with their constitutional regime, which is unwritten. And we'll tell you how many states, even in Africa, are here. Honorable Speaker, as I end, let us make a choice as a House. I want to beg we make a choice as a House. We are either joining Kenyans in fighting corruption, or we want to be people to sustain avenues for purveying it. It is as simple as that. So the line, Honorable Speaker, is drawn on this bill. You are either a money launderer or an advocate keeping those money, or you are a Kenyan well-meaning, knowing the place of money laundering, and you are making provisions to improve this bill to ensure those things you call confidentiality can be allowed to some extent, while we also require lawyers to make disclosures where necessary. And I can confirm, Honorable Speaker, I'll be supporting this bill, but with amendments I'll speak to. Let us not kill the bill unless you are on the other side. We are losing so much money to corruption, and our business environment is no longer competitive. If you compare to the losses in business we are having to Rwanda, to Uganda, to even small countries, because our environment allows money laundering, these small things. I beg you, Honorable Speaker. And Honorable Speaker, you were with me when piracy started in Somalia across here. These marionettes in South B were 3-4 million in 2000, 2004, 2005. When piracy started, people would come, and while you are still negotiating, they are offering 18 million. They went to 30 million. They are working towards 60 million. Those money, piracy money from Somalia, did not just come and land here. They came through advocates' accounts, Honorable Speaker, and you know those advocates. Let us not pretend. So we may take it for granted, but this money laundering thing is overturning our entire economy and making dirty our business environment. Honorable Speaker, I urge you to rule against this motion. For number one, it is not unconstitutional. Nothing has been clearly demonstrated. For number two, the matters being raised can be dealt with on the merits, and we make amendments if necessary. For number three, that past the second reading, we will have a chance, more so as lawyers, to look at this thing word for word against Article 24 and fine-tune it to ensure that the profession continues as we also comply with other national values. Honorable Speaker, dismiss this objection. I thank you, Honorable Speaker.
The Honorable Kaluma, you must be alive to the two principles of natural justice, which are inviolable. That you will not be adjudged guilty unless you have been heard. And the right to hearing is the greatest. I will allow, this is a constitutional issue. I'm going to allow members to ventilate on this. So don't worry, I am not in a hurry. This is a very fundamental issue. I'll allow members to debate this, but I was just informing, musing with the Honorable Kaluma about the right to hearing, which is the primary fundamental rule, which is unwritten anywhere and which cannot be violated by anyone. But be that as it may, I will now allow the next bite to the Honorable Ishungwa, a member for Kikuyu. He is not here. He is on top here. The next one is the Honorable Muathi, member for Limuru.
Thank you, Honorable Speaker. And Honorable Speaker, from the onset, I want to say I'm not an advocate of the High Court of any other advocate anyway. But I've listened to the arguments from the lawyers, and I have always seen cases which are conducted and argued by advocates, where when one stands, you're almost convinced that they are winning. And when the reply comes, Honorable Speaker, you again agree with that, that reply. I've listened to the other members who have spoken. My very good friend, the Honorable Dr. Otiende Amolo, and he almost convinced me that his route was the way to go. But the provisions which have been quoted by Honorable Kaluma, and obviously extensively so, clause by clause, article by article in the Constitution, begs the question as to why the people who are against the continuation of this bill would not also come with those articles quoted, which I did not get, so that they convince those of us who are not lawyers that we should not debate. But basically, Honorable Speaker, if the key critical rights that have been mentioned have not been violated, if indeed, Honorable Speaker, at the Committee of the Whole House, we can amend any one of those clauses that makes the advocates feel offended. And I'm also, by virtue of my right, I'm also a profession. And I don't mind if it is the advocates and the accountants who feel that they are the only ones who have been looped in. It only means if we really have to save this country from proceeds of crime, money laundering, and such, then all we need to do is simple, Honorable Speaker. We include all professionals if they are not there. And I'm very happy to be included there as an architect and planner. And I will support that amendment. But why do you want to say, just because, and I'm not sure that is the case, it is only a mention of the lawyers and advocates, then it is quite unconstitutional, as if we cannot, at the stage of the Committee of the Whole House, amend the law to make sure that all of us are obligated to report. Honorable Speaker, if we have to save this country, I have listened to arguments out there, how money comes in. I'm even hearing the revelations from Honorable Kaluma, how millions came in trucks and canters, how property, and I mean property for that matter, how property in this country, prices have gone up. And it's a fact. You cannot hide. Yes, those properties where now a member of parliament cannot even afford to buy a house have been pushed or propped up by money which has found itself in an ethical way in our economy. Honorable Speaker, we just have to save ourselves. Honorable Speaker, we have to save this nation. We have to create it and make it for our future generation. And for us to do that, we must pass laws that will bite both ways. If it is going to bite a lawyer, let it bite an architect like myself. If it's going to bite an accountant, let it bite any other advocate or any other profession. But we cannot say, because we have two professions which are only mentioned, then we are going to throw the baby with the bathwater. We just have to fight corruption in the best way possible. We have to fight money laundering, Honorable Speaker. And to that extent, Honorable Speaker, I want to persuade all of us that let us, and I persuade you, Honorable Speaker, even as you make the determination, that you please allow us to debate this, and that if there is any amendment at the stage of the Committee of the Whole House, persuaded by the argument of one Honorable Kaluma, then we can incorporate everybody. But let us not remove everybody from reporting obligations just because we think two groups have been put there. So, Honorable Speaker, if you have been ever persuaded by an advocate let me persuade you as an architect that I want to be included in the reporting groups, and that everybody else in this country should. And then, therefore, persuade you to rule that we should continue with debate of the bill as it is, with amendments to follow. I thank you, Honorable Speaker.
The Honorable Mwathi, the real issue was, Honorable members, as you continue to speak to this, the issue that was raised by the Honorable Murugara and the Honorable Dr. Otiende in their constitutional argument was the advocate-client relationship, the confidentiality of the advocate. It is not the advocate per se, but the client, the confidentiality of the client's information in possession of the advocate. That is the crux of the matter, isn't it? The Honorable Wanga.
Thank you, Honorable Speaker. Honorable Speaker, I have had a chance to listen to very senior counsels here, and I also had a chance yesterday as chair of the Finance Committee to listen to very many stakeholders who appeared before the committee to bring their views with regards to this bill. Honorable Speaker, we listened to the Governor of the Central Bank, the National Treasury, the Director of Public Prosecution, the ARA, the DPP, the ESCC, Law Society of Kenya, ISPAC, and several others, Honorable Speaker. Honorable Speaker, we also had the privilege of having a very senior counsel from this very house, who was my father's lawyer, the Honorable Olaga Loch, also coming into the committee, and made very strong arguments in support of these amendments. But Honorable Speaker, I just want to make 2 points. Honorable Speaker, what exactly are lawyers supposed to report on under these amendments? Because it is made to look like lawyers are supposed to report on every litigation commission they have with their clients. But Honorable Speaker, this is not the case. Lawyers under this amendment are expected to report on transactional activities that are specified, which are not at the core of litigation. Buying and selling of real estate, managing of client money, securities, and other assets, management of bank savings or securities accounts, organization of contributions for the creation, operation, or management of companies, creation, operation, or management of legal persons, arrangements, and buying and selling of business entities. Honorable Speaker, as a lawyer yourself, litigation is not specified as an activity that you're supposed to report on as a lawyer. So this should not be taken as an amendment that's bringing each and every activity that a lawyer practices into the ambit of reporting. Secondly, Honorable Speaker, Article 2(6) of the Constitution requires that our international obligations or ratification or treaties that we ratify internationally become part of our domestic obligations. And Honorable Speaker, Kenya is a founder member of the Eastern and Southern Africa Anti-Money Laundering Group. And we are guided by the Financial Action Task Force recommendations, which were brought forward by the UN Security Council. And right now, Kenya has a seat in the Security Council, a privileged position. Now, it is this Financial Action Task Force regulations that requires the amendments that are being made at this point in time. Are we going to throw away our constitutional obligations? And by the way, Honorable Speaker, we are 18 members of the Eastern and Southern African Anti-Money Laundering Group. All countries except Kenya have passed this law. All countries in the EAC, all countries in COMESA. Why are we different, Honorable Speaker? Why are we different, Honorable Speaker? We are not different, Honorable Speaker. And therefore, it has also been raised on the floor of this House that this bill has been withdrawn several times. And Honorable Duale went to the extent of saying that this bill is being sneaked into the House. This bill is properly before the House. Honorable Speaker, there is no sneaking that is happening. In any case, Honorable Speaker, the amendments that have been withdrawn in the past was the amendment in the finance bill and the amendment in the statute law. In fact, it is this time that this bill is properly before the House as an amendment to POCAMLA. And therefore, Honorable Speaker, we should debate this bill. And there are several issues that were raised, Honorable Speaker, including this issue on advocate-client confidentiality. And there were proposals that were made to the committee, which the committee was favorably considering, including the one to include a threshold, a high threshold, for purposes of this reporting by advocates. I think that is the direction to go. Let us make amendments where we deem necessary. But Honorable Speaker, as has been said, we have these international obligations. If by January 1st, and this is not being imposed by anybody, let it be clear, it is ourselves who are in this treaty, in this agreement. We are not being told by anybody. So it should not be said that somebody is imposing this on us. This is an obligation in which we entered with our eyes wide open, and we must therefore fulfill. Honorable Speaker, if by January we remain the only country, the island, that hasn't passed this law,
The Honorable Wanga, I would like you to speak to the constitutional.
Honorable Speaker, this is what I am speaking to.
Yes, and as you speak about
I am
the treaty,
speaking to section 2.6.
Just listen, just listen.
2.5 and 2.6.
Just listen, the Honorable Wanga. As you speak to that, the treaty that you are speaking to, you should inform the Speaker whether that treaty is superior to our Constitution.
Thank you, Honorable Speaker. Let me read that section of the Constitution. The general rules of international, this is 2.5. The general rules of international law shall form part of the law of Kenya. That is 6. That is 5. 6. Any treaty, this is the Constitution that I'm reading. Any treaty or convention ratified by Kenya shall form part of the law of Kenya under this Constitution. This is why I am speaking to those issues, because these are international obligations that Kenya has gotten itself into. By January, if we do not pass this law, we are going to go into the gray list. Once we get into the gray list and progress into the black list, then every Kenyan will be affected. Every Kenyan. Because every financial transaction that you try to make that leaves this country will come under inordinately high scrutiny. So, Honorable Speaker, I know that my brother Musimba has been heckling unusually today because he's a quiet, fairly quiet and fine gentleman, as we know. But today he's a bit, I think he has, anyway.
The Honorable
Let me
Musimba,
not
just hold your horses. I'll allow you the next slot.
Exactly.
So that you contribute.
So thank you, Honorable Speaker, for giving me this opportunity. But finally, let me say this. Is client-advocate privilege or confidentiality protected by the Kenyan law? Honorable Speaker, the answer is yes. POCAMLA, this very law that we are talking about, POCAMLA Section 18.1 expressly protects the client-advocate privilege relationship with regard to communication of privileged information between advocate and client. Let's read that section. It openly protects that. Honorable Speaker, we are dealing with a global issue here. 3, 4, 5 years ago, we had a bombing here. When lives are lost, nobody thinks about the issues we are discussing here today. They say that Parliament should have protected these lives. This is the opportunity that we have to do it today. And, Honorable Speaker, as Honorable Kaluma correctly pointed out, if there's anything within this law that can be amended so that we accommodate the fears that have been raised, let us bring the amendments and we shall support them, as we have discussed off record with many of the advocates in this House. Thank you, Honorable Speaker.
The Honorable Musimba. But as the Honorable Musimba, you contribute. The Honorable Odhiambo, you prepare yourself. And when you will be speaking, I would like you to speak to me on the hierarchy of the laws in this country, from the Constitution to the statute law, to treaties, to rules, and other regulations. Proceed, the Honorable Musimba.
Thank you, Speaker, for this opportunity. Speaker, I have listened quite intently to the arguments which have been put forth. And the fundamental thing in this House is, one, before we even go to second reading, there ought to be a report on this particular bill as we are moving through. The second import, Speaker, I gave them their time. Kindly allow me my time. Allow me my time.
Order members allow the Honorable Musimba.
And I was listening very intently to all of you. And the reason why I was listening to the chair also of finance, the Honorable Gladys Wanga, is, number one, the fact that people are ratifying things abroad. For instance, we had the biggest issue in this House, which was about the GLBT movement, you know, and their rights. None other than His Excellency the President said, this is not a priority in this country at the moment. Mr. Speaker, sir, when we are looking at these things about lawyers, it's about transactions. Accountants will report what is ongoing. They act as whistleblowers. But when it comes to lawyers, we are talking about transactions in process. We are a going concern as a nation. And what should concern us is, are we halting transactions for posterity or for continued process? Because lawyers are not a repository of cash. They are only a conveyor, and all cash transactions or otherwise go through banks. These banks are mandated by law to report to the Financial Reporting Center as to any transaction which takes place, which means there's a footprint, you know, as to do every transaction. As such, we have recourse. When you look at the bill and it talks about, you know, being able to, having ability to hold cash for 48 hours and people are in a transactional mode, then it negates stories which are heroic in this country, like the late Noshad Marali and the deals he did with Kensel moving to Airtel. And he was able, in a span of 12 hours, being able to put up a monumental deal together, because it had legal guarantees and the monies were expressed, and these were across borders. If we could say at that point that this is a suspicious transaction that someone has to report, there goes an entrepreneurial opportunity which was for posterity of Kenya. And we can be able to herald the things which have gone on in terms of inclusion and, in fact, financial posterity of this nation because of actions done by Noshad Marali at the time to rescue, otherwise, deal which would have gone away from this country. As such, Mr. Speaker, and this is what I'm imploring to the chair, it does not hurt this House to be able to get a substantial ruling on these issues that have been raised and the ways forward. Because the history, when we head towards the third reading in this House, is that we cannot be able to bring prepositions on the floor of the House that are otherwise deemed to negate the law that is being proposed. Because there are substantial moves we are making to say that we cannot go and include lawyers that it's going to go against you know, the privacy issues. And more importantly, and I listened to my brother, Honorable Kaluma, talk about the, you know, the rights which are immune. And one such right is cruelty. Mr. Speaker, there is no greater cruelty than being able to be excluded from financial transaction. There's absolutely no greater cruelty that you are able to put or subject someone to than to deny them what is otherwise a hard-earned process to make their money. There's absolutely nothing. So we can sit here in comfort and be able to say, oh, we are going to, you just go report suspicion. Suspicion can be even on the basis of in law, we say all contracts are on the basis of utmost good faith. If I'm not showing that utmost good faith, I'll simply say, oh, I think a deal so-and-so is doing does not seem right. At which point that escalation leads to irreparable damage to the parties. And this is what is of concern. Even that definition of what is suspicious, it's suspicious to who? The fact that someone is dealing in a deal which is above a certain threshold doesn't mean suspicion. We have had people, a lady being told, oh, he's getting a gift and is being sent, say, $2 million. $2 million outside of this country is a gift which is just of a necklace of gold. But in Kenya, somebody says, oh, $2 million, 200 million, whoever gets such a gift. So it's a double standard. So I implore, Mr. Speaker, from your chair, please apply your discretion and let's give us time. We still have time to be able to move on and make this discourse. I thank you, Speaker.
The Honorable Odhiambo Akoth, member for Suba.
Thank you, Mr. Speaker, for giving me this opportunity. Mr. Speaker, I want to say as a lawyer, and especially a human rights lawyer, that these are not very easy issues, because it's a question that pits rights against rights. It pits the rights against discrimination, the right to privacy, the right to self-incrimination, against the right to social and economic rights, Mr. Speaker, the right to good governance, Mr. Speaker. And whichever way we look at it, one may have to give way. And the Constitution has a solution of which one gives way. Mr. Speaker, I'd want to say, and that's why I'm actually happy that Honorable Kaluma referred to good governance under Article 10 of the Constitution and accountability. But beyond that, Mr. Speaker, if you are dealing with issues of money laundering, it actually then negates my own right to fair trade practices. I may not be able to access services. I may not be able to access contracts. I may not be able to have a good life. So it affects a whole spectrum of my rights because of a bad practice. But nonetheless, Mr. Speaker, we still have other rights which constitutionally must be protected. And that's why I'm saying it's not an easy issue, but we must deal with it. Mr. Speaker, we must, in the process, also distinguish between what is constitutional and what is undesirable. There may be things which are undesirable, but are not necessarily unconstitutional, and vice versa. And Mr. Speaker, because members have spoken a lot to some of these issues, so I'll just speak one by one. Mr. Speaker, one of the issues that has been spoken to is the issue of discrimination against lawyers or advocates and accountants under 27(4). Mr. Speaker, I would actually call on your office to declare that unconstitutional if not amended to include other professions. And if amended to include other professions, then there is nothing unconstitutional. But if you pinpoint on lawyers or advocates and accountants, then it is unconstitutional. And so, Mr. Speaker, the way to cure that is to give a ruling stating that make amendments and include morticians, include therapists, include bankers, include all those people, so that it is beauticians, so that it's not unconstitutional, because we must safeguard this country. Mr. Speaker, I want to talk to, again, the other issue that has been spoken to, which is the issue of privacy. And Honorable Kaluma has spoken to it, and Mr. Speaker, maybe because I don't have time, I can't look at it, But the Constitution under Article 24 gives the threshold for limitation of privacy. And what it provides is very, very clear, that you will look at the nature of right or fundamental freedom. It will look at the importance and the purpose of limitation, which is protecting lives, the nature and extent of the limitation. So if you are protecting lives, limitation really, there is even no issue up for discussion. The need to ensure that enjoyment of the rights and fundamental freedoms by any individual does not prejudice the rights of others, Mr. Speaker. And so where my right begin, Mr. Speaker, you must also take into account other people's rights. You cannot look at rights with one side. You must balance rights so that everybody's rights are looked into. So, Mr. Speaker, what we should be looking at in terms of privacy is that have we met the threshold of limitation? And if you look at actually the amendments, the way they are provided, then the threshold is met. Mr. Speaker, the other issue that I think for me, the others that Honorable Duale spoke to, I will not speak to them because they don't meet for me the threshold of constitutionality. But he spoke on one thing that I picked up, the issue of self-incrimination under Article 49(1)(d). And Mr. Speaker, one of the things we should look at is, does a lawyer reporting require, does it mean self-incrimination? Mr. Speaker, that is a moot issue. And I think that would be the elephant in the room that I don't want to speak to. Mr. Speaker, I want to talk on the issue of lawyer-client privilege, Mr. Speaker. By practice in the Commonwealth, it is privilege, but it is not constitutional. Perhaps that is something the lawyers missed, and perhaps if you have another BBI, we should provide it constitutionally, but it is not constitutional. The lawyer-client privilege is not constitutional, and therefore it may be undesirable, and so it's an issue for debate, not for declaration of unconstitutionality, and we may defeat it or may, not defeat it, but it is not an issue of unconstitutionality. Mr. Speaker, you have asked me to speak to the issue of supremacy of laws, and Mr. Speaker, I want to say that I am happy to be one of the founding mothers of the Constitution, and I can tell you that, Mr. Speaker, I am one of the people who actually brought Article 2.5 and Article 2.6 of the Constitution, because specifically of my interest in the Convention on the Elimination of All Forms of Discrimination Against Women, Convention on the Rights of the Child, and other conventions. I was not thinking of these ones, Mr. Speaker. And I wanted to protect the rights that Kenya has protected for women and children internationally. And Mr. Speaker, if you read what Honorable Gladys read, it is clear. It says, the general rules of international law shall form part of the law of Kenya. And that is 5. And 6, any treaty or convention ratified by Kenya form part of the law of Kenya under the Constitution. Mr. Speaker, what that therefore means, as soon as a treaty is ratified by Kenya, it becomes the law of Kenya. And Mr. Speaker, this issue became a very thorny issue for the church. And they actually wanted the Constitution to be defeated because of 2.5 and 6. And I made a promise to the church that I will bring a law to ensure that Parliament is involved in the process of treaty making, so that you cannot say that these treaties are made without our input. Mr. Speaker, if there's one single law that comes to this Parliament so many times, it's the Treaty Making and Ratification Act that was passed in 2012. So Parliament is involved. Unfortunately for us, the East and Southern Africa Anti-Money Laundering Group was formed in 1999 and is not subject to the Treaty Making and Ratification Act. Hence, in all the decisions and the recommendations that were made thereto, and the UN Security Council Resolution 2462 that actually buttresses these 40 recommendations that actually calls on us to do this, is law by Kenya by virtue of 2.5 and 2.6 of the Constitution of Kenya. And Mr. Speaker, if we want to undo that, it means we have to undo our ratification of this. And we must also look at 2.5.
The Honorable Millie, the question really was
Yes.
not whether the treaties form part of the law.
Yes.
The hierarchy, whether if there is a stipulation in the Constitution that is expressed, and there is a stipulation in a treaty that is contrary to what is stipulated in the Constitution, which one is superior to the other one?
Mr. Speaker, that is a very interesting question. An interesting question. Mr. Speaker, by virtue and by dint of 2.5 and 2.6, the moment we ratify a treaty, it automatically becomes law. The Constitution gives it that clothing. And that is why under the Treaty Making and Ratification Act, Parliament must be involved. Before, it was solely the role of the executive. And we were saying there was always a clash because the executive would not look into what our Constitution provides. But because it now comes to Parliament, then it means Parliament must look at the issue of constitutionality before we go out there. So, Mr. Speaker, in terms of ranking, any treaty that is ratified by Kenya takes on a constitutional standard immediately, by dint of 2.5 and 2.6 of the Constitution. Mr. Speaker, I see my time is up. I said these are not very easy issues, but I would suggest that I have indicated that some without amendment are clearly unconstitutional, and you can make a ruling that they can be passed with amendments, but there are some which are undesirable, but not necessarily unconstitutional. So it would require each of us to be convincing each other. Thank you, Mr. Speaker.
Very well spoken. The Honorable Makali.
Yeah, thank you, Mr. Speaker. You know, Mr. Speaker, I've been listening to the lawyers make their presentation and their arguments. And Mr. Speaker, I think I will not focus on the constitutional issues.
The Honorable Makali, I wanted you to speak. You wanted to speak to the constitutionality, or
No, I just want a general general statements,
No,
and then
I wanted you to speak to the Constitution. I think, honorable members, the Honorable Makali, you'll forgive me because I wanted you to speak to the constitutional issue. But if you are not,
I'm just referring to the bill.
I'll give you a first opportunity when we proceed.
No, it's just one or two things, very brief. I will not even take 2 minutes.
Okay.
Because I'm just reading the bill, Honorable Speaker.
Yeah.
And I'm just looking at only two sentences. It is saying, limiting the rights to privacy as far as prevention, detection, and investigation of money laundering and the financing of terrorism is concerned. To me, I thought this is a very specific issue. And it means those other issues might not matter much, Honorable Speaker. Honorable Speaker, that's why I like what Karuma was saying. I think, you know, I think that's why law is a social science. Because it's like there is no formula. You know, as mathematicians, we just go to the formula and you get the answer. But I like the arguments. But I think, Honorable Speaker, having listened to everybody, the world is now a global village, Honorable Speaker. It's a global village. And we can't live in isolation. It's important that we do how the other people are also, what they are doing. But to me, the issue of terrorism and corruption are critical to this country, Honorable Speaker. And I think it's important that as legislators, we make sure that we protect Kenyans against those two, terrorism and corruption issues. And if we do that, Honorable Speaker, we'll be helping this country. So even as you make your ruling on this matter, which is constitutional, let's also not forget that Kenyans out there would also want to benefit from some of the decisions we make. I submit, Honorable Speaker.
Honorable members, I think we have had quite a bit on this. And this is really a preliminary issue. We have not done anything to the business as was set out in the order paper. Honorable members, the Honorable Murugara rose in his place and raised a constitutional tangent to the business that is coming, that is to be considered here. as business number 17. And for the last 2 hours, really, almost 2 hours, we have been canvassing that matter that he raised. And it is a weighty matter, it is fundamental. There have been so many takes on it. The Honorable Kaluma, the Honorable Dr. Tiende, I appreciate his contribution. The Honorable Odhiambo, the chair, has contributed. Honorable members, I think this is a matter that will require considered, a considered ruling that will be delivered on the issue of constitutionality, or whether this proposed legislation meets the constitutional threshold or it does not. And at any point before the matter is concluded, definitely if it is found that it does not meet the threshold, then the matter will be stopped right there. But as of the moment, I think the fair thing to do as we prepare that ruling, which will be delivered, it will be fair to allow the mover to move it, then the ruling will come, and it will deal with all the issues that have been raised by the various members, of the honorable members of this honorable house. So my direction is that we allow the mover to move. The ruling will be considered and delivered, and at that point, we will determine whichever way this particular business will fall. So the honorable chair of committee, you may now proceed to move. Just hold on, just hold on. Just hold on. Oh, yes. Before you move, Chair, yes. Yes, I will have the leader of majority to lay papers on. Yes.
Honorable Speaker, I beg to lay the following additional papers on the table of the House today, Thursday, December the 2nd, 2021, afternoon sitting. Number one, legal notice number 236 of 2021 on the section of properties regulations 2021 and the explanatory memorandum. Number two, legal notice number 238 of 2021 on fiscal and land use planning, institutions regulations 2021 and the explanatory memorandum. Number three, legal notice number 239 of 2021 on fiscal and land use planning, building regulations 2021 and the explanatory memorandum. Number four, legal notice number 240 of 2021 on fiscal land use planning, county fiscal and land use development plan, regulations 2021 and the explanatory memorandum. Number five, legal notice number 241 of 2021 on fiscal and land use planning, national fiscal and land use development plan, regulations of 2021 and the explanatory memorandum. Number six, legal notice number 242 of 2021 on fiscal and land use planning, advertisement regulations 2021 and the explanatory memorandum. Number seven, legal notice number 243 of 2021 on fiscal land use planning, planning fees regulations 2021 and the explanatory memorandum. Number eight, legal notice number 244 of 2021 on fiscal land use planning, inter-county fiscal and land use development plan, regulations 2021 and the explanatory memorandum. Number nine, legal notice number 245 of 2021 on fiscal and land use planning, development control for inter-county projects, regulations 2021 and the explanatory memorandum. Number 10, legal notice number 246 of 2021 on fiscal and land use planning, development control for strategic national projects, regulations 2021 and the explanatory memorandum. Number 11, the legal notice number 247 to 2021 on fiscal and land use planning, development control around strategic installations, regulations 2021 and explanatory memorandum. Legal notice number 248 of 2021 on fiscal land use planning, local and fiscal development plan, regulations 2021 and explanatory memorandum. And lastly, legal notice number 249 of 2021 on fiscal land use planning, special planning area, Regulations 2021 and the explanatory memorandum. Thank you, Honorable Speaker, and I'm sure the relevant committee will now be able to do justice on this in the course of the break.
Very well. We shall now have the mover for the order number 17. It's the leader of majority still. Proceed, leader of majority.
Honorable Speaker, I beg to move that the Proceeds of Crime and Anti-Money Laundering Amendment Bill, National Assembly Bill number 39 of 2021, be now read a second time. Honorable Speaker, I want to, before I even move, to thank the members who have endured the dilatory motion that was brought before this House for the last 2 hours, and I want to ask them to endure the balance of the time so that we can achieve what we came here to achieve. Because, as you notice, the members who came, taking advantage of standing orders and spending all the time, all of them have since disappeared. Basically, filibustering to ensure that we do not start on this motion. Mr. Speaker, this House is a supreme law-making body. It's recognized in the Constitution. It does not legislate for the rich or for the poor, for the money launderers, or for other people. It legislates for the people of Kenya, for the welfare of society and the just government of the people. And nobody can take away that responsibility from this House. So, we are persuaded in moving this motion by the ordinary pain of the ordinary Kenyans that they have to endure because of the effects of corruption on their lives. Honorable Speaker, I hear issues about limitation of rights, that even medical doctors, there's a doctor-patient relationship, and Dr. Nyikal is an expert in that matter. But if you take your COVID test today and you turn positive, that result is reported to MOH without your concurrence, in the public interest. And these are the things we need to start thinking of. We are not doing this because individuals. It's to protect that Kenyan, that suffering Kenyan, who is suffering because our country has been made a pariah. Surrounded by all these neighbors who passed a law, we are the only ones. Kenya and Somalia being put in the same basket is the worst thing that can happen. And Mr. Speaker, it's something that we need to clean up our image. We are the financial center for this country, for this area, for the region. And I know in the course of all those arguments, the Chair of Finance, and she will reiterate, did mention, if we don't pass this law which we committed ourselves to, we get blacklisted, even the money the lawyers are trying to protect will not be moving. Because the international financial system, we have closed our financial system anyway.
State capture.
So we're basically talking here about some people who are fearing for nothing. Madam Speaker, let me also say, we've had interactions with the various agencies, and some of the people, including the Honorable Muragara, who raised this issue, was with us in Mombasa. And at that point, he actually committed, I will support this bill. When he did the turnaround, I don't know. Honorable Speaker, let me get to the bill. And the principal object of this can be summarized as being the imposition of reporting obligations on expanding the number of people with reporting obligations to now include advocates. And one may ask, why are we talking of advocates? I don't even want to think of the history of this Pokamla We know he came here through 2018, through the wrong route, miscellaneous, it was ruled out. He came back in 2019, again through another route, it was reversed, and members, we were told, bring it as a substantive law, which is what we've done. Now, I don't even want to ask, because we're looking at it, but when the Financial Action Task Force carried out a study to identify the risk groups, the most vulnerable, the legal profession in Kenya was identified as a high-risk profession. And Mr. Speaker, for the record, between the year 2012 to 8th of September 2021, the number of suspicious transactions that were reported on lawyers in this country were 326. The number of suspicious transactions where a lawyer assisted in this country were 579. And this is growing. So we are basically not talking of lawyers being included from the blues. It's because every time a transaction takes place, there's no lawyer who owns a bank. He will take that money and take it to the bank. And the bank will flag that issue to the Financial Reporting Center. And they have their own mechanism of tracing all these issues. And eventually they have traced to most of these lawyers. So it's said, why are we putting our lawyers at risk? Because they are doing it innocently. But in the process, what they don't realize is they are handling proceeds of crime. So it's our duty to protect our legal profession who do things in good faith. For those who do things underhand, they'll probably not even go to the bank anyway. And I think that is where we come in and say, for the good lawyers who are doing things, we must protect them by law. So that when they now discover a client who normally deposits 10 million shillings every month has all of a sudden brought 100 million shillings. And they ask the client, says, no, it's okay. You know, we have a confidential relationship, you don't report. They should be able to flag it to the Financial Reporting Center and say, this client, I've suspicion to believe that the money has changed in pattern. Can you look at it? And that's all they're required to do. It's not them to investigate where the money came from. All they're supposed to is flag. When you put your money in a bank, and you convince the bank this is the proceeds from selling chicken or selling meat or from my petrol station operations, the bank is satisfied. But they now realize, do you actually look like you could be making much money from your kiosk? And we saw during the vetting of policemen, Honorable Speaker, policemen who were caught with money in their M-Pesa, and they are trying to justify through all manner of things that we are doing. And even if you work on a day-to-day basis, their business cannot accumulate the kind of money they are being. But it's only because the vetting brought them out. So what we are trying to do here is, first of all, let everyone have that obligation to society in the greater public interest, that you not be the conveyor belt through which proceeds of crime, like the kind of money that came and killed people in Dusit. The kind of money that was used to finance terrorism in Westgate. The kind of money that was used to bring down the World Trade Center in New York. This is the kind of thing that we are saying we should not allow in our Kenyan banking system. Honorable Speaker, when we look at the neighborhood, our big comparators, they are basically melting in the mouth waiting for Kenya to fail. And I can tell you all headquarters of these big banks will soon be in Rwanda, including KCB, including Equity Bank. Because if you continue in Kenya and you are blacklisted, and you're being removed from the international financial system, where Kenyan banks cannot have corresponding relationships with international banks, it basically means that banks will not trust Kenya, they'll move out. And there will be joblessness here. You members of parliament will not be able to access visas. How are you going to pay for your visas? Exactly. And people asking for you to pay for hotels with a credit card. Who will be guaranteeing that credit card?
Maybe that's what they
You know, these are the kind of things that people who are talking here, yeah, because they have a client or some audience to please, are not looking at the ordinary pain of the ordinary Kenyans that people will be put into because of us being blacklisted. Honorable Speaker, Botswana has done it. Let's put it, all other countries have done it within the Eastern and Southern African anti-laundering group, except Kenya and Somalia. Surely we must rise above Somalia. We must rise above other criminals. We must rise above the wash generation. And we must give Kenya the legit business people and protect the good lawyers. I'm very proud as an accountant that we took the bold step and we said, as accountants, there is no money moving anywhere where an accountant is not involved. And we said we will be part of the reporting. So even as lawyers are fearing, the accountant has already reported the money anyway. Yeah? The bank has reported the money. The estate agent who is being given the money to buy the house has reported. But the innocent lawyer holding that money will soon be deemed to be holding proceeds of crime and anti-money laundering. So, Honorable Speaker, I don't want to talk about client-advocate confidentiality. We know that all these things have been canvassed, and this law is not cast in stone. We are doing second reading. Let people canvass the issues they would want to be considered in the third reading. And then we will be sitting here as a house. Exactly. And we will look at each of those clauses and say, this one we can amend, this one we can live with. And when we then do that, we will collectively as a house pass a law. Not the Committee on Finance, not myself as a mover. It will be an act of parliament enacted by the Parliament of Kenya, collectively with the 349 members of this house. So let people not fear that because they are a minority and they will not be able to carry the day, they want to forestall it, like what some people did, BBI, because 5 million Kenyans passed it, and they realized they could lose in the referendum, they went to court to meet 7 judges. Now, Honorable Speaker, I'm very glad you made that decision to allow this debate, so that this august house that is constitutionally empowered to legislate can make the decision on behalf of the people of Kenya. Honorable Speaker, in terms of the other critical aspects, I mean, the bill is so clear-cut. We have dwelled so much about the lawyers. But the bill also covers giving power to the Asset Recovery Agency so that it can have its own standing. Right now, we have EACC doing the investigation. We have DCI doing investigation. We have the DPP who does the prosecution. We have the courts who will decide whether one is guilty or not. We also have an Asset Recovery Agency which is hanging somewhere under the AG's office. And they are doing a great job in terms of recovering those monies, because crime should not pay. And we have a tendency in this country where people say, I can steal billions because all I'll do is I'll get a fine of 100 million, take part of the billions, pay the 100 million, and go back and enjoy forever. Now, the world has moved. No person should benefit from crime. And it's a fundamental issue in law, that you cannot benefit from your own mischief. But it will be happening in this Kenya. So the Asset Recovery Agency will now have more power to be able to intercept some of these things and hold it until a decision is made. And we also give it now legal teeth, so that now working together, you have the investigators, you have the prosecutors, you have the adjudicators in terms of the judge. When you're guilty, you're given to the Commission of Prisons to handle you. And then also your assets are recovered through the Asset Recovery Agency. So that nobody will ever benefit from stealing public property. And I'm surprised that this House, which sought to uphold the Constitution, which includes protection of public property, can have members coming here telling us it's the wrong thing to do. So, Mr. Speaker, let me say that on the one hand, I've said our lawyers are at risk if we don't pass this law. The good lawyers who handle things in good faith. We also said we stand the risk of being blacklisted, and the entire country will be at a loss. And, Mr. Speaker, the future of our children will be in jeopardy, yet we saw to do it ourselves. So, really, I don't want to beat about the point. This matter is so straightforward, and I would urge that we close this matter today. We can put the question another day by the time the decision is made, but at least for the members who have endured being here the whole afternoon, at least let it be that your wait was not in vain. Honorable Speaker, in terms of all these other issues of limitations and all that, a whole series of stakeholders have appeared before the Finance Committee. And they've been slogging over this since December. Since the first meeting we had in Mombasa, lots of consultation, the whole of yesterday, and they even brought a report, which members have read and accepted, including some of those who are raising the issues. So I would like to allow that we get to hear of that as well. And Honorable Speaker, allow me to say that this is Kenya a test. The whole world is watching. Kenya being given the honor of even chairing the United Nations Security Council, and I was there and I saw the president presiding over the UNSC, and the honor the whole world was giving. And immediately after that, we were invited to go and visit Joe Biden in the Oval Office. And I could see the way he was being held and being looked at as the stabilizer for the region. And the same region, which is basically saying, you are talking to Kenya, and these are nations of money launderers who cannot even pass a simple law. Let us not bring ourselves down when we're being lifted in terms of the global honor that's being given to this country. He enumerated here during the State of the Nation address in terms of the investors who are lining up to come to Kenya. How do you get the investor coming in to do the road from Limuru, Rironi to Mau Summit on a PPP to put in so much of their money when he cannot move their money through the international financial system because we are money launderers? We are basically saying we kill all investments. Just because a few people here are not happy with what we are doing. Honorable Speaker, let's look at the bigger picture, where we want to put Kenya, not the half-empty glass that people are looking at what is not there. Let's look at what we can improve to fill our glass. And all those amendments that people want to bring, I'll be happy, as the mover of the bill, plus the chair of the finance, we'll be happy to look at them and bring sure that we bring a law that is good for everyone, not just for a few. Honorable Speaker, with those remarks, I beg to move and ask that the Honorable Kaluma, a seasoned lawyer, and I know he has talked most of the other things, so I would like him just to do a quick, for the record, to second, and then after that, we will obviously get the issues from the chair in terms of public participation. I beg to move.
The Honorable Leader of Majority, you have said you are very happy to be hosted at the White House, and that is why you are moving. Proceed, the Honorable Kaluma.
I thank you, Honorable Speaker. Honorable Speaker, it is very difficult to speak after the majority leader. You know, a short while ago, he got a PhD on matters finance. And so he understands this matter very deeply. Honorable Speaker, most of the matters I wanted to address, we addressed them when the constitutional issues, quote unquote, were raised, so I will not take much time. But Honorable Speaker, allow me to make mention of two so that I allow other members to contribute. Honorable Speaker, when Westgate happened, among the soldiers who were directed to go there was a man from my village, Katuma village in Kanyada, called Jackton Pwode in Arunda. We cried with Honorable Gladys Wanga when we were burying him next to Arunda Primary School. He died there. Honorable Speaker, when our students were being killed at Garissa, the first young man who was shot on the head was so bad we would not even look at him in the grave. Honorable Wangi, you remember we buried also Philip Pwode, next to Marindi. So, Honorable Speaker, when I see a provision saying we want to stop situations where money laundering can be used to prevent and detect terrorism, I feel it very deeply. Honorable Wanga, I didn't tell you when we were burying Philip Pwode, but he's a boy I educated at a school called Ubiero Mixed Primary School. It's painful. And so without saying much, I wanted to request, fellow members, we are not an island as a country. We are not an island. We have international conventions. Let us not exclude ourselves from the global community by seeking cover under some amorphous things like advocate-client confidentiality. Advocate-client confidentiality is a good thing, but it can be limited, and it is not a constitutional issue. The reasons for limitations here are well explained. If there are grounds for improvements, it will be at the committee stage. And so I thank Majority Leader for choosing upon me to second. And without much ado, Honorable Speaker, I accept the honor and I bow to your chair to say I second and request the members to support this. If there are amendments, let us deal with them at the committee. But I'm supporting fully, and I support. I didn't mention, Honorable Speaker, but all these lawyers, and Honorable Speaker, I don't know whether you can see, currently, only 2 lawyers have remained in the House. Honorable Anthony Kiai there, Honorable Japheth Samala, and Honorable Speaker, who is honored to chair. All those lawyers who are telling us privileges, oh, very senior. Oh, Honorable Mill is also there. Now, Honorable Speaker, let me confirm, only lawyers who see the sense in supporting have remained. I don't want to say much. I support Honorable Speaker, and I second. I thank you very much.
Honorable members, allow me to propose the question that the proceeds of crime and anti-money laundering Amendment Bill, National Assembly Bill number 39 of 2021 be now read a second time. The first one will be the Honorable Nyekal.
Thank you, Mr. Speaker. I rise to support this bill. Mr. Speaker, in my simple mind, I've listened to the lawyers go about it on all the issues, the rights, international commitments, and all these. But to me, this is a fight against corruption. And Mr. Speaker, the danger that corruption poses to our society is great. Mr. Speaker, our services cannot run. We cannot run our health services. You saw what happened when we had COVID and the supplies that we needed at KEMSA. That is what we saw. And Mr. Speaker, when we are talking of rights and other people's rights, what about when corruption denies our people from getting health care? Are they not really denying our people the right under Article 43? So it cannot just be one side. If you look at the businesses, people can hardly survive. Businesses cannot be started. Businesses are running to other countries. We have lost businesses. The oil pipeline that was to run from Uganda through Kenya to the coast went through Tanzania. And that is a loss to us merely because of corruption. We cannot have manufacturing sector started quickly so that our children can get employment. Again, that is because of corruption. Our banking system, as we've been told, is actually under threat because of corruption. Mr. Speaker, if you look at politics of governance, even look at our electoral system, as much as we try, people who have money whose sources we do not understand have a big sway in the electoral system. They actually corrupt the decision of the people using money. Mr. Speaker, we cannot really go and support that. The governance itself, the security, Honorable Kaluma has indicated here how gravely our children, how people have died, and that is money that comes to us through corrupt means. But Mr. Speaker, the mainstay of all this damage to our society is the use of the proceeds of corruption. If people could steal money and get stranded with them and not know how to use them, obviously it will not have this impact. So I support this bill because it actually makes provision for people who actually steal money to stop them from enjoying the loot, enjoying the proceeds of the loot. And this, I think, is desirable if we have to deal with corruption. It does look discriminatory because, as the lawyers have put it, why only the lawyers, why only the accountants? But my response to that, Mr. Speaker, if it is necessary, in fact, let us amend it when it comes to the committee of the whole house to involve all professionals that are regulated by law should actually be included. If they come to actually handle money, we are talking here about money. I know about the client-advocate confidentiality, but how do we measure that against public interest? Shall we say, but actually whose confidentiality are we talking about? Is it the confidentiality of the advocate or actually the confidentiality of the thief who is using the law and being now protected by the lawyer? In fact, they're abusing our lawyers. We should actually go around and protect our lawyers so that these thieves, as Honorable Kaluma was saying, if they have a counter of money, they should deal with it. They should not run to our lawyers and say, let's use the confidentiality between you and them to hide this. It is hurting the country. So public interest, in my view, will outweigh even confidentiality. Even in medicine, we know, if there are communicable diseases and the patient has a communicable disease, you are bound to report that. You cannot hide it and say, this is patient-doctor relationship and the disease is going to affect other people. So there are times that these confidentialities have actually to be breached so that we actually protect public interest. Mr. Speaker, if we do not pass this, in my view, I think this House cannot stand up in public and say they are against corruption. I think with that, Mr. Speaker, I support this bill.
The Honorable Gishim, member for Gishugu. It's not in. The Honorable Chair of Finance and Planning.
Thank you, Honorable Speaker. Honorable Speaker, I thank you for your ruling to allow the bill to proceed. And I want to confirm to this House that, Mr. Speaker, you are you're firm, but you're a fair person. So I thank you that you allowed this to proceed. Honorable Speaker, I just want to, because I had spoken to other issues earlier, and for the record, to anticipate any litigation, that the Committee of Finance and National Planning did conduct public participation on this bill. We did meet several stakeholders face-to-face, and we had several memoranda also sent. We met the Institute of Certified Public Accountants, who supported the bill. The Kenya Bankers Association supported the bill. The Insurance Underwriters and Brokers Association supported the bill. We had the Central Bank of Kenya, the Financial Reporting Center, the National Treasury. We had the Law Society of Kenya, who expressed their dissent with the bill, but were perhaps the only stakeholders who actually expressed dissent. We had the Assets and Recovery Agency appearing before us. We had the Office of the Director of Public Prosecution, the DPP himself appearing before us. We had the Ethics and Anti-Corruption Commission appearing before us. So, Honorable Speaker, we held broad-based public participation, and all the input that was given is indicated in our report. Honorable Speaker, there's just one other issue that I'd like to mention that we have not already deliberated, which is on what the bill calls the Assets Recovery Oversight Board. The ARA made submissions to change this from oversight to advisory so that they retain their independent role in assets recovery. There's also a case made that in this board, which included the Director of Public Prosecution, that the DPP be removed because this is investigative rather than prosecution related. So that was also made. We will be debating it further as we move along. The Ethics and Anti-Corruption Commission made a case to be included in this board. Honorable Speaker, the Central Bank of Kenya Governor or ARA asked that Central Bank Governor be included in the board. Again, these are issues that we will look at during the third reading of the bill. So, but I wanted to take note of them during this second reading, just so that the House is notified of that. So, Honorable Speaker, I beg to support.
The Honorable Ole Sankok.
Thank you so much, Honorable Speaker, and I rise to support this bill 100%, Honorable Speaker. Honorable Speaker, I have had some arguments from some lawyers that there is what we call client-lawyer confidentiality, and that there are some rights that they thought that they are infringed. Honorable Speaker, but remember your rights stop where mine begins, Honorable Speaker. Honorable Speaker, this country, in terms of corruption, it have denied our mothers an opportunity for free maternity, Honorable Speaker. Honorable Speaker, because of corruption, it have denied our children proper education, Honorable Speaker. Honorable Speaker, the poor, Honorable Speaker, go hungry, yet there are billions and billions of shillings snatched in banks, Honorable Speaker, by the corrupt, Honorable Speaker. NYS 1, Honorable Speaker. NYS 2, Honorable Speaker. Took a lot of money, Honorable Speaker, and it is because some people don't want to report this proceed of crimes, Honorable Speaker. Honorable Speaker, if we have known that the conduit of proceed of crimes, one of them include lawyers, Honorable Speaker, what is wrong for us to tell them and ask them to report that there is, and flag out that there is proceed of crime passing through there? We are not telling them to investigate. We are telling them just to report, Honorable Speaker. Why are they feeling guilty, Honorable Speaker? And if you can see, the lawyers who are opposed to this one have just all of a sudden disappeared. We have only been left with a few lawyers like Honorable Shamala, Honorable Millie Odhiambo, Honorable Kaluma, who are very sober, Honorable Speaker, and who are lawyers who want to protect this country, Honorable Speaker, from thieves, Honorable Speaker. Honorable Speaker, we must protect this country because thieves in this country are worse than even terrorists, Honorable Speaker. Honorable Speaker, they have stolen from COVID-19. They have been COVID-19 billionaires stealing from the death, Honorable Speaker. Honorable Speaker.
Honorable Sankok,
yes,
you will withdraw that part of your statement that the other members who have opposed or raised issues are not sober.
I do withdraw.
Very well. Proceed.
So, Honorable Speaker, I'm sorry for I've withdrawn, but they should have stayed so that we can see the end of to it and see your ruling, Honorable Speaker. And Honorable Speaker, today, I can assure you, nimekufulia kofia, because the ruling was really timely and it will save this country. The last one, Honorable Speaker, we will be blacklisted. If we are blacklisted, Honorable Speaker, investment will not be in this country. Honorable Speaker, we will be facing problems. So today, this House is divided among those who want to fight corruption and those who want to benefit from corruption. Choose which side you are today in this House. Choose which side of history you want to be, because those who will support this bill will be in the golden pages of Kenyan history books. Those who will oppose will be in the dark pages of Kenyan history books, because corruption is a cancer that is ailing our country. I support, Honorable Speaker.
The Honorable Odhiambo Akoth, member for Suba North.
Thank you, Mr. Speaker. Mr. Speaker, let me rise to support. Mr. Speaker, because I've spoken at length on the issue of constitutionality, I just want to say that, Mr. Speaker, if you are minded in dealing with corruption, in this country we must take very, very difficult choices, even for us as lawyers, because this law affects me. We must balance between rights and doing the right thing, Mr. Speaker. We will not limit our rights to an extent that is not allowed constitutionally, but Mr. Speaker, we will ensure that we deal with the corruption. I only urge the agencies that are designated to deal with corruption and crime to focus on the core issues and not actually politicize fighting corruption. With those few remarks, Mr. Speaker, I support.
The Honorable Muathi Mungai, member for Limuru.
Thank you, Honorable Speaker. And I also want to associate myself with the contributions of the other members without having to repeat. But most importantly, Honorable Speaker, thank you for your ruling. You being an advocate of high standing, that you will allow debate to continue, and at opportune time, you will be able to give us direction on the ruling that was sought regarding the matters that were raised. So we thank you. Secondly, Honorable Speaker, is to say that I want, just like Honorable Sankok has said, and I said before, I want to be part of the people who will be counted, that they stand for this nation. I stand for the future of our children, and that they'll know in the 12th Parliament there were people who cared about their life by making sure we legislate against money laundering, which of course finally ends up creating a lot of corruption and therefore spoiling and messing the entire society. So, Honorable Speaker, without further ado, as we wait for your ruling, I support and wish to also state that since I'm also a professional, and if the lawyers here can listen to me, that if indeed there is that one clause that will speak to only lawyers and accountants being the only ones who are going to be having the obligation to report, then all of us, and I will support that, all of us, let us be looped in, and so that we have obligation to report. I thank you, Honorable Speaker.
The Honorable Shamala.
Thank you, Mr. Speaker, sir. I rise to support, and everything that has been said has already been said. I just want to state I'm very passionate about this matter because I am personally a victim of terrorism. I have an uncle, Mwani, who died in the '98 bomb blast. I have my colleague and my friend, Peter Simani, who died in Westgate. And so it is a matter that is very close to my heart. I feel extreme pain when I think that Kenya and Somalia today are lumped in one basket. We have a funny maritime decision that took place somewhere else, but as Kenyans we have said, not an inch less. Is it deliberate? Because I want to state, and I'll read it out, the definition of what is state capture. It is a system where you use political corruption in which private interests significantly influence a state's decision-making process. And what is happening for those who will oppose a bill like this and oppose treaties that we have signed are actually working to state capture. Is it a coincidence that it is only Somalia and Kenya who are in this situation, and that our country, and as the Speaker has as the Majority Leader has very succinctly stated, we will not be able to do any business past a particular date. As was stated to us in Mombasa, if we do not pass this bill, the blood will be on our hands. The blood of the Kenyans who have died and should any die in future terrorism attacks. With those few remarks, I support.
The Honorable Wangwe.
Thank you, Honorable Speaker. Honorable Speaker, on the onset, I want to support this bill and say in 1998, Honorable Speaker, I happened to be a victim of the bomb blast at a cooperative. Lucky enough, God saved me, and I'm alive. Honorable Speaker, I just want to echo my old folks who say, Vindu vichenjanga. Meaning, Honorable Speaker, things change. And also, Honorable Speaker, I want to go to the Bible and say, the Bible talks about the 40 days. When the 40 days come, it must change, Honorable Speaker. Therefore, I want to suggest, Honorable Speaker, that 40 days have come. Let things change. Let us all agree that we include all the professions, including the advocates, Honorable Speaker, so that we save the country from the acts of terrorism and money laundering. With those very few remarks, Honorable Speaker, I wish to support this amendment.
The Honorable Ngeno, member for Muradikir.
Thank you, Speaker. I wish also to state on the onset that I support the with the reservations. Speaker, I support with the reservations. You know, Speaker, sometimes we do not wish to be coerced into making laws that sometimes will come back to haunt us. So, Speaker, I support the fact that we want to kill and we want to finish the question of money laundering and the question of anti-crime money laundering. Mr. Speaker, it is not for us, even for those who are lawyers, to prevent the country from ascending to good leadership and to also have a situation where we can curb terrorism in our country and proceeds from these crimes, Mr. Speaker. But we must also ensure and be guarded on the way we make these laws so that we do not produce laws that will be like the laws that we did sometimes back in this House, Mr. Speaker, the security laws, which came to haunt many members of this House, Mr. Speaker. So I support but with reservation, Mr. Speaker. Thank you.
The Honorable Ndirangu, you had something to say to this, Waihenya? Proceed.
Thank you, Mr. Speaker. I also wish to join my colleagues in supporting this Pokamla law and indicate, Mr. Speaker, that Kenya is a member of the international community. And there is a narrative that has been pursued here that by passing this law, Kenya is bedding to some international pressure. Mr. Speaker, you know Kenya has made, is a signatory to many international treaties. And I would want to give an example that the other day, the anti-doping agency sanctioned Kenya's athletes from participating in the Olympics and other international athletic and sports. And this House had to be called upon, Mr. Speaker, to adopt the anti-doping law so that our Kenyan athletes could be allowed to go and participate at the world stage. So, Mr. Speaker, we are not an isolated nation, and we don't want to be a pariah in world financial systems. So, Mr. Speaker, I want to thank members of our committee and members of the House who have supported this bill. I beg to support. Thank you, Mr. Speaker.
There being no other member interested to speak in this, I now call upon the mover to reply.
Honorable Speaker, I'll go on recess a very happy person. And I'm sure the members here who endured the whole afternoon, the shenanigans and the rigmarole, will go home feeling their time was not in vain. And the Kenyans out there, those suffering Kenyans, will now feel that there's a 12th parliament that puts their welfare at the forefront and the just government of the people at the forefront. And that Kenya, nobody shall think that Kenya will be home for illicit money. Honorable Speaker, I wish to thank you. You've been really taken quite a testing phase, and you've had to endure all that. And at this point, I really want to say I'm elated, and I want to thank everyone who has been here. And with those few remarks, I beg to reply.
Very well. Honorable members, I want to thank you. And I would just like to say that what has happened in the House today is what should be. That sometimes that we'll have different opinions on different things, but it does not mean that the interest of the country will suffer because we might carry different opinions. And this floor is where those opinions must be expressed. And under my chairmanship, under my speakership, sitting in this seat, every voice will be heard. And it does not mean that those voices that I hear sometimes are very pleasing to me, but it is my duty to listen to them. And they will be heard. Kenyans demand that those voices be heard. But our constitution, our people require that those who remain on the floor and do the business and are in the majority carry the day. And that is the way it is. So well done, members. We have had a fair fight here. Very interesting elucidation on the constitution, stipulations, and the different texts on the issue of the issues that were here before all of us. And I thank members for being brave and being representatives of the people in what they've done. I am glad to have sat through all this, And I am happy that I'm part of this debate. It is correct. So, honorable members, I want to wish you all happy holidays, and I want to wish you a Merry Christmas that is free of all the troubles and shenanigans and these bad illnesses that have come to encompass. I hope you enjoy this period with a little restraint and care for yourself, so that we shall see each other on the 25th of January in the year of our Lord 2022, which is a great and heavy year, as you all know. Thank you, members, for allowing me to be here and to hear all of you. And therefore, honorable members, the time being 8:55 p.m., this House stands adjourned until Tuesday, 25th January 2022 at 2:30 p.m. God bless you all.